ಹಲೋ ಶಿವರಾಮ್. ಹಾ ಬಂದೆ, ಬರ್ತೀನಿ.
Allora metà. Vamos a
So quota number 8 is voice clear, sir? Sir, quota number 8 is voice clear, sir?
Yes, sir. Clear, sir. Clear.
So first, there will be submissions with regard to adjournments through VC. After those submissions through VC, any memos from left to right? After the memos, if any submissions are right from left to right.
to convenience.
The mentionings through video.
My lord, serial number 84, my lord. The concerned counsel is not well, my lord. He has gone to hospital. I am proxying this matter. Therefore, I am seeking 1 week time, my lord.
Request of the learned consequence for the appellant who submits that due to medical reasons, the learned counsel for the appellant is unable to appear today at final opportunity. A week's time as grade is granted.
Yes.
Great, my lord.
Any other submissions through video?
Yes.
Any memos from left side? Memo from the left side? ಸ್ವಲ್ಪ ಗಟ್ಟಿ ಹೇಳಿ. ಹಾ. ರೀಕಾಲಿಂಗು ಅದನ್ನ ಹಾಗೆ ಬರ್ತದೆ, ಮೆಮೊ ಮೂವ್ ಮಾಡೋದು ಬೇಡ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಇಮಿಡಿಯೇಟ್ ಬರುತ್ತೆ. ಎಸ್ ಪ್ಲೀಸ್. ಹ್ಮ್. ಹ್ಮ್.
Last call, the compound wall has fallen onto my property. The tenants are vacating and I'm not able to carry on the paperwork because of the existing status quo. That has to be heard finally.
Which year matter?
But if I'm not able to carry out any repair work,
What is the stage of the matter now?
final year.
final hearing. According to roster, you will come if you want any early hearing, file an application. We will consider it. Yes.
So, the tenants are vacating the lot.
No, we are not rejecting your request. Yes. Ah. When did you file application? 2021 you have filed application. Monday. Yes.
For the respondent, I just we spoke on the question of amount order dated 15/22, last one I to 1.2.
File it in the registry. Yeah. Yes. Usually. Yes. Order ನಲ್ಲಿ ಬರ್ರಿ ಮಧ್ಯದವ್ರು ಇದ್ದಾರೆ ಮಧ್ಯ ಯಾಕೆ ತೋರಿಸ್ತೀರಿ?
And matter for finally in 2017 matter.
Yes, please.
2017, your daughter had filed, unmarried daughter had filed for the partition that has been dismissed now. It has been stayed by this honorable court. The mother is seriously ill.
What is the stage?
Finally.
According to roster, it would come. Yes, please.
The time it was adjourned by 1 week.
Hmm.
Thereafter, it has not come. I start for interim order.
Yes.
Monday or Tuesday.
Yes. Next week. Yes, please. Microphone hatra bani.
Suit for declaration injunction
Hmm.
decreed by the trial court and for the defendants. They have filed a petition not before the revenue authorities seeking for change of Karnataka.
Hmm. Have read for any interim order. Whether all the office objections are complied with. Yeah, list the matter on Tuesday, provided all the office objections complied.
Not an extension of interim order. The interim order expires 17th Monday.
Going to expire.
Yes,
Yes, Monday. Yes. Make use of the microphone, please. Ah, what is the urgency?
Super injection, they are interfering my position.
Have prayed for any interim relief? No, it's not necessary.
Submission, they were going to settle the matter.
Come up with the settlement memo. We will take it on the very same day. Don't worry. Come up with the settlement. If they are settling the matter, come up with the settlement. Move the matter. We will take it on the very next day. On the very next day. No urgency. Yes. Have prayed for any interim order. List on Wednesday, provided interim order is prayed for. And office objections are complied with.
Order of injunction from the trial court. Respondents are trying.
Ah.
Filed it last week, but there is a movement in the.
No. If they are trying to alienate the property, why do you want this matter to be listed immediately?
So we seek to make our case now. We're trying to alienate the property.
Yes.
There's an order of injunction by the trial court. They're trying to alienate the property.
Yes. Here, what do you want to do?
There's an RFA file.
There are.
There is an RFA file. 151.
That is fine. In RFA, what you was sought for? Why? By listing the matter, what you get here?
There's an interim order.
Say that. ಏನ್ ಹೇಳ್ಬೇಕು ಅದನ್ನ ಬಿಟ್ಟು ಉಳಿದಿದ್ದೆಲ್ಲ ಹೇಳ್ತಾ ಹೋದ್ರೆ we can infer, but I don't want to infer unless it comes from your mouth. At least a council should know how to make a submission precisely. Yes, Thursday, next week. Have you filed the memo? Tomorrow. Provided withdrawal memo is filed. No, this memo, what for? Is it for posting the matter? Have you filed any memo for? Yes, the same order. Yes, any mentioning. Serial number? Yes. Last time 10 ತಗೊಂಡಿದ್ರಿ ನಲ್ಲಿ. The counsel from both sides presented the request of the learned counsel for the appellant. That finally 2 weeks time as spread is granted. Yes. 78. Yes.
78.
That is the first matter. We'll see when the matter reaches. Yes.
From the other side, advocate made a proposal also, a proposal of rupees 40,000 as a full and final settlement. Seeks instructions from his party. Please.
Then we will record that when the matter reaches, make the submission and see the file once.
So, no, please, madam. Last occasion he was not present. Only my request.
Adjournment requested. Request for adjournment requested. Matter stands passed over. Yes.
Serial number 4, my lordship.
Yes.
For 1 week time, my lordship. As a office objection.
Serial number
Serial number 4, my lordship.
4. Wait for till the matter reaches. ಅದನ್ನು ಮಧ್ಯಾಹ್ನ 2:30 ಗಂಟೆಗೆ ಕರೀರಿ. Yes. Serial number. Whom you appear for? Whom you appear for? What is the rank of the party to whom you are appearing for? Yes, at the request of the learned counsel for the appellant, a week's time as spread is granted. Yes.
Lordship, serial number 79, counsel for the appellants. Senior SC Giridhar will be unable to appear today, my lords. Personal inconvenience.
We'll see when the matter is reached. Yes, call the case.
On complaint for execution, second time, 71, Vijay Kumar.
The appellant. I will comply with the office objection. Pay for 1 week's time.
You have complied, that to
Okay,
complain.
now,
At the request of the learned counsel for the appellant, both sides present. The request of the learned counsel for the appellant as a final opportunity, a week's time is granted. This matter on 22/6.
Serial number 2, Hallu Shivagi Basuraj.
And submits a needful and registry to verify and proceed further. Yes.
Serial number 3, third time, B. Srinivas.
Permitted body, counsel for the appellant absent to 31/5/2023 following observation. Right of the same, not complied in detail. These objections are simple and trivial in nature. All of the office objections to be complied with are simple and trivial in nature. Party taking few minutes to complete. Yaudun happen. Dismiss. No prosecution, non-complaint.
Serial number 5, Syed Akmal Hassan Rasmi. Serial number 5.
Letter 3. Yes.
Serial number 6, Santosh Gogi.
this commission regarding the school fees. I have paid 17,335 in the trial court, Your Lordship. Same amount has been paid here. Submission slip is at page 50, Your Lordship.
Counsel for the appellant, who was required to comply the office subsection by this time, has not complied with the office subsection. Several sufficient opportunities of not less than 3 times, even as finally, were all given to him. It is now for the first time the learned counsel for the appellant comes up with a submission that he has a submission to be made regarding the sufficiency of the court fee paid before the learned registrar judiciary. Such submission could have been made and ought to have been made by learned counsel for the appellant at the earliest point of time, instead of taking several adjournments for doing it. Such imposing a cost of ₹200 payable by the appellant to the legal services committee of this court, payable within a day from today and filing a complaint memo, etc. 4 days, the time is granted to the appellant to make submission, if any, regarding the requirement of payment of deficit court fee before the learned registrar judiciary. After hearing the submission, the learned registrar judiciary make his submission regarding the sustainability of the office objection with respect to making good the deficit court fee. Please the matter. In the meantime, the appellant to comply the other office objection. If other office objections. Please the matter. On 23-6. Yes. Fourth case, let's start with the first one. 3 cases disposal. This is the last one. Serial 3. Yes.
Number 8. Abhinav Ramana.
Counsel for the appellant press for 3 more days time to comply the office objection regarding the parent of court. As final last opportunity, a week's time is granted to do needful. In case if needful not done, list this matter on 23-6. Yes.
With a Mandagi. With the office objection.
Same other. Complaint.
Yes, Ramurthy.
Appear for the appellant, my lord. In this case, I serial number 1 objection. There was no indication of court fee on counterclaim being filed in the cost column of the decree. Therefore, he has paid the court fee and account valuation slip also has been filed in the court below and he has applied for a copy, my lord. It may require some time. 2 weeks time may kindly be granted. And second objection is concerned, it is a modified objection raised by the office, which requires a modification of the decree because as far as counterclaim is dismissed, that is not found in the decree. So that requires a amendment to the decree, my lord, which has to be applied before the court. And this objection, yesterday I came to know. So I pray for 2 weeks' time, my lord.
These objections were raised a long back, merely because
No,
you
the
came to
second
know
one
about
was
the
raised
objection.
now, my lord. The second one is modified now, my lord. Because earlier it was not possible to make out what exactly that objection was. Earlier objection was impugned orders of OS para number 3 not forthcoming in certified copy of decree copy. That was not possible to comprehend what exactly it means. So that is modified now.
You should have approached the registry and asked them as to what does it mean.
Because there was some confusion, my lord, last time what has happened was this was sought to be dismissed because compromised. So a wrong number had been mentioned. So that was the
Bit of the
problem.
letter counsel for the appellant as a final last opportunity. 2 weeks time is granted to complete all of his objection, failing which the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance of office objection. In case if office objections are not complied in their entirety within 2 weeks from today, registry to reach this matter. On. P7, yes.
Till number 11, MS Nagarajan.
Complied, my lord.
Yes.
Till 12. Shankar Reddy.
First to five,
A connected matter is before division bench is quite challenging common judgment matter. This matter also to be referred to.
First comply the office objections. And then we will see before whom it lies. There is ambiguity as to before whom it lies. Merely because you say it is before division bench, the record speaks otherwise. On cost. The request of the learned counsel for the appellant as a final last opportunity. The week's time is granted to comply office objection, failing which the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance. In case if office objections are not complied within time, issue this matter on 27/6. Yes.
13, Girish P. Paladare.
The counsel for the appellant pays for a week's accommodation. In view of the observation made on 5/6/2023 and considering the fact that the office objection to the majority of the office objection to be complied with were too simple in nature, which hardly requires few minutes to complete. The granting of time would be only on cost. Accordingly, imposing a cost of ₹500 payable by the appellant to the Legal Services Committee of this court within 2 days from today and filing, etc., etc. As an ultimate opportunity, 1 week time as paid is granted in case not complied in total by paying the cost 27/6. Yes.
Till number 14, Harish HB. Both them are compliant.
For a week time to comply also.
Counsel for the appellant who is physically present. Once again, prays for a week's accommodation to complete office subsection. The perusal of the order sheet, more particularly the observation made on 2/6/2022, would go to show that after exhausting several opportunities, once again, as a final last opportunity, a week's time as grade was granted to the appellant. However, by imposing a cost of ₹500, it appears that till date, the appellant has not paid the cost. On the other hand, is paying for some more time to comply with. A perusal of the order sheet would also go to show that the office objection to be complied with, which were raised at the first instance, are only two office objections, which is showing the ranking of the executant of Wakalat, requirement of mentioning the actual days of delay in IA 3/23. The same would take hardly few minutes to complete, for which the appellant has taken not less than 4 years. The subsequent verification has also led to some more office objections, which also the appellant has not complied with. As such, though there is no ground for granting any further adjournment, however, in the best interest of justice, imposing an additional cost of ₹2,000 payable by the appellant to the Legal Services Committee of this court within 3 days from today, and filing a complaints memo along with etc. etc. And also subject to paying the cost of ₹500 imposed on 2/6/2023 during the course of the day, and filing complaints memo of the receipt in the registry to that effect. As an ultimate opportunity, 1 week time as paid is granted. In case if office subsections are not complied after paying the cost within the said time, registry to list this matter on 27/6, on which day the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance of office subsection and suitable order regarding the recovery of the cost, provided if the cost is also not paid. Yes.
Number 15, Mohammed Asiruddin.
Being for the appellant, Your Honor, this objection has been complied with, but with regard to the DCF, Your Honor, it will be made good during the course of the day, Your Honor.
Office objections are complied with, however, the DCF is not made good.
Rest of the office objection has
No,
been
that is the only office objection that was due.
Your Honor, will be complied with during the course of the day, Your Honor. We have to pay the deficit for.
ಹೇಳುವುದರಲ್ಲಿ ಅಷ್ಟು ಬುದ್ಧಿವಂತಿಕೆ ತೋರಿಸಬಾರದು. ನಮ್ಮ ರೆಕಾರ್ಡ್ ಇರ್ತದೆ ನೋಡಿ. Counsel for the appellant present. Delayed payment of cost is accepted. He submits that DCF would be made good during the course of the day. As an ultimate opportunity, 2 days accommodation is granted to comply the office objection in total. In case if office objection not complied in their entirety within the said time, registry to list this matter on 21. Yes.
16, Marlin.
Memo. You have filed a complaints memo. Yes. Have you filed the complaints memo regarding payment of the cost? When you have filed? Yeah. ನೋಡ್ರಿ ಇದೆಯಾ ಅಂತ. ಕಾಂಪ್ಲೆನ್ಸ್ ಮೆಮೊ ಹಾಕಿಲ್ಲ ಅಂತ ರಿಜಿಸ್ಟ್ರಿ ಹೇಳಿದೆ, ಇಲ್ಲಿಯೂ ಇಲ್ಲ, ಮೆಮೊ ಇಲ್ಲ, ಬರೀ ಒಂದು ರಿಸಿಟ್ ಹಾಕಿದ್ದೀರಿ. ಕಾಪಿ ತೋರಿಸಿದ್ದಾರಲ್ರಿ ಹಾಕಿದ್ದೇನೆ ಅಂತ, ಇಸ್ಕೊಳ್ಳಿ. No, there are few more office objections to comply, right? Huh. Stating that she has filed complaints memo also. However, the registry has not put up the same, the Learned Council produces a produces a office copy of the said complaints memo for the perusal and return. The office objection in that regard about non-filing of complaints memo stands to overrule. To comply the remaining office objection as paid for by Learned Council for the appellant as an ultimate opportunity, 4 days time is granted. In case if office objections are not complied within the said time, registry to list this matter on 22/6, on which day the court may proceed to pass appropriate order, including dismissal of appeal for non-compliance of office objection. Yes.
Number 70, Nur Mohammed.
In this case, not paid the deposit as I applied the office objections.
Paid.
Yes, my lord.
Learned Council for the appellant submits that he has completed the office objection by paying the deposit court fee. Registry to verify and proceed. If not complied, list this matter on 22/6.
Much,
80,
much obliged.
Victor Manoharan.
Office objections are there, my lord. Today I have filed it in the registry, my lord. Application will be filed, I have filed. Today I have.
Counsel for the appellant submits that he would comply the remaining office objection during the course of the day. He is granted 3 days time to comply as final ultimate opportunity to comply. Compliance is not done in this matter on 21/6.
Number 19, Sriram Timappa Nayak.
Time to be granted. Compliance is not done.
Counsel for the appellant will physically present place for once again place for each time of the office objection. Several and sufficient opportunities of not less than 4 times, including as the last opportunity, have already been granted to the appellant. Perusal of the office objection to comply with also would go to show that several of them are too simple and trivial in nature, like properly stitching the IAs, mentioning the full cost title in the IAs, stating the number of days of delay, correctly stating the prayer in IA 4/2020. Attending these office objection hardly would take few minutes. However, since 2021, the appellant has not complied office objection. In the light of the above, imposing a cost of rupees 800 payable by the appellant to the Legal Services Committee of this court within 4 days from today and filing complaints memo, etc., etc. As an ultimate opportunity, a week's time as paid is granted. In case if cost is not paid and office objections are not complied in total within the said time, the registry to list this matter on 26/6. On which day the court Proceed to pass order so and so. Yes.
20, Sukanya HT.
Yes.
Number 21, Satish SP.
Just name that it happened. The objections are there. That is the. Here was not. That's.
Counsel for the appellant prays for 2 days time to complete office objection. Ultimate opportunity, the time as prayed is granted. In case office objection not complied with, registry to list the matter. Keeper.
22, Tom Naidu.
Lots of weeks time may be granted.
Counsel for the appellant prays for weeks time to comply. Considering the observation made on 2/6/2023 and number of adjournments granted to comply of these objections. Time as paid is granted, however, imposing a cost of ₹600 payable by the appellant to the legal services committee of this court within 2 days from today and filing, etc., etc. Not complied in total. In the time of the format had to list this matter on 27/6. Yes, 1 week with cost.
23, Subhash Chandra Bose.
So I'll pay the DCF payment. Remaining all the office subsections are complied.
Counsel for the appellant submits that complaints of the office objection. It would be done during the course of the day. In case if office objection not complied during the course of the day, registry to list this matter on 19. Yes.
Number 24, Prasanna Kumar.
Now, therefore, the appellant, my lords, I seek a week's time to remove the remaining office objections, my lords.
As requested by Learned Counsel for the appellant as an ultimate opportunity, a week's time is granted to comply with subsection. Failing which the court may proceed to pass on. So if not complied within time, is the matter on. Yes.
Dev Sitappa.
Now complied the office objections. Office objections is regarding the valuation of this properties. Appellant valued this, appeal for rupees 11,50,000. Valuation slip also produced. Not in this case, only part of the decree is challenged. I can over 10 lakh. It's claiming that the use of the self-active properties of the appellant. I have valued it for 11,50,000. Asking for proof of valuation. I have paid the court valuation.
A cost of rupees 200 to LSC during the course of the day. Make this submission before the registrar within 3 days from today.
Bill number 26, R. P. Sadashivappa.
Valuation of this. What is second? The value is more than 40 lakhs. For completion, but yet regarding the one valuation para, the value is more than 40 lakhs and I have filed the second set also. Hence I complained officer.
Office objection is that plaintiff's share value to be stated correctly in valuation para.
I'll do the needful during the course of the day.
200 rupees.
Please.
Yes. The counsel for the appellant is permitted to comply office objection during the course of the day. However, after paying a cost of rupees 200 to the legal services committee of this court. Before complying office objection today and filing a complaint receipt in the registry to that effect. In case if cost not paid and office objection not complied with, list this matter on. Yes.
Bill number 27, Kashina Cherry.
In spite of granting all opportunities of not less than 4 times, the appellant is once again praying for 4 days accommodation. The office objection required to be due for complaints. Inter alia includes very simple and trivial office objection, which requires hardly few minutes to complete. As such, the time as paid is granted. However, imposing a cost of rupees 500 payable by the appellant to the legal services committee of this court in 2 days from today and filing a complaints memo, which are on the registry. In case if cost not paid and office objection not complied within total, list this matter on. 6, yes.
Bill number 28, Ganapati Subrata.
ಕಾಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ವಿ. ಅದೇನಾಗಿದೆ ಅಂದ್ರೆ ಈ ಹೈಯರ್ಗಳಲ್ಲಿ ಮತ್ತೆ 3 ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿದ್ವಿ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಎಸ್ಟರ್ಡೇ ನಾನು ಎಲ್ಲ ರೆಡಿ ಮಾಡ್ಕೊಂಡು ತಗೊಂಡೋಗಿದ್ದೆ. ಇಲ್ಲ ಬೈಕ್ ಹೋಗ್ಬಿಟ್ಟಿದ್ದೆ ಕೋರ್ಟ್ಗೆ. 1 ಡೇಟ್ ತಗೊಳ್ಳಿ ನೆಕ್ಸ್ಟ್ ಡೇ ಬಂದು ಇದು ಮಾಡಿದ್ದೆ. ಇವನ್ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ರೆಡಿ ಮಾಡಿ. ಯಾವುದು ಇಲ್ಲೇ ಒಂದು 5 to 11 days ಇತ್ತು. ನಾವು ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಆಗ್ತಿತ್ತು. ಹೊಸದಾಗಿ ಹೈಯರ್ ಮೇಲೆ ರೈಸ್ ಮಾಡಿ ಲಾಸ್ಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಯಾವ ನಾಳೆ ಫೈಲ್ ಮಾಡಿ ರೆಡಿ ಇದೆ.
The request of the 11th counsel for the appellant as an ultimate opportunity. 4 days time as paid is granted. In case if office objection not complied within time, list this matter on. Yes, sir.
Bill 29, Pradeep Asokar.
4 days, no, 1 week. 1 week.
Only one office objection is remaining, that is filing of certified valuation. We have applied for it, 2 days time, even. And cost has been paid, memo has been filed in that respect in the registry yesterday, 13/6/2000.
Old office objections are still being complied.
Because old office objections have been complied with respect to changing of address and first. But the valuation, certified copy of the valuation slip as well as the valuation memo to be filed.
That office objection was there previously. Also.
Previously, it was there.
They have not complied.
Yes, 2 days ago time.
Also for the following. For 2 days accommodation to come. An ultimate opportunity. 5 days time is granted to complete, failing which the court may proceed to pass. And in the law, if not complete. Start 26/6.
Fifth non-compliance, seal number 30, Harish Pandari T.
What happened?
Whether the prayer made by you in the prayer column of the appeal mentions that you have restricted the prayer only for a sum of rupees 5,63,493.
Sir. Last line, Your Worship.
Yes, please.
This one depends on the work done by him as on 2014, amount in 5,63,493.
No, read it. So and so quote in so far as it relates to. Read the paragraph, please. Prayer.
Wherefore it is prayed this honor court will be issued to settle the judgment and decree dated 31/1/2019 made in OS number 606 of 2017 by the court of the additional civil jurisdictions CCL 63 Bangalore City insofar as it relates to rejection of claim made by the appellant 24 payment of dues from the respondent defendant in respect of the work done by him as on 3/3/2014 amounting 5,60,493.
Exactly. 5,63,493 was the cost of the work done. You have prayed that with respect to defendant in respect of the work done by him as on so and so date amounting to rupees 5,63,493. In plaint also we have mentioned so. The cost of the work done is 5,63,493. However, you have added the interest thereupon.
Interest and tool and other materials which you have placed there, that in total what you have claimed your loss, it is.
Therefore, even in the trial court also, the cost of work done was only rupees 5,63,000 only.
Yes.
However, the addition claiming of the interest thereupon has enhanced the claim amount to 11,65,517. Therefore, in this prayer, you should have very clear and decree the suit for rupees 5,63,947. Otherwise, today we accept your court fee. Tomorrow somebody would be there here, and you say, kindly decree my suit. My claim is so much. Yes, decree. Bandari avare. ಜಡ್ಜ್ಗಳು ಓದ್ತೇವೆ ಸ್ವಲ್ಪ.
ಅಲ್ಲ ಇವನ್ ಇದರಲ್ಲಿ ಇವರು ಲಾಸ್ ಇತ್ತು. ನಾನು ಬಿ ಅದರಲ್ಲೂ ಹೇಳಿದ್ರೆ ಅದೇ ಹೇಳಿದ್ದೆ ನಾನು ವ್ಯಾಲ್ಯೂಷನ್ ಅಲ್ಲಿ 563 ಹೇಳಿದ್ದೆ ನಾನು.
ನಿಮ್ಮ ಪ್ರೇಯರ್ ತಾನೇ ನಾವು ನೋಡೋದು.
One word I need to add your lordship as far as your lordship, sir.
ವ್ಯಾಲ್ಯೂಯೇಷನ್ ನಲ್ಲಿಯೂ ಕೂಡ ನೀವು ದಿ ಅಪೀಲ್ ಈಸ್ ಫೈಲ್ಡ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಿ ವರ್ಕ್ ಡನ್ ಆಸ್ ಆನ್ ಸೋ ಅಂಡ್ ಸೋ ಅಮೌಂಟಿಂಗ್ ಟು rupees so and so ಅಂದಿದ್ದೀರಿ. ದಿ ಅಪೀಲ್ ಈಸ್ ವ್ಯಾಲ್ಯೂಡ್ ಫಾರ್ ಎ ಟೋಟಲ್ ಸಮ್ ಆಫ್ rupees so and so ವಿಚ್ ಈಸ್ ದಿ ಕ್ಲೈಮ್ ಅಂತನೂ ಹೇಳಲಿಲ್ಲ. ಸರಳವಾಗಿ ಸುಂದರವಾಗಿ ಸ್ಪಷ್ಟವಾಗಿ ಹೇಳಿಬಿಟ್ರೆ ಯಾವ್ದು ಅಂಬಿಗ್ಯೂಟಿ ಇರಲ್ಲ. ಒಂದ್ ರೀತಿ ಹೇಳಿ ನಾಳೆ ಅದನ್ನ ಹೇಗ್ ಬೇಕಾದ್ರೂ ಓದ್ಬಹುದು ಅಂತ ಮಾಡ್ಕೊಂಡ್ರೆ ಎಲ್ಲದೂ ಆಗ್ತದೆ. ನಿಮ್ಮ ದುರದೃಷ್ಟ ನನ್ನ ಕೋರ್ಟಲ್ಲಿ ಬಂತು. Heard the submission of learned counsel for the appellant. And there is the report submitted by the learned registrar judicial. Learned counsel for the appellant submits that he has restricted the suit claim only to rupees 5,63,493. Accordingly, the learned registrar judicial has opined that the court fee paid is sufficient on the said claim. Next line, a reading of the valuation and the prayer made in this appeal nowhere mentions that the appellant has restricted this claim to a sum of rupees 5,63,493. Since the learned counsel has made a submission both before the learned registrar judicial and before the court today that the appellant is restricting the claim amount only to a sum of rupees 5,63,493, he is required to carry out the said amendment in the valuation and prayer paragraph of the memorandum of appeal. As such, as submitted by him, he is permitted to carry out the amendment within 2 days from today. Registry to list the matter on 27/6. 2 days or within 4 days. Carry out ಮಾಡಿ ಬನ್ನಿ, ಆಮೇಲೆ ಕೋರ್ಟ್ ಫೀಸ್ ಬಗ್ಗೆ ಹೇಳುವ.
Number 31 ಸದಾಶಿವಯ್ಯ.
4 ದಿನ ಕೊಟ್ಟಿದ್ದೇನೆ. ಅದಕ್ಕೆ 4 ದಿನ ಕೊಟ್ಟಿದ್ದೇನೆ ಮಾಡಿ.
Number 31 ಸದಾಶಿವಯ್ಯ.
Yes.
For a password in this matter, my lord, we will be basing the guidance value of the property and the third method.
Request of the learned counsel for appellant matter is possible.
Number
Counter
32
officer.
yes.
Valuation of claim share was for partition
is more than 15 lakhs, it comes to 7 lakhs, 17 lakhs.
Have you filed the acknowledgement for having paid the cost? When you have filed it? Learned counsel for the appellant submits that she has filed acknowledgement for having paid the cost with complaints memo in the registry. On linear date happy registry to verify, put up the matter. On Hatombutuar. Yes. Bunny no me.
Cell number 33, Purushottam KN.
Deal. DB 36 after obtaining. Honorable Chief Justice.
30.
Seeking Hakadal award. Not DB 36. Yes. 37.
Cell number 34, Girish Pardare.
Pay for appellate member. Well, page number 9 and 10 only. Detailed valuations did not.
Counsel for the appellant submits that subsequent to the order dated 2/6/2023, the appellant had filed detailed valuation in the registry and has stitched it with the main appeal, giving the page number, appropriate page numbers. However, the registry has not considered the same. So, in the memorandum of appeal, valuation Tiara is no clear. However, since the appellant has filed a separate valuation slip, the registry to consider the same and make its submission regarding the sustainability of its objection. Is the matter. Seven six. Yes.
Cell number 35, Prakash GR.
Here are 3 items.
36, MR Vijay Kumar. Fixed non-compliance. 36. Vijay Kumar.
Also for the current which represent physically not being vacant. No reasons are forthcoming either for its non-appearance or for non-compliance of officers. On 29/5/2023, this court had made the following observation. In spite of the above, the appellant has not reported the payment of the cost. On 29/5/2023, nor even complied with the officer. Several the perusal of the office objection go to show that several of them are simple office objection could have been complied with without taking much pain. Simple office objection, including mentioning the correct provision of law in IA 1/19, filing the typed copy of the valuation slip, correctly stating the prayer in appeal and IA 1/19, correctly stating the valuation paragraph, numbering the paragraphs correctly, removal of annexures. This would hardly take 2 minutes to complete. To do the same, the appellant has taken more than 4 years, and despite a detailed order passed on 29/5/2023, imposing the cost also, the appellant has failed to comply the office objection, and according to registry, is not even reported the payment of cost. Hence, I do not find any reasons to grant some more. The learned counsel has further remained absent also, without showing any reason for non-compliance and non-payment of cost. Hence, the appeal stands dismissed for non-prosecution and for non-compliance of office objection. Beneficiary copy, recovery decree, land revenue arrears. Format LSC. Yes.
Sayed Kumar.
Delayed payment of cost is accepted. Registry to proceed further.
Number 38, 8 and now complaint Sagar BB.
Aspect of hearing, the objection was with regard to non-production of the valuation statement that was annexed to the claim. But at page number 33, minutes have produced the certified copy of the valuation statement. The objection is that minutes in terms of section 5(1) of the
1 minute. 1 minute. Then file must bear for revaluation. Page number
33.
According to how much is the value of the share of the plaintiff?
2 lakhs, as stated in the valuation statement, it's 2 lakhs.
Is it not? It is 2 lakhs rupees and above each.
But before the trial court, it is not valued beyond 2 lakhs. The court, for the purpose of payment of court fees before the trial court, the claim of the plaintiff was valued at rupees 2 lakhs. Now, the very same valuation statements have
Kindly see your own valuation slip, sir.
the appeal.
Valuation slip ಕೈಲಿ ಇಟ್ಕೊಂಡು ಅದನ್ನೇ ನೀವು ಸರಿ ಓದದೆ ನಿಮ್ಮ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಕೊಡ್ತಾ ಇದ್ದೀರಿ.
Pursuant in partition and separate possession, the value of the share of the plaintiff rupees 2 lakhs. And
ಒಂದು ವರ್ಡ್ ಯಾಕೆ ನೀವು ಜಂಪ್ ಮಾಡ್ತೀರಿ? ಓದಿ, ಆ ಬಿಟ್ಟಿರೋ ವರ್ಡ್ ಅನ್ನು ಓದಿ. The value of the share of plaintiff.
Value of the share of plaintiff. Next word is rupees 2 lakhs and above.
ನೀವೇ ಹಾಕಿರೋ ಡಾಕ್ಯುಮೆಂಟ್.
Yes, ma'am.
ಸೊ ಎಷ್ಟಾಗ್ತದೆ?
4 plaintiffs are there. 4 plaintiffs are there. Now, the total value was calculated at rupees 2 lakhs and above. Now, for the purpose of
ಆಗ್ರಿ ಟೋಟಲ್ ವ್ಯಾಲ್ಯೂ ಮಾಡಿದ್ದೀರಿ ವಕೀಲ್ರೆ. ನಿಮ್ ಕೈ ಕೊಟ್ರು ನೀವು ಅದನ್ನ ಸರಿ ಓದ್ಲಿಕ್ಕೆ ಬರಲ್ವಲ್ರಿ? ಓದ್ತೇನೆ ಕೇಳಿ, ಇದನ್ನ ಗಟ್ಟಿ ಓದಿಸಬಾರ್ದು, ಓದ್ತೇನೆ. Suit in partition and separate possession, the value of the share of plaintiff approximately rupees 2 lakh and above each. ಅಂದ್ರೆ not less than 2 lakhs, 2 lakhs and above each. ಎಷ್ಟು ಜನ ಇದ್ದೀರಿ plaintiff? 4 ಜನ ಇದ್ದೀರಿ. And above 4 ಜನರಿಗೆ ಎಷ್ಟಾಯ್ತು ಅಲ್ಲಿಗೆ?
8 lakhs.
8 ಲಕ್ಷ ಆಯ್ತು. ಅಲ್ಲಿ ಟೋಟಲ್ ವ್ಯಾಲ್ಯೂ 2 lakh ಅಲ್ಲ, ಮಿನಿಮಮ್ 8 lakh.
Yes, ma'am.
ಅಂಡ್ ಅಬೌವ್ ಅಂದ್ರೆ ಅದು ಎಷ್ಟಾದ್ರೂ ಆಗ್ಬಹುದಲ್ವೇ?
Yes, ma'am.
ಅಂಡ್ ಅಬೌವ್ ಅಂದ್ರೆ ಅದು ಎಲ್ಲದೂ ಸೇರಿಸಿ 30 ಲಕ್ಷನೂ ಆಗ್ಬಹುದು, 50 ಲಕ್ಷನೂ ಆಗ್ಬಹುದು.
Yes, yes.
ಮತ್ತೆ ಸಿಂಗಲ್ ಬೆಂಚ್ ಬರ್ತದೋ ಡಿಬಿ ಬರ್ತದೋ ಅಂತ ಅವ್ರು ಹೇಗ್ರಿ ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ?
That is the value. Now that valuation I cannot change. That is the value.
It is only you who can do that because you are the plaintiff.
Now, based upon that valuation, the suit was considered on merits and with regard to court.
ನೋಡಿ ವಕೀಲ್ರೆ, ಕನ್ನಡದಲ್ಲಿ ಒಂದು ಗಾದೆ ಇದೆ, ಅಡಿ ಬಿದ್ರು ಮೂಗು ಮೇಲೆ ಅಂತ. ಆ ಪ್ರಯತ್ನ ಮಾಡ್ತಾ ಬಂದಿದ್ದೀರಿ. ಹೆವಿ ಕಾಸ್ಟ್ ಹಾಕಿದ್ದೇನೆ ಲಾಸ್ಟ್ ಟೈಮ್, ಕಾಸ್ಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ ಮತ್ತು ಅದನ್ನೇ ಮಾಡ್ತಿದ್ದೀರಿ. ಮಾಡ್ಬೇಕಾಗಿರೋದು ಏನ್ ಸಿಂಪಲ್, ವೆರಿ ಸಿಂಪಲ್, ಒಂದು ಸೆಂಟೆನ್ಸ್, ನೀವೇ ಪ್ಲಾಂಟಿಫ್, ನಿಮ್ಮದೇ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್, ಅದನ್ನ ನೀವು 8 ಲಕ್ಷಕ್ಕೆ ಕನ್ಫೈನ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಮುಗಿದೋಯ್ತು ಕತೆ. ನಿಮ್ಮ ಪ್ರಕಾರ ಬರೀ 2 ಲಕ್ಷ, ಆಪರ್ಚುನಿಟಿ ಇರೋದು 8 ಲಕ್ಷ ಮಾಡಿದ್ರೆ ಸಿಂಗಲ್ ಬೆಂಚಿಗೆ ಬರ್ತದೆ. 3 ನಿಮಿಷದೊಳಗೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಆಗುತ್ತೆ. ಹೇಳ್ಕೊಂಡು ಹೋಗ್ತೀರಿ, ವ್ಯರ್ಥ ವಾದ ಮಾಡ್ತೀರಿ. 4 ವರ್ಷ ಅದನ್ನೇ ಮಾಡಿದ್ದೀರಿ. ಸಿಂಪಲ್. ಉಗುರಿನಲ್ಲಿ ಆಗೋದಕ್ಕೆ ಕೊಡ್ಲೇ ಇಲ್ಲ, ನೀವು ಇನ್ನೂ ದೊಡ್ಡದು ತಗೊಳ್ತಾ ಇದ್ದೀರಿ. ಮಾಡಿ, ಅದ್ ಏನ್ ಮಾಡ್ತೀರಿ ಮಾಡಿ, ರಿಜಿಸ್ಟ್ರಿ. Learned counsel for the appellant who is physically present submits that since the valuation slip shows that the value of the share of each of the plaintiff is rupees 2 lakh and above, and the appellant himself being the plaintiff, they would confine the They would limit the valuation at rupees 2 lakh each, in total amounting to rupees 8 lakh as value of the share of the plaintiffs. Council prays for 4 days time to do needful in this matter, including mentioning the same very clearly in the valuation paragraph. The time as prayed is granted to do needful. In case if it is not done, registry to list this matter on 27/6, on which day the court may. Yes.
Number 39, orders matter, Ramaya Gowda, LM.
Copies furnished to you. ಈಗ
ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ. I'll file my objection. I'll file my objection next week.
There are counsel from both
Next
sides.
witness.
There are counsel for the KVH stating that he has received. He has been furnished with the copy of IA 1/2023 just now. Prays for a short accommodation to file his objection. 10 days time is granted to file objection. The matter immediately thereafter.
Number 40, HH 50.
Insufficiency of funds. ಸ್ಟೇಜ್ ಹಾಕಬೇಕು, ಸ್ಟೇಜ್ ಹಾಕಿ ಎಂಟ್ರಿ ಮಾಡಬೇಕು. ಕೋರ್ಟ್ ನೋಟಿಸ್ ಇಂದ ಅಷ್ಟೇ ಹಾಕಿದ್ದಾರೆ ಹೊರತು ಅದರ್ವೈಸ್ ಮ್ಯಾಟರ್ ಯಾವ ಸ್ಟೇಜ್ ಇದೆ. Yes, please. ಮೈಕ್ರೋಫೋನ್ ಇಟ್ಕೊಂಡು ಮಾತಾಡಿ, ಲೈವ್ ನಲ್ಲಿ ಇರೋರು ಸ್ವಲ್ಪ ಕೇಳಿಸ್ಕೊಳ್ಳಿ.
ಕೆಳಗಡೆ ಇದರಲ್ಲಿ
ಕೋರ್ಟ್ ನೋಟಿಸ್ ಹೋಗಿದೆ, ಅದು ಇನ್ಸಫಿಷಿಯಂಟ್ ಅಡ್ರೆಸ್ ಅಂತ ವಾಪಸ್ ಬಂದಿದೆ. ತಾವು ಯಾರಿಗೆ ಅಪಿಯರ್ ಹಾಕಿದ್ದೀರಿ? ಅಪೆಲೆಂಟ್ಗೆ. ಕೋರ್ಟ್ ನೋಟಿಸ್ ಯಾಕೆ ಹೋಯ್ತು ಪಾರ್ಟಿಗೆ? ಅಲ್ವೇ? ಎಷ್ಟು ಅಕೇಶನ್? Thirty-one 8/20, 14/9/20, 39/20, 19/10/20. ಕಂಟಿನ್ಯೂಸ್ ಅಬ್ಸೆಂಟ್. ಹಾಗಿರ್ಬೇಕಾದ್ರೆ ಇವತ್ತು ಬಂದಾಗ ಸ್ವಾಮಿ ನಾನು ಯಾವುದೇ ಕಾರಣ ತೋರಿಸ್ದೆ ಅಷ್ಟು ದಿವಸ ಅಬ್ಸೆಂಟ್ ಆಗಿದ್ದೆ, ಇನ್ ಮುಂದೆ ಹಾಗೆ ಮಾಡಲ್ಲ, ಬರ್ತೇನೆ ಕರೆಕ್ಟ್ ಆಗಿ ಎಲ್ಲಾ ಮುದ್ದತ್ತಿನಲ್ಲಿ ಅಂತ ಹೇಳೋದು ಬಿಟ್ಟು ನೋಟಿಸ್ ಹ್ಯಾಸ್ ಬಿನ್ ರಿಟರ್ನ್ಡ್ ವಿತ್ ಇನ್ಸಫಿಷಿಯಂಟ್ ಅಡ್ರೆಸ್ ಅಂತ ಅಷ್ಟೇ ಹೇಳಿದೀನಿ ಸರಿ. ಏನ್ರಿ ಅಡ್ವೊಕೇಸಿಯಾ? ಈಗ ನೋಡಿ, ನೀವು ಹೇಳಿದ್ರಿಂದ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೂತ್ರೆ ಎಲ್ಲ ವಕೀಲರು ನಿಮ್ಮನ್ನೊಮ್ಮೆ ನೋಡ್ತಾರೆ. ಈಗ ನೀವು ಹೋಗ್ಬೇಕಾದ್ರೆ ಅಲ್ವೇ? Counsel for the appellant, Shri so and so is physically present and submits that due to some personal reasons he could not appear on the previous dates of hearing and that he would henceforth regularly appear in this matter. Next line, registry to list the matter at the appropriate stage. The next page. Bunny, yes, Mundos.
Number 41 HSCT.
Same author. Bunny.
Serial number 42 is Ganesh Roy.
I appear for. I- appear for appellant note. The copy sent by the post has been received by my office. I just checked up my records.
ಅಯ್ಯೇ ಹಾಕಿರೋದು ಯಾರು ಅವರು ಮತ್ತೆ ಅವ್ರು ಕೊಡ್ಬೇಕು ನಿಮಗೆ ಕಾಪಿ. ನೀವ್ಯಾಕೆ ಅವ್ರ ಪಕ್ಕದಲ್ಲಿ ಇದಾರೆ ಅನ್ಕೊಳ್ಳಿ, ಅವ್ರ ಜೊತೆ ದೋಸ್ತಿ ಮಾಡ್ಕೊಂಡು ಅವ್ರು ಕೊಡ್ಬೇಕು ಸ್ವಾಮಿ ಇರ್ತೀರಿ. ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಹಾಕಿದ್ದಾರೆ, ಅಲ್ಲೋ ಮಾಡ್ಬೋದೇ?
ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ.
ಹಾ,
Should kindly see page 14 of the para. Page number 14. Para K, my lord. Read, my lord.
14 ಅಲ್ಲಿ ಯಾವ
Para K, my lord.
ಏ
The tempered scheduled property is the secured asset of State Bank of India. Aforesaid. The said bank, however, sought to take the question of the scheduled premises from the petitioner in excess of its power under surpassing Act 13/1/2016, and entire balance of the loan used to rupees so and so was paid from out of the entire sales in consideration that was deposited with the bank. Shortfall 7,28,700 rupees in addition also the state, and she was put back question scheduled premise on 14/1/2016, which evident also. Only allegation against me, I am secure creditor of the property, my lord. They never sought any relief against the bank.
ಅಪೀಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದೆಯೇನ್ರಿ?
Admit.
ಯಾವತ್ತಾಗಿದೆ?
Here advocate is no more now. Now recently I got contact. On the last time for hearing the discussion about what also.
ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಡೇಟು ಎಂಟ್ರಿ ಮಾಡಿ ಕಾಪಿ.
Present counsel for the appellant acknowledges the receipt of the copy. 1/22 and submits his no objection to allow the said IA. Further submission from both sides on the IA, considering the reasons shown in the IA. And more particularly, the no objection from the appellant also. IA stands allowed and the registry is directed to list this matter for final hearing in the first week of July 2023, provided the matter is otherwise ripened for final hearing.
Yes. Highly okay.
Serial number 43.
Now received. Same.
43 Ganesh.
ಯಾವಾಗ ಹೇಳಿ?
Same.
You are not a necessary party. ಅದನ್ನ ಅವಾಗ ಹೇಳಿ. Yes. Same.
Much.
Serial number 44. It is on the connected matters.
Respondent number 9 is not there. Correct report filed by somebody.
First matter, RFA 763 of 2019.
Respondent number 5 is dead. Apart from that, some more responses are dead.
1 second, 1 second. Okay, 469 ಅಲ್ಲಿ
Minor Yogendra Prasad, number 9 Yogendra Prasad. There will be some mistake in the report.
469 of 2019.
44.3, RFA 416 of 2019, Usmanabad PL.
For appellant. Really, I filed the LR's applications.
1 second. You forward. Because you have moved the matter.
I have.
Yes, first appeal 763. Ah.
There are, I have prepared the application, but I am now told that there are 2 more respondents who are dead. Therefore, I did not file the IA. ಯಾರ್ಯಾರು ಬರ್ತಿದ್ದಾರೆ ಎಲ್ಲ ಒಟ್ಟಿಗೆ ತಂದ್ಬಿಡಿ. Naturally 3 days time and application ರೆಡಿ ಮಾಡಿದ್ದೇನೆ. ಸೈನ್ ಮಾಡುವಾಗ ಹೇಳಿದ್ರು ಇವರು ಸತ್ತವರೆ ಅವರು ಸತ್ತವರೆ. They have not reported that. 7B is dead. So 9 is not dead. Number 9 is alive.
PH moved ಅಂತಿದೆ. ಈಗ 763 ಅಲ್ಲಿ.
And 63 and RFA 469 is a common system. 901 and 902.
There are
But,
11 respondents and several legal representatives in your appeal. Who are all yet to be served and who are all dead now?
According to the report filed by one of my friends,
Ah.
they say that respondent number 5 is dead. That is confirmed. And in the FDP, the LRs of the Indrani are brought on record.
1 second, 1 second.
Number 4, Geeta is dead. Number 5, Indrani is dead.
Geeta did and did it.
Number 4. Our number 9 and incorrectly report.
Number 9.
Number 4 and 5.
Who appears for respondent number 1?
Prakash T. Hepa for Kevata, respondent number 1.
So it is not respondent number 9, but it is respondent number 4.
Now, if my lord were to allow the application companion appeal, my submission is, it may also be permitted to impede them in view of the Supreme Court says that if LRs are brought in one proceeding, they do to benefit all the other. Every bezel of they are.
That you can do yourself, right?
Yes, therefore, I file a necessary memo. Any companion proceedings of the country, where a proceeding is
1 minute. Apart from respondent number 4, Geeta, and respondent number 5, Indrani, are there any other respondents or legal representatives of any other respondents who are yet to be served with the notice?
Yes, 7B dead. LR service agida. 7B is now dead. Is also dead. inclined.
I have filed the LR application. It's appellant number 2. It's our actions. Present appeal allowed.
So far as this 4 and 5 are concerned, everything are LR. Therefore,
ಈಗ R4, R5, 7B ಬಿಟ್ಟು ಉಳಿದವ್ರು ಎಲ್ರಿಗೂ ಸರ್ವ್ ಆಗಿದೆಯಾ? ಸರ್ವ್ ಆಗಿದೆ. RFA 763 of 2019, learned counsel for the appellant. RFA 763 ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಗೆ ಯಾರಿದ್ದೀರಿ?
I am representing 7th.
And learned counsel for respondent number 7A to 7E. Respondent number R4 to 6. Or physically present. R4 to 6 ಯಾರು? 4 to 6 ನೀವು. 4 and 6 ನೀವು. 4 ಆಗ್ಲಿ ರೀ, 4 ಗೆ ನೀವಿದ್ದೀರಿ. 4 ಸತ್ತೋಗಿದ್ದಾರಾ? Learned counsel for R4 submits that respondent number 4, Srimati Geeta, is dead. Learned counsel for the appellant. R4 ಬರ್ತಿದೇನ್ರಿ? ಇದರಲ್ಲಿ ಮೆಮೋದಲ್ಲಿ ಅವ್ರನ್ನ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ ಬೇರೆ ಹಾಕಿದ್ದಾರೆ. ಅದನ್ನು ನಾನು ಕ್ಲಾರಿಫೈ ಮಾಡಬೇಕು. ಈಗ ಸುಮ್ಮನಿರ್ತಾರೆ. ನಾಳೆ ಯಾರೋ ಒಬ್ರು ನಿಮ್ಮಲ್ಲಿ ಯಾರೋ ಒಬ್ರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗಿ ನೋಡಿ ಸ್ವಾಮಿ ನಾವು ಹೇಳಿರೋದು ಬೇರೆ, ಇದ್ ಬೇರೆ, ಜಡ್ಜ್ ಏನೋ ತಿಳ್ಕೊಂಡು ಮಾಡಿದ್ರು ಯಾಕೆ ಅಲ್ವೇ ಅಂತದ್ ಒಂದೊಂದೇ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ವಾಪಸ್ ಬರ್ತದೆ. ನನ್ನ ಎದುರು ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಅನ್ನೋದ್ರ ಮೇಲೆ ನನ್ನ ಆರ್ಡರ್ಗಳು ಹೆಂಗೆ ಅನ್ನೋದು ಹೋಗ್ತದೆ. ಎಷ್ಟು ಶಾರ್ಟ್ ಇರಬೇಕು, ಎಷ್ಟು ಡೀಟೇಲ್ ಇರಬೇಕು ಅಂತ ಅದು ನ್ಯಾಯಾಧೀಶರ ಮನಸ್ಸಿನೊಳಗೆ ಇರ್ತದೆ. ನೀವಿರಿ ಏನ್ ತಗೊಂಡ್ರಿ?
Respondent number 4 submits that respondent number 4, Srimati Geeta, is dead. Learned counsel for the appellant.
Dead on 30/31/2022. Learned counsel for the appellant also submits that respondent number 1 has filed a memo to that effect along with the copy of the death certificate. However, the ranking of the deceased, Srimati Geeta, is shown as respondent number 9, which is required to be read as respondent number 4. Next one. Learned counsel for the appellant submits that since learned counsel for respondent number R7A to E submits that respondent number 7B, Shankarappana.
Shankarappa.
Respondent number 7B, Sri Shankarappa, is also dead. In that, the same has already been brought on record in which appeal?
I filed the application.
Houdri,
In 469, please.
in RFA 469 of 2019. Next time, learned counsel for the appellant prays for a short accommodation to ascertain the details of the legal representatives, if any of the deceased parties, and to bring them on record. Next,
469.
RFA 901 of 2010.
Number submission.
901
and 902. Is the arising judgment in a different group. It is decreed in dismissed in 2010. The suit, the 763 and 469. It is a suit for partition. It is dealing to this case. I request this honorable court. I request.
ಯಾವಾಗ ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ಹೇಗೆ ಲಿಂಕ್ ಆಯ್ತು ಅದಷ್ಟನ್ನು ನೋಡ್ಬೇಕಾಗ್ತದೆ. ಲಿಂಕ್ ಅನ್ಕೊಳ್ಳ ಲಿಂಕ್, ಡಿ ಲಿಂಕ್ ಅನ್ಕೊಳ್ಳ ಡಿ ಲಿಂಕ್ ಅಂತ ಮಾಡ್ಲಿಕ್ಕೆ ಇದು ಇಂಡಿಯನ್ ರೈಲ್ವೇಸ್ ಅಲ್ಲ ಅಲ್ವೇ? ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ಸಮಯ ತಗೊಳ್ತದೆ. ಅದು ಲಿಂಕ್ ಆಗ್ಲಿ ಡಿ ಲಿಂಕ್ ಆಗ್ಲಿ ರಿಪೇರಿ ಮಾಡಿ ಎಲ್ಲರನ್ನು ಒಂದ್ಸರ್ತಿ ಉದ್ದ ಹಳಿ ಮೇಲೆ ನಿಲ್ಸುವ, ಆಮೇಲೆ ಯಾವ ಇಂಜಿನ್ಗೆ ಯಾವ ಬೋಗಿ ಅಟ್ಯಾಚ್ ಮಾಡ್ಬೇಕು ಮಾಡಿ ಅವ್ರವ್ರ ಟ್ರ್ಯಾಕ್ ಅಲ್ಲಿ ಕಳ್ಸಾಡ. ಎಸ್, ಇಲ್ಲಿ ಒಂದ್ಸರ್ತಿ ಡಿ ಲಿಂಕ್ ಆದ್ರೆ ಮತ್ತೆ ಅದರಲ್ಲಿ ಏನೇನ್ ನೀಡ್ಫುಲ್ ಆಗ್ಬೇಕು, ಯಾರನ್ನ ತರಬೇಕು, ಅದು ಸುಲಭದಲ್ಲಿ ಆಗಲ್ಲ. ತಡೀರಿ, ಇನ್ನೂ ಇದೆ ಇದರಲ್ಲಿ 901 of 2010 ನಲ್ಲಿ. What are the office objection you are yet to comply on IAS? ನಿಮಗೆ ಕಾಪಿ ಬಂದಿದೆ ಏನ್ರಿ ಅದ್ರಲ್ಲಿ ಐಎ ಕಾಪಿ ತಮಗೆ ತಾವು ರೆಸ್ಪಾಂಡೆಂಟ್ 1C to F ಇದ್ದೀರಿ. ಕಾಪಿ ಆಫ್ IA 1/17 to 3/17 ತಮಗೆ ಬಂದಿದ್ಯಾ? ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್ ಏನ್ರಿ ಇದು?
Served long back, but.
ರಿಸೀವ್ಡ್ ಅಂತ ತಗೊಳ್ಬಹುದೇ? ಸರಿ. ರಘು ಯಾರ್ರಿ? ಬಂದಿದೇನ್ರಿ? ಬಂದಿದೆ. RFA 901 of 2010. The learned counsel from both sides present and the learned counsel. And the opponents in IA 1 of 17 to 3 of 17 submits that they have been furnished with a copy of IAs. The registry to note the same.
Just address to R1, A and B. Leonard Pinde appear ಆಗ್ತಾ ಇದೆ. Appear ಆಗ್ತಾ ಇದೆ.
R1 A and B ಯಾಕೆ ತೋರಿಸ್ರಿ? ಅದು ಕೊಡ್ರಿ. Memo of appeal. RFS 901 of 2010. Last time.
ಶಾರದಾ and ಚಂದ್ರ.
But party ಯಾರು ನೋಡೋಣ. R1 A and B. R1 A and B. ಶಾರದಾ ಚಂದ್ರಕಲಾ. ಅವ್ರ ಮೊದಲನೇ ಅಪೀಲ್ ನಲ್ಲಿ ಇದ್ದಾರ? ಅವ್ರ ಅಪೀಲ್ ನಲ್ಲಿ 763 ಅಲ್ಲಿ ಇದ್ದಾರ ಶಾರದಾ ಚಂದ್ರಕಲಾ? ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ಗಳು ಸರ್. ಡಿಫೆಂಡೆಂಟ್ ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ ನೋಡ್ರಿ. ಎಲ್ಲದು ನಿಮ್ಮ ಕ್ಲರ್ಕ್ಗಳು ಮಾಡುವ ಕೆಲಸಗಳು. ಅದನ್ನ ಇಲ್ಲಿ ಕೋರ್ಟಿನಲ್ಲಿ ನೀವು ಇಗ್ನೋರ್ ಮಾಡಿ ಹೋಗ್ತೀರಿ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬಂದಾಗ ಅದನ್ನೆಲ್ಲ ಮತ್ತೆ ಓಪನ್ ಮಾಡ್ಕೊಂಡು ಕೂರ್ತೀರಿ. ಸ್ವಾಮಿ ಇನ್ನು ನೋಟಿಸ್ ಹೋಗ್ಲಿಲ್ಲ, ಮತ್ತೊಂದು ಮಗದೊಂದು ಅಂತ ಬಹಳ ಬೇಜಾರು ಅನ್ಸುವ ವಿದ್ಯಮಾನಗಳು ಅದು. 10 and 11 ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಿದ್ದಾರೆ ನೋಡ್ತೀನಿ. ಶಶಿಧರ್ ಎಸ್ ಕರ್ಮಾಡಿ. ವಕೀಲರು ಕೂಗಿಸ್ರಿ.
ಶಶಿಧರ್ ಎಸ್ ಕರ್ಮಾಡಿ.
Next line. In view of the fact that learned counsel Sri Shashidhar S. Karmadi is appearing for respondent number 10 and 11 in RFS 763/2019, who are the unserved respondents number R1A and R1B in this RFA 901 of 2010. Learned counsel Sri Shashidhar S. Karmadi is directed to take notice for the respondent number 1A and 1B. The learned counsel for the appellant to furnish the copy of the memo of appeal along with IAS and annexures if any to the said counsel within 3 days from today, and file acknowledgement in the registry to that effect.
R3 date this. R2 and.
ಈಗ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ಗಳೆಲ್ಲ ಇದೆ. ಅದರಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಎಲ್ಲಾರು ಬೇರೆ ಅಪೀಲ್ ನಲ್ಲಿ ಇದ್ದಾರಾ? ಥ್ರೂ ದೇರ್ ಕೌನ್ಸಿಲ್ ಅಪಿಯರ್ ಆಗ್ತಿದ್ದಾರಾ?
ಅದರಲ್ಲಿ ಇಬ್ಬರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ. R2
1, 2, 3 of 13. 1 of 13, 2 of 13, 3 of 13. 9011.
2013, 3/2013, 4/2.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3 ಎಲ್ಲಾರ್ಸ್ ಯಾವ್ದ್ರಲ್ಲಿದ್ದಾರೆ ಈ ಅಪೀಲ್ ಬಿಟ್ರೆ?
69 ಅಲ್ಲಿ ಇದೆ.
469 ಅಲ್ಲಿ ಇದ್ದಾರೆ. 469 ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ತೆಗಿರಿ. ಲಲಿತಾ ಸಂಪತ್ ಕುಮಾರ್
ಲಲಿತಾ
ಕೆವಿ ಲಲಿತಾ ಶ್ರೀ ಸಂಪತ್ ಕುಮಾರ್ ಯಾವ್ದ್ರಲ್ಲಿ ಅದು? 469 ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 and 3 ನಾ? HR Raghu. Yes, in 469 of 2019, you appear for R2 to R8, which includes Srimati KV Lalita and Shri Sampath Kumar as R2 and R3. You accept the notice on IA 1, 2 and 3 of 2013. ನೋಡಿ 10 ವರ್ಷ ನೀವು ಮಾಡದೇ ಇರೋ ಕೆಲಸ 10 ನಿಮಿಷದಲ್ಲಿ ಆಗ್ತಾ ಇದೆ. ಅವರಿಗೆ ಬರೀ ಇಂಟರ್ವ್ಯೂ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು. ನೀವು ಏನಿಲ್ಲ ಕೋರ್ಟ್ ಹೇಳಿದೊರ್ತು ನೀವು ಸುಮ್ಮನೆ ಇರ್ತೀರಿ. ಕೇಸ್ ಉದ್ದಕ್ಕೆ ಹೇಳ್ಕೊಂಡು ಹೋಗ್ತದೆ. 10 ವರ್ಷ, 12 ವರ್ಷ, 20 ವರ್ಷ. ನಿಮ್ಮ ಆಫೀಸಲ್ಲಿ ಫೈಲ್ಗಳು ಇಡ್ಲಿಕ್ಕೆ ಜಾಗ ಇಲ್ಲ ಅಲ್ವೇ? ಅವಾಗ ಅವೆನ್ನೂರು ರೋಡು, ಚಿಕ್ಕಪೇಟೆ, ಮಾಮೂಲ್ಪೇಟೆ ಎಲ್ಲವನ್ನೂ ಎಕ್ಸ್ಪೆಂಡ್ ಮಾಡ್ಕೊಂಡು ನೀವು ಫೈಲ್ಗಳು ತುಂಬಬೇಕು. You accept notice? Yes. Since the proposed legal representatives of alleged deceased respondent number 3, that is Srimati KV Lalita and Shri Sampath Kumar, or respondents number 2 and 3 respectively in RFA number 469/2019 and are being represented by their counsel, learned counsel Shri HR Raghu, appearing for them, who is physically present in the court, is directed to take notice for the said proposed LR number 3A and 3B. The learned counsel Shri HR Raghu accepts notice for R3 proposed R3A and R3B and acknowledges the receipt of the copy of IA 1, 2 and 3 of 2013 and prays for weeks accommodation to file the objections if any to the said IAs. ಆಯ್ತೆ, ನಿಮ್ಗೆ 10 ವರ್ಷದ ಕೆಲಸ ಈಗ ಸುಲಭದಲ್ಲಿ ಆಯ್ತೆ, ಒಂದು ಪೈಸೆ ಖರ್ಚಿಲ್ಲದೆಯೇ. ಆಮೇಲೆ ಅವ್ರಿಗೊಂದು ಕಾಫಿ ಕುಡಿಸಿ.
Next IA number.
ನೆಕ್ಸ್ಟ್
R2 please.
4, 5 and 6.
15 to 17.
4, 5 and 6 ಅಲ್ಲಿ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ One second. Other set of IA is about the death of respondent number 2 and bringing his legal representatives on record. Who is said respondent number 2?
Respondent number 2 is Doreswamy.
ದೊರೆಸ್ವಾಮಿ ಹೆಸರು ಈ 3 ಐಎಗಳಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಒಂದು ಐಎನಲ್ಲಿ ಇದೆಯಾ? ನನಗೆ ತೋರಿಸ್ತೀರಾ? ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ದೊರೆಸ್ವಾಮಿ ಬೇರೆ ಯಾವ್ದ್ರಲ್ಲಿ ಇದ್ದಾರೆ? ದೊರೆಸ್ವಾಮಿ ಅಥವಾ ಅವರ ಮಕ್ಕಳು?
ಅವರ ಮಕ್ಕಳು 69 ಅಲ್ಲಿ R1
ತೆಗಿರಿ. 469 ಅಲ್ಲಿ ಗೋಪಿನಾಥ್ ಪ್ರಸಾದ್, ಗೀತಾ, ಇಂದ್ರಾಣಿ, ವಸಂತ.
Yes, Gopinath.
15 to 17.
ಗೋಪಿನಾಥ್ ಪ್ರಸಾದ್. ಗೋಪಿನಾಥ್ ಪ್ರಸಾದ್ ಯಾವ್ದ್ರಲ್ಲಿದ್ದಾರೆ? 469 ಅಲ್ಲಿ. 469 ಅಲ್ಲಿ
Respondent number 1.
ಸನ್ ಆಫ್
H.G. Doras.
ಲೇಟ್ ದೊರೆಸ್ವಾಮಿ. ನಂಬರ್ 1 ನೋಡಿ.
ಮತ್ತೆ 15 to 17 are the legal.
ಒಂದು ನಿಮಿಷ. ಪ್ಯಾರಾ. The proposed respondent number 2A, Shri Gopinath Prasad, son of late Doreswamy. In IA 6/2013 is respondent number 1 in RFA 469/2019 and is being represented by his learned counsel Shri Prakash T. Hebbar. Learned counsel Prakash T. Hebbar takes notice for proposed respondent number 2A on IA 4/13, 5/13 and 6/13. ಹೌದಲ್ವೇನ್ರಿ? ಅದು ಮೂರೇ ಅದು 4, 5, 6,
4, 5, 6.
5, 6. Acknowledging the receipt of the copy of IA 4, 5 and 6 of 2013, prays for a week's time to file their objection if any, and also the wakala. ಹಿಂದಿಂದ್ರಲ್ಲಿಯೂ ಕೂಡ ರಘುದು ಆಲ್ಸೋ ವಕಾಲತ್ ಅಂತ ಸೇರಿಸಿ. ಶ್ರೀಮತಿ ವಸಂತ ಎಷ್ಟನೇರಿದ್ದಾರೆ ನೋಡಿ ಅದರಲ್ಲಿ?
ವಸಂತ respondent number 17.
17 ಬಂದೆ. ಇಂದ್ರಾಣಿಗೆ ಬರ್ತೇನೆ, ಒಂದ್ ನಿಮಿಷ ಇರಿ. 17 ಗೀತಾ ಮತ್ತೆ ಇಂದ್ರಾಣಿ.
Respondent number 15.
Huh.
Indrani respondent number 16.
Indrani respondent number 16. The proposed respondent number B, C and D in IA 6/2013 are respondents number Geeta, Indrani, Vasanta.
15, 16 and 17.
Respondent number 15, 16 and 17 respectively in RFA 469/2019 and are being represented by their learned counsel Sri H.R. Raghu, who is also physically present in the court. ಹೌದ್ರಿ, ಅದನ್ನೀಗ ಅವ್ರು ಹೇಳ್ತಾರೆ ಅಂತ ಬರ್ಕೊಳ್ತೀನ್ರಿ. ಹೌದು, ಅದಕ್ಕೆ ನೀವು ರಿಪೇರಿ ಮಾಡ್ಬೇಕಾದ್ರಲ್ಲಿ ಅದು ಬರ್ಬೇಕಲ್ವೇ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ. ಮತ್ತೆ ನಾಳೆ ಯಾರು ಕೂತ್ರು ಈ ಸೀಟಲ್ಲಿ ಗೊತ್ತಾಗ್ಬೇಕು ಏನ್ ಪೊಸಿಷನ್ ಏನೇನ್ ಇದೆ, ಯಾವ್ದು ಕ್ಲಿಯರ್ ಆಗಿದೆ ಅಂತ. Learned counsel Sri H.R. Raghu, though volunteers to accept notice for respondent proposed. Respondent number 2A, Shrimati Vasanta, however, submits that as brought to the notice of the court already in RFA ಮೊದಲನೇದು RFA 763/2019, Srimati Geeta and Srimati Indrani bracket and proposed respondent number 2B and 2C are dead. As such, she could not accept notice. ಅದರಲ್ಲಿ ಎಲ್ಲಾರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ ಅವರದ್ದು? ಗೀತಾ ಇಂದ್ರಾಣಿ ಯಾರು?
ಗೀತಾ ಮತ್ತೆ ಇಂದ್ರಾಣಿ.
ಅಂದ್ರೆ ಗೀತಾ ಇಂದ್ರಾಣಿಗೆ ಒಂದು ಮ್ಯಾಟರ್ ನಲ್ಲಿ ನೀವು ಹಾಕಿದವರು, ಈಗ ಅವ್ರನ್ನೇ ನೀವು ಎಲ್ಲಾರಂತ ತೋರ್ಸೋದ್ ಬೇಕಾದ್ರೆ
ಇಲ್ಲಿ ಫ್ರೆಶ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು. ಫ್ರೆಶ್ ಅಪ್ಲಿಕೇಶನ್ ಕೇಸಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟು
ಸರಿ, ನೀವು ಈ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ಅಥವಾ ತೀರಿ ಹೋಗಿದ್ದಾರೆ ಅಂದ್ರ ಮೇಲೆ ಅಟ್ ದಿ ಅರ್ಲಿಯಸ್ಟ್ ಪಾಯಿಂಟ್ ಆಫ್ ಟೈಮ್ ಇದ್ರಲ್ಲಿ ಅವರನ್ನ ಪ್ರಪೋಸಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಅಷ್ಟನ್ನೇ ಮಾಡಿ ಅನ್ನೋದ್ರ ಬದಲು ನೀವೇ ಅವ್ರಿಗೆ ಇರೋದ್ರಿಂದ ಇನ್ನೊಂದು ಕೇಸಿನಲ್ಲಿ ಇದನ್ನ ಹೇಗೆ ಡ್ರಾಫ್ಟ್ ಮಾಡಬೇಕು ಅಥವಾ ಏನ್ ಮಾಡಿಫೈ ಮಾಡಬೇಕು ಅದನ್ನ ಮಾಡ್ಬೇಕಲ್ವೇ? ಅಲ್ರಿ ನಂತರದಲ್ಲಿ ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೇನೆ. ಗೀತಾ ಮತ್ತು ಇಂದ್ರಾಣಿಯವರ ಮರಣದ ಸುದ್ದಿ ತಮಗೆ ತಿಳಿದು ಬಂದ ನಂತರವಾದರೂ ಕೂಡ ನಿಮ್ಮ ಅರ್ಜಿಯಲ್ಲಿ ಏನು ಮಾಡಬಹುದಿತ್ತು ಅದನ್ನು ಮಾಡಬಹುದಿತ್ತಲ್ಲವೇ? ಏನ್ರಿ?
ಓದ್ತೀನಿ. Learned Counsel Sri HR Raghu, though volunteers to
At this stage, learned counsel Shri PM Siddhamallappa for the appellant himself submits that since proposed respondent number 2B2C Srimati Geeta and Srimati Indrani are reported to be dead and they were being represented by him. They are reported to be dead. He is required to do needful in that matter for which he requires 10 days time. ಅಲ್ಲಿಗ ಈಗ 902 ಬನ್ನಿ. ಇಲ್ಲ 4 ಸ್ಟೆಪ್ ತಗೊಳ್ಬೇಕು. ಸುರಾನಿಗೆ ಇವ್ರು ತಗೊಳ್ಬೇಕು, ಇವರು ತಗೊಳ್ಬೇಕು. ಎಸ್, ಈಗ ಗೀತಾ ಮತ್ತು ಇಂದ್ರಾಣಿಯವರಿಗೆ ಯಾರು ವಕೀಲರಿರ್ಲಿಲ್ವಾ? ನೀವು ಆಗ್ತಾ ಇದ್ದೀರಿ. ಈಗ ನೀವು ಅವ್ರದ್ದು ಎಲ್ಲಾರು ಅಪ್ಲಿಕೇಶನ್ ಯಾವ್ದಕ್ಕಾದ್ರೂ ಹಾಕಿದ್ದೀರಾ? ಗೀತಾ ಮತ್ತು ಇಂದ್ರಾಣಿ ಕುರಿತಂತೆ ಎಲ್ಲಾರು ಅಪ್ಲಿಕೇಶನ್ ಯಾವ್ದಾದ್ರು ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ? ಇಲ್ಲ, ಎಲ್ಲದ್ರಲ್ಲಿ ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್. ಸೊ ಈಗ ಹಾಗಾಗಿ ಅವರಿಬ್ರು ಜವಾಬ್ದಾರಿ ಇದೆ. ಅವರಿಬ್ರಲ್ಲಿ ನಾನ್ಯಾಕೆ ಹಾಕ್ಲಿ, ಜಸ್ಟ್ ಫೈಲ್ ಎ ಮೆಮೋ ಅಂತ ಹೇಳಿ ಅವ್ರು ಕೂತಿದ್ದಾರೆ. ಈಗ ಸಿದ್ಮಲ್ಲಪ್ಪ ಹಾಕ್ಬೇಕು. ಅದೇ ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಇನ್ನೂ ಯಾರು ಹಾಕ್ಲಿಲ್ಲ. ಯಾರು ಒಬ್ರು ಹಾಕಿದ್ರೆ ಇನ್ನೊಬ್ರು ಮೆಮೋ ಹಾಕ್ತಾರೆ. ಆಗ್ಲಿ, ಈಗ ಅದಕ್ಕೊಂದು ವಾರ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಮಾಡ್ಬೋದು. ಎಸ್, 902 ಏನಿದೆ ಈಗ ಸ್ಟೇಜು?
902 ಸೇಮ್, 901 and 2
ತಡೀರಿ. ನಾ ಸಿಮಿಲರ್ ಅಂದ್ರೆ ಅಲ್ಲಿ ಯಾರೋ ಸತ್ರ ಇಲ್ಲಿ ಯಾರನ್ನೋ ಸಾಯಿಸ್ಲಿಕ್ಕೆ ಆಗ್ತದೇನ್ರಿ? ನಿಮ್ದೊಳ್ಳೆ ಕಥೆ ಆಯ್ತಲ್ಲ. ಸಬ್ಜೆಕ್ಷನ್ಸ್ ಅಷ್ಟೇ ಇದೆ ಇದರಲ್ಲಿ. ಇದೆಯಾ ಐಎಗಳಿದೆಯಾ?
number 2 and 3 are the last of complaint number 1 and 2.
ಕಾಸ್ ಲಿಸ್ಟ್ ಇದನ್ನು ಓಪನ್ ಇದೆ, ಗೀತಾ ಇಂದ್ರಾಣಿ ಇದನ್ನು ಓಪನ್ ಇದೆ. 902 ಕೊಡಿ. ಸ್ವಲ್ಪ ತೀರಿ ಹೋಗಿದ್ದಾರೆ ಅನ್ನೋಂಥವ್ರಿದ್ದಾರ ನೋಡಿದ್ರು ಇದ್ರೆ ಅದ್ರದ್ದೊಂದು ರಿಪೇರಿ ಮಾಡ್ಬೋದು. ಚಂದ್ರಕಲಾ, ರವಿ, ರಮೇಶು, ರಾಜಶೇಖರ್ ಇದ್ದಾರೆ ಅಂದ್ರೆ ಇಲ್ಲ, ತಿರುಗಿ ಹೋದವ್ರೆ. ಅದು ಮೆಮೋ ಏನು ರೆಸ್ಪಾಂಡೆಂಟ್ ಎಂದು ತೆಗೀರಿ.
ನಂಬರ್ 1 ತೀರ್ಕೊಂಡಿದ್ದಾರೆ.
Number 2 and 3 as a loss of number
RFA 902 of 2010. Learned counsels from both sides present. The learned counsel for the appellant submits that since he is required to file a necessary application with affidavit even to seek treating appellant number 2 and 3 are the sons of deceased appellant number 1, he would not press on the said memo and file a necessary application for which request 10 days time. The time as paid is granted. The memo I do. Next.
application is there. This is the respond number 2 and 3. But they are returned with our office objections. The names do not tally with the concept of here.
Are 2 and 3 na?
Yes, sir.
Respondent number 2 and 3.
But ಇದರಲ್ಲಿ ಸೆಂಟಕಲ ಅಂತ ಇದೆ. ಸೆಂಟಕಲ ಅಂತ ಇದೆ.
In view of the appellant applicant in IA 1 of 13 to IA 6 of 13 has not complied of his objection in spite of having 10 years time, those IA stands return to him. Those IA stands to return to the applicants. R1A and B.
R1 A and B, the Shishidhar Karmadi. Represent.
ಮೊದಲನೇ ತೆಗಿರಿ ಕಾಸ್ಟ್ ಆಯ್ತು ಶಶಿಧರ್ ಕಲ್ಮಾಡಿ ಅವರಿಗೆ ನಾವು ಒಂದು ಮಾಡಿದ್ದು ನೋಡಿ ಚಂದ್ರಕುಮಾರ್ ಇದು 901 ರೀ 769 R1A ಶ್ರೀಮತಿ ಶಾರದಾ and R1 ಒಂದು ನಿಮಿಷ ರೀ PF correct address to issue notice to R1 A and B. R1 A and B ಯಾರು ರೀ
Sharda and Chandrakala.
ಅವ್ರು R1 and R2 ರೀ R1 A and B ಅಲ್ಲ ಯಾರು R1 and R2 ಮಾಡ್ತಾರೆ ಗಟ್ಟಿ ಕೂತ್ ರಿಪೇರಿ ಮಾಡಿಸದೆ ಹೋದ್ರೆ ಏನಿಲ್ಲ ಎಲ್ಲ ತಪ್ಪು ಮಾಡ್ತಾರೆ ಅದು ಎರಡೂ ಕಡೆಯವರೆಗೂ ಬೇಕಾದಾಗ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಸಿಗ್ತದಲ್ಲ ಮುಂದೆ R1 A and B ಯಾರು R1 A and B ನಿಮ್ಮ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿಯೇ ಇಲ್ಲ R1 ಇದ್ದಾರೆ R2 ಇದ್ದಾರೆ R3 ಇದ್ದಾರೆ ಎ ಸೀರೀಸ್ ಆಲ್ಫಾಬೆಟ್ ಸೀರೀಸ್ ಇಲ್ಲ ನ್ಯೂಮರಿಕಲ್ ಸೀರೀಸ್ ಇದೆ ನಾನು ಹೇಗೆ ಮಾಡ್ಲಿ ಅದನ್ನ ಈಗ ಬಂದಿರೋದು 902 ಅಲ್ಲಿ 902 ಆಯ್ತಲ್ಲಿ
901 ಆಯ್ತು
R1 A and B C and F Next, the registry has shown that Laredo Council Sri PD Surana is appearing for R1 bracket C dash F and R3 to R6. Whereas the memo of appeal shows the ranking of the respondents as respondents in numeric numbers from R1 to R6, but not with any alphabets or numbers. Thus, registry to clarify its note shown in the cause list. RFA 469/2019.
R18 is best subset.
R469 ನಲ್ಲಿ ಈಗ ಏನಿದೆ
469 ಅಲ್ಲಿ ಸ್ವಾಮಿ R18 ಗೆ have to take the steps. Address correct ಇಲ್ಲ ಅಂತ ಬಂದಿದೆ. ಅದು ಬಂದು correct ಆಗಿ.
R18 ಯಾರು
R18 is Ishwar Das Prasad.
ಅವ್ರು ಬೇರೆ ಯಾವ್ದಾದ್ರು ಅಪೀಲ್ ನಲ್ಲಿ ಇದ್ದಾರಾ ಇದ್ದಾರೆ ನೋಡಿ ಸುರಾನ್ ಅವ್ರ ಅಪೀಲ್ ನಲ್ಲಿಯೇ ಇದ್ದಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ 8.
ಅವ್ರಿಗೆ ಸರ್ವ್ ಆಗಿದೆ.
ಇನ್ನೊಂದರಿದ್ದಾರೆ 901 ನಲ್ಲಿ 901
901 ಎಲ್ಲಾರು ಹಾಕ್ತಾರೆ. ಎಲ್ಲಾರ
901 ನಲ್ಲಿ ಇನ್ನೂ ರೆಕಾರ್ಡ್ ಮೇಲೆ ಬಂದಿಲ್ಲ. ಹಾಗಾಗಿ ಯು ಹ್ಯಾವ್ ಟು ಟೇಕ್ ಫಸ್ಟ್ ಸ್ಟೆಪ್. ನೆಕ್ಸ್ಟ್ ಲೈನ್ ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. ಅದು ಯಾವಾಗ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿದ್ದಾರೆ ಯಾವಾಗಿಂತ ತಗೊಂಡಿಲ್ಲ ನೋಡೋಣಂತೆ. In view of the fact that the appellant has not taken first steps to ensure the service of notice for respondent number 18, the appeal as against respondent number 18 stands dismissed for not taking steps. ಅದೆಲ್ಲದೂ ನೀವು ಮಾಡಲಿಲ್ಲ ಬಿಡಿ. 2010 ಇಂದ 13 ವರ್ಷ ಸುಮ್ಮನೆ ಇದ್ದೀರಿ. ಅದೇನ್ ಮಾಡ್ತೀರಿ ಮಾಡಿ, ಇನ್ನೊಂದ್ರಲ್ಲಿ ಬರ್ಲಿ, ಆಮೇಲೆ ಬೇಕಾದ್ರೆ ಅವ್ರನ್ನ ಮತ್ತೆ ತಗೊಂಡ್ಬನ್ನಿ.
Number 2.
2/23.
The appellant number 2 is legal age or not?
Appellant?
Also, appellant number 2.
Appellant number 2, Sri Shankarappa. ಈಗ ಇದರ ಕಾಪಿ, ಐಎ ಕಾಪಿ ನೀವು ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಿ, ಯಾರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ. 469 ನಲ್ಲಿ ಪ್ರಕಾಶ್ ಟಿ ಹೆಬ್ಬಾರ್ ನಿಮ್ಗೆ ಕಾಪಿ ಬಂದಿದೆ ಏನ್ರಿ? ಐಎಗಳದ್ದು ಬಂದಿದೆ. ರಘು ಅವರಿಗೆ ಬಂದಿದೆ ಏನ್ರಿ? ಸುರಾನ್ ಅವರಿಗೆ ಬಂದಿದೆ ಏನ್ರಿ? ಎಲ್ಲರ ಕಾಪಿಗಳು ಹೌದು. ಇಟ್ ಮೇ ಬಿ ಅಲೋಡ್ ಅನ್ಬೇಕಾದ್ರೆ ಉಳಿದಿರೋರು ಸರ್ವ್ ಆಗ್ಬೇಕಲ್ವಾ ರೆಸ್ಪಾಂಡೆಂಟ್. ಅದಾದ್ರೆ ಐ ಕ್ಯಾನ್ ಪ್ರೊಸೀಡ್ ಫರ್ದರ್. ನಿಮ್ದು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. Learned counsel for respondent number 1, respondent number 2 to 8, 15 and 17. Nine to 12 who are physically present acknowledges the receipt of the copy of IA 1 and 2 of 2023 and submit their no objection to allow those applications. IA 3/23 yaudri?
IA 1 and IA 3.
However, objection if you need to be heard from the other respondents, learned counsel for other respondents, the said IA could not be proceeded with today. Next body.
IA number
3 of 23.
Suggestion. IA 1 and IA 3. Notice has to be
Rani. Mentioned as Indramani in death certificate. As an appeal, it is mentioned as.
certificate.
ಅದರಲ್ಲಿ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಚೇಂಜ್ ಇದೆ. ನೀವು ಕರೆಕ್ಟೆಡ್ ಕಾಪಿ ಹಾಕ್ಬೇಕು.
ಮಣಿ ಅಂತ
ಹೌದ್ರಿ, ಅದೇ ವ್ಯತ್ಯಾಸ ಆಗ್ತದೆ.
ಸೇಮ್ ಲೀಗಲ್ ಅವರೇ ಸರ್ಟಿಫಿಕೇಟ್.
ಅದನ್ನ ನೀವು ಕಾನೂನಾತ್ಮಕವಾಗಿ ಹೇಗೆ ಹೇಳ್ಬೇಕು ಹಾಗೆ ಹೇಳಿ. ಬರೀ ಬಾಯಲ್ಲಿ ಹೇಳಿದ್ರೆ ಆಗಲ್ಲ ಅಲ್ವೇ? ಸಿದ್ಮಲ್ಲಯ್ಯ ಬೇರೆ, ಸಿದ್ಮಲ್ಲಪ್ಪ ಬೇರೆ, ಸಿದ್ದಮಲ್ಲ ಬೇರೆ ಅಲ್ವೇ? the learned counsel for the applicants in IA. Three of 23. In view of the fact that registry has shown that IA 3 of 2023 has stood returned to the applicant with office objection, the said IA does not warrant, the said IA does not exist to proceed with.
Yeah, one number here. Shrimati Geeta.
Legal aid something.
Phone number 15, Shrimati Geeta.
ಅದು ಯಾವ್ದ್ರಲ್ಲಿ ಬರ್ತದೆ ಮುಗಿತಲ್ಲ ಮ್ಯಾಟರ್ ಅಷ್ಟು
1 of 23.
69. Yeah, one ಬಗ್ಗೆ
ಇಲ್ಲಿ ಶ್ರೀಮತಿ ಗೀತಾ ಎಲ್ಲಾರ್ ತರೋದಕ್ಕೆ
ಇದ್ರಲ್ಲಿ ತೋರಿಸಿದ್ದಾರಾ
ಫಸ್ಟ್ ಅವರು ಡೈರೆಕ್ಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಬೇಕು 2 of 23
2 of 23 ಮಾಡಿದ್ರು. ರೆಸ್ಪಾಂಡೆಂಟ್ ಇವ್ರು ಇಲ್ವಲ್ಲ,
phone number 15.
ಶಶಿಧರ್ ಕರ್ಮಾಡಿಯಿಂದ ಯೋಗೇಂದ್ರ ದಾಸ್ಗೆ
ಸರ್ವ್
ಅವರಿಗೆ ಶಶಿಧರ್ ಕರ್ಮಾಡಿ ಬೇಕಲ್ಲ, ಅಷ್ಟೇ ಇಡಿ. ಈಗ ಅದರಲ್ಲಿ ಆದಷ್ಟು ಇಟ್ಕೊಡಿ, ಯಾವ್ದ್ರಲ್ಲಿ ಇಂಟಿದೆ ಮಾತ್ರ ಇದೆ.
69.
ಯಾವ್ದಾದ್ರು ಒಂದಾದ್ರು
ಈ ಎಕ್ಸ್ಟೆಂಡ್ ಯಾವ್ದ್ರಲ್ಲಿ ಆಗ್ಬೇಕು
763.
ಕೊಡ್ರಿ. 763 ಪ್ರೀವಿಯಸ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್. Next paper. 3 weeks time is granted to both sides in all the matters to do needful as observed above as a final opportunity. ಅದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ವಲ್ಲ ವಕೀಲ್ರೆ, ನಂತರದ ಡೇಟ್ಗಳಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಲಿಲ್ಲ. ಒಂದು ಐಎ ಹಾಕಿ ಮಾಡುವ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಇಷ್ಟ ಮ್ಯಾಟರ್.
Serial number 45. Sukmaran G. Connected. Prasanna we have for Kevata respondent.
since this time the issue has been purchased.
You are not pressing both the appeal. Connected ನಲ್ಲಿ panel disposal ಒಟ್ಟಿಗೆ ಮಾಡ್ತೀರಾ ಬೇರೆ ಮಾಡ್ತೀರಾ? Not pressing on that. ಒಟ್ಟಿಗೆ ಮಾಡ್ತೀವಿ. ಆಮೇಲೆ ಒಂದು ಕನ್ಫ್ಯೂಸ್ ಮಿಸ್ಟೇಕ್ ಅಂತ ಹೇಳ್ಬಾರ್ದು. The counsel for the appellant sin RFA 2218 of 2019 and RFA 2182 of 2019. Has filed one memo each in these two appeals. Not pressing the appeal. The learned counsel for the letter of the respondent submits that no objection to allow the memo. In view of the memo supporting submission from both sides. Both the appeals stands dismissed as having become ineffective. Yes.
Number 46.
DB 47 before DB.
Number 47. Brilliant.
ಏನು ನೀಡ್ಫುಲ್ ಮಾಡಿದ್ದೀರಿ ಯಾವಾಗ ಮಾಡಿದ್ದೀರಿ ಮಾರ್ನಿಂಗ್ ಮಾಡಿದ್ದೀರಿ counsel for the appellant submits it to the registry to verify and proceed further. Yes.
Number 46. DV Vidyalata.
ಏನು ನೀಡ್ಫುಲ್ ಮಾಡಿದ್ದೀರಿ ಫ್ರೆಶ್ ಏನು ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ದೀರಿ ಈಗ ಯಾವಾಗ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿದ್ದೀರಿ ಯಾವಾಗ ನೀಡ್ಫುಲ್ ಮಾಡಿದ್ದೀರಿ ಸೇ ಮಾಡಿ ಎಸ್ ರಿಜಿಸ್ಟ್ರಿ ಟು
Number 49. DV Vidyalata.
take a step. The cover not been returned. The learned counsel for the appellant prays for a week's time to take fresh steps to ensure the service of notice upon the sole respondent. Time has been granted. Yes.
Number 50. Sola.
Counsel for the appellant submits that she has taken fresh steps to ensure the service of notice upon sole respondent today. She further prays for 2 weeks time to comply the office subjection as a 1 week time to comply office subjection. And finally, the time as paid is granted. With respect to service of notice, registry to verify and proceed further. Yes.
Number 51. Saraswati.
2 weeks actually. ಹೌದು ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಅಂದ್ರೆ 2 weeks ಒಳಗಡೆ ಅದು ಸರ್ವ್ ಆಗಿ ವಾಪಸ್ ಬರಬೇಕು. ನೀವು ಸ್ಟೆಪ್ ತಗೊಳ್ಳಿಕ್ಕೆ 2 weeks ಅಂತೀರಿ. Request of the 11th council for the appellant as finally. It is granted. Yes.
He was convicted for offense of 32 NI Act. My lordship on 1/12/22. Lordship granted 8 weeks time to pay the fine amount while suspending the sentence of 4,67,000 within 8 weeks. But the region petitioner could not pay, collect the amount and could not apply the 8 weeks time. And now he had arranged 4,67,000 fine amount and is ready to pay the deposit. So praying for extending the time of from 8 weeks to further 20 weeks till June.
Respondent with the concludes.
Yeah, Vishwanath.
Yeah, we'll put it in the consideration. For the submission of Lord Council for vision petitioner on year 1/23. Filed by the revision petition. By the revision petition, seeking permission to pay the fine amount as per the order dated 1/12/2022. The Lord Council for the respondent has remained also. There is the affidavit accompanying the application. The Prior reading the application is the permission to deposit the fine amount. However, there is no prior about the revival of the interim order granted on 1/12/2022 or no application for any interim relief. Since the interim order granted on 1/12/2022 has already stood expired by the end of the 8 weeks, the question of allowing, because the allowing of the present IA would serve no purpose, since the very order of suspension of sentence has already been expired. Hence, IA 1/23 does not deserve to be allowed. Accordingly, it stands rejected. Yes.
Bill number 54, S.A. Swami.
Each step to fail. Get the respondent. Each step to fail memo.
Counsel for the appellant not present. Counsel for respondent number 2, public caveat on. Praise for a week's time. The time has already been granted. Yes.
Bill number 55, Prem Nath TN.
2 weeks. Yes.
Last 4 years, after Corona, I could not reach. 2 weeks time, otherwise. They are ambulance and
Counsels from both sides present. In spite of having sufficient time from the year 2019 till date, the respondents have not filed their objections if any to IA 1/17. Hence, it is taken that objection to 1/17 is not filed by the respondent. Naturally, there is IA 1/17 filed under Section 5 of Limitation Act by the appellant seeking duration of delay of 178 days in filing this appeal. Heard submission from both sides. Considering the fact that the applicant in the sworn affidavit has stated that for some time the certified copy of the impugned judgment was misplaced, and in the meantime he lost his brother also. As such, there was a delay caused, and the said reason being not denied by the respondent since they have not filed objection. I am of the view that the appellant has explained the delay with sufficient cause. Hence, IA 1/17 stands allowed and the delay of 178 days in filing the appeal stands condoned. Yes, next.
56, Manjunath S.
Delay of 50 days.
The counsel for the appellant alone present and counsel for the respondent neither present physically nor through video conference. In spite of having sufficient time, the respondent has not chosen to file her objection if any to IA 1/17. Hence it is taken that the respondent has not filed objection if any to IA 1/17. Next line, perused IA 1/17 filed by the appellant under section 5 of limitation seeking condemnation of delay of 80 days in filing the appeal. Considering the reasons shown in the heard the submission of the counsel for the applicant. Considering the reasons shown in the affidavit accompanying the application where the deponent has pleaded inter area is economic constraint to pay the court fee. And the submission made by the land counsel for the appellant, and also considering the nature of the suit. I am of the view that the applicant has shown the sufficient cause for condemnation of delay accordingly. Sufficient cause for delay. Hence, IA 1/17 stands allowed and the delay of 80 days. In filing the appeal stands condoned. Yes.
57, A. Balakrishnan.
The IA put up ಮಾಡಿಲ್ರಿ ಅವರು ಆಗಿದೆ. Yes, as finally 10 days time is granted to the respondent to file their objection if any to IA 2/17. Yes.
Serial number 57, Balakrishnan.
None appear for appellant. Which time is granted for the appearance of the counsel for the appellant and to proceed further, filing which the court would pass appropriate order, including dismissal of the appeal for non-prosecution. If the matter on pertain to or.
58 NS Bhatt.
Notice PCR.
59 Nur Mohammed.
Allowed for the appellant in this case. Allowed praying 2 weeks of additional time for filing the paper book, my lord.
Counsel from both sides present. 2 more weeks time is spread for by learned counsel for the appellant is granted to file paper.
Much obliged.
60 Murthy K.
Notice PCR. That's good.
61 Nagarajas.
It is chairman. Notice sir.
For the submission of the counsel for the appellant, there is the memorandum of appeal, including judgment and pending liens. There is delay in filing the appeal. Then issue notice to the respondents. Pending liens. Appellant to pay the necessary process that furnished copies in the registry if not already done. In a week from today. The registry to also call for TCR.
62 Jayan Mohan.
That file was different number 20 for the trial court. They have to speak to this.
Defendant number 1 did not join you.
He has filed separate appeal. Different, no. Native has filed separate appeal.
Appeal number.
Root of the. Find out. Native has filed the.
Notice TCR. Yes.
63 Achha Anand.
The 4 weeks time to file CB, paper book. 1 week.
Number 1 or 2 file memo.
Memo of what?
Connected the appeal.
Microphone is a use ಮಾಡ್ರಿ.
The trial court disposed 3 suits simultaneously. So here in the appellant filed different appeals.
It has an extra appeal. That can be.
The appellant file here in separate appeals. The suit for partition decreed. The other this suit and another injunction suit dismissed. Before the trial court.
ಅದಕ್ಕೆ ಏನಾಗಬೇಕು?
ಅದಕ್ಕೆ
ಕ್ಲಬ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಒಂದೇ ಬೆಂಚ್ ಮುಂದೆ ಏರ್ ಆಗ್ಬೇಕು.
ಕಲಿಬೇಕಲ್ವಾ ಸಬ್ಮಿಷನ್ ಮಾಡೋದನ್ನ ಮತ್ತೆ?
ಅಲ್ಲ ಒಂದೇ ಬೆಂಚ್ ಮುಂದೆ ಏರ್ ಆಗ್ಬೇಕು.
ಅದು ಯಾವ ಬೆಂಚ್ ಎದುರಿದೆ?
ಅದು ಬೇರೆ ಇದರಲ್ಲಿ ಟೋಟಲ್ ನಂಬರ್ 4 ಅಲ್ಲಿ ಬಂದಿತ್ತು.
ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಇದೆಯಾ ಅದು?
ಹೌದು.
ಇದೇ ಇಂಕ್ಲೂಡ್ ಜಜ್ಮೆಂಟ್ ಮೇಲೆ ಅದು
ಸಪರೇಟ್ ಸೈಮಲ್ಟೇನಿಯಸ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ದಾರೆ.
ಅಕಾರ್ಡಿಂಗ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ ಕೂಡಲೇ ಅದಕ್ಕೆ ಹೋಗ್ಬೇಕಂತ ಎಲ್ಲಿದೆ?
ಅಕಾರ್ಡಿಂಗ್ ಟು ದಿಸ್ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಅಕಾರ್ಡಿಂಗ್ ಟು ದಿಸ್ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್.
ಏನ್ ಡೈರೆಕ್ಷನ್ ಇದೆ ಹೇಳಿ?
ಎಸ್ ಸರ್.
ಓಕೆ, ಫೀಸ್ ತಗೊಂಡಿರೋದಕ್ಕೆ ನೀವು ಓದ್ಕೊಂಡ್ ಬರ್ಬೇಕಿಲ್ಲಿ ಅಲ್ವೇ? ಕಡಿಮೆ ಫೀಸ್ ತಗೊಂಡಿದ್ರೆ ಹೇಳಿ, ಜಾಸ್ತಿ ಕೊಡಿಸುವ ಓದ್ಕೊಂಡ್ ಬನ್ನಿ.
ಅದರಲ್ಲಿ ಅಪೀಲ್ ಬಂದಿದ್ರು ಸರ್. that trial total pending.
ಇನ್ನೊಂದು ಸೂಟು simultaneously dispose ಆಗಿದೆ. ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಬಂದಿದೆ. Admittedly, both the judgments are separate judgments, separate evidence, separate pleading.
The subject matter is interlinked. All suits.
ಅದನ್ನ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿ. ಆ ಮೆಮೊನ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿ. DB can summon this record there. Yes.
4 weeks time.
Learned counsel from both sides present. As requested for by learned counsel for the appellant, 4 more weeks time is granted. Entry ಮಾಡ್ರೆ ಮಧ್ಯಾಹ್ನ 2:30ಗೆ ಬನ್ನಿ. ಟೈಪ್ ಆಗದೆ ಹೋದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡುವ. ಟೈಮ್ ಕೇಳೋದ್ರ ಮುಂಚೆ ಇಂಟರ್ವ್ಯೂ ಮಾಡರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳಬೇಕು. ಅವಾಗ ನಾವು 4 weeks ಕೊಡ್ಬೇಕು, 3 days ಕೊಡ್ಬೇಕು ನೋಡ್ತೇವೆ. ಹಾ, ಮಕ್ಕಳು ಮಾಡ್ತಾರಲ್ಲ, ಐಸ್ ಕ್ರೀಮ್ ಬೇಕು, ಐಸ್ ಕ್ರೀಮ್ ಆದ್ರ ಮೇಲೆ ಅಲ್ಲಿರೋ ಚಾಕ್ಲೇಟು ಕೊಡು ಅಷ್ಟೇ. ಮಧ್ಯಾಹ್ನ 2:30ಗೆ ಬನ್ನಿ. ನೀವು ಸೀನಿಯರ್ ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ಜೂನಿಯರ್ ಏನ್ ಮಾಡ್ತಾರೆ? ಅದನ್ನ 2 weeks ಮಾಡಿ ಕೊಡಿ ಆರ್ಡರ್ ಶೀಟ್. 23 ವರ್ಷದಿಂದ ಹೇಳ್ತಿದ್ದೇನೆ ಅನಂತ ಕೃಷ್ಣ ಅವರೇ. The interim order granted on 19/4/2023. Times extended for the same period. Yes.
Admission matters, seal number 64, Srihari AV.
4 weeks. Object or application in re.
Also. You have filed 3 applications.
Ah.
One is to recall, another one to appoint a road commissioner and to consider my case, that is our IA number 1. Application 1 was allowed and 2 applications were rejected.
For what reason?
The ground that my sister-in-law has already filed a suit. There was a suit against my sister-in-law. The suit came to be allowed and RFI filed by my sister-in-law came to be dismissed. These are one of the ground numbers. My case is that in 1980, my brother Srinivas had purchased the site number 25 from one Bayanna and Krishnappa, 1980 matters. 1981, under a family settlement, that site came to be allotted to me. That is site number 25. The plaintiff before the trial court claims that there was a sale deed in favor of him in the year 2001 by the BDA. He claimed that land came to be acquired for the formation of Nandini Road, survey number 14/7 of Lagare village. From out of which the site in question is carved out, that came to be
Admit case paper book 6 weeks. ಬಂದಿದ್ಯಾ? Admit paper book 6 weeks. Yes.
Short date can be on 2017.
ಪೇಪರ್ ಬುಕ್ ಹಾಕ್ಬೇಕು. ಈಗಷ್ಟೇ ಅಡ್ಮಿಟ್ ಆಗಿದೆ. ಅದು ಅಡ್ಮಿಟ್ ಆದ್ಮೇಲೆ ಸೀನಿಯಾರಿಟಿ ಪ್ರಕಾರ ಬರ್ತದೆ. 2017 ಹಿಯರಿಂಗ್ ಬರ್ತದೆ.
Srinivas Murthy, seal number 65.
ಇದು ಸ್ವಲ್ಪ ಎಡಗಡೆ ಸರ್ಕಲ್ ಅಲ್ಲಿ ಮುಂದೊಂದು ಕಡ್ಡಿ ಇದೆ ನೋಡಿ, ಅದ್ರ ತುದಿಯಲ್ಲಿ ಒಂದು ಬಾಯಿ ಇದೆ ನೋಡಿ, ಅಲ್ಲಿ ಮಾತಾಡಿ. Yes.
on 30/11/2021. This honorable court has passed the following law.
None appears for the.
Learned counsel for the appellant is alone is physically present. Learned counsel for the appellant neither present physically nor through video conference. 30/11/2021, this court had made the following declaration. In spite of the above, the learned counsel for the appellant neither appearing nor showing any reasons for non-appearance in the matter. Hence, the appeal is of the year 2017. Hence, the appeal stands dismissed for non-prosecution. Yes.
Serial number 66, Afzal Khan.
None appear in this matter either physically or through video conference. ಇದೆಲ್ಲದನ್ನು ಮೇಲಿಂದನೇ ಆರ್ಡರ್ ಡೇಟೆಡ್ 35/2020 ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿ. Yes.
G. Lakshmi Rao.
The counsel from both sides present as requested for by learned counsel for the respondent, to which I must grant it. Yes.
68, D. Balkrishna Shastri.
Petition got dismissed by the learned trial judge. Plaintiff is the appellant before the lordships. First defendant is the father. Second defendant is the mother. Defendant number 4 and 5 are the two brothers. Then up to defendant number 10, my lord, the rest of them are sisters. Several items, my lord, stand in the name of first defendant and second defendant. Second defendant died, my lord, during the pendency of this. The first defendant died, my lord, during the pendency of this appeal. So both mother and father, my lord, are no more now. About 23 items are standing in their name. The appellant and D1 to D9 are the heirs. Only dispute, my lord, which the other side could make is in respect of certain items, which the defendant number 4 claims as his self-acquired property. There, my lord, some ticklish issues are there. The 4, very few items stand in the name of D4. Some property is he has purchased in the name of his wife and in the name of his son. That is being contested by my clients as not the acquired out of joint family properties. These are the points, my lord. But major portions of the properties, now, my lord, there could be no dispute because D1 and D2 being the parents are no more. Not all children are bound to get, my lord, equal share. In about 20.
You have failed to prove that the properties in dispute were acquired out of nucleus of the joint family.
No, my lord, that's where, my lord, I say the trial judge holds so, my lord, but that here the error is D1 and D2, my lord, are the parents. About 23 items stand in their name. They did not file any return statement. They did not enter into the witness box. Now they are no more. So we are children, not sons, 3 sons and 5 daughters. They are liable to be partitioned. Not. The trial court says, Lord, trial court only considers not the property standing in the name of D4. But that's what happens. Parties contest on some issues with the some hatred or some rivalry in respect of certain issues. Parties have gone on arguing that point. The court has concentrated and delivered judgment only on that item. It says item standing in the name of D4 is not proved to be acquired out of not a joint family properties. But there are several items which need not be, no one can join issue in respect of those items.
What is that connected appeal?
Lord,
this is one of the properties, which is the self-acquired property of the defendant number 4 here in the suit for partition. There was a permissible possession given to the plaintiff. That suit came to be dismissed on the ground that the suit schedule property is part and parcel of the larger issue in partitions. It was a permissible possession where I have filed a suit for vacate and hand over the physical possession.
Now the true fact is, my lord, the defendant has now built his own house, residing with his family, which has been culled out in the partition suit, that he is staying with the separate house with his family built in a different location. Now the suit schedule property in RFA 128 is now rented out to a third party, and the fruits of the property belonging to me, even though I have a decree.
ಶಾಸ್ತ್ರಗಳು ಖಾಲಿ ಮಾಡಿ ಕೊಡಬೇಕು ಅಂತ.
ಖಾಲಿ ಮಾಡ್ಕೊಡ್ಬೇಕಂತ ನಾವು
ಯಾವಾಗ ಮಾಡ್ತೀರಿ?
Sir, out of joint family properties, that property was acquired. Out of not income from the joint family properties, that item was acquired. That was acquired not in the year 1982. I am residing there from the year 1988, even according to him. Sometimes he said I am in permissive possession. Sometimes he said it was rented out to me. There is nothing to show it is rented out. From 88, I have been residing it. It's an undisputed fact.
Whatever
Now,
I
my
say,
lord,
the plain pleading speech.
he also admitted as a DW1 in the cross examination. D5 was residing here. Parents were residing here. That is how I say, my lord, it is a property acquired out of joint family income, and it is a joint family
Both
property.
of your brothers.
Yes.
Both of them are brothers, full brothers.
Excellent.
Please attest.
ಏನಾದ್ರು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ಗಳು ಏನಾದ್ರು ಮಾಡ್ಕೊಂಡಿದ್ದಾರ? ಸ್ವಲ್ಪ ಮಾಡ್ಕೊಳ್ಳಿ.
Sir, ಅಷ್ಟೇ ಬಾಕಿ ಅದರಲ್ಲಿ.
ಅವ್ರಿಗೆ ಹೇಳಿ ಅಪ್ಪ ತಗೋ ವಿಸಿಟಿಂಗ್ ಕಾರ್ಡ್ ಇನ್ನೊಂದು ಏನಾರು ಇದ್ರೆ ಮಾಡು. 320 ಇಂದ ಹಾಫ್ ಮರ್ಡರ್ ವರೆಗೂ ನಾ ಮಾಡ್ತೇನೆ.
ಅಂತದ್ದು ಹೋಗ್ಲಿಕ್ಕೆ ನಾವು ಗೊತ್ತಿಲ್ಲ. ಅಲ್ಲ, my lord, one submission I would like.
ಅಷ್ಟು ಎಕ್ಸಾಸ್ಟ್ ಮಾಡಬಾರ್ದ್ರಿ ನೀವು. ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಅಲ್ಲೇ ಪಾರ್ಟ್ನ ಅಷ್ಟು ಡ್ರೈ ಮಾಡಿ ಬಿಟ್ರೆ
ಅಲ್ಲ,
ಎಷ್ಟು ಮಾಡಬಾರ್ದು.
in the cross examination it has been clearly illustrated that father was having only 1 acre 30 guntas of a dry land. It has been illustrated, your honor. ಮತ್ತೆ ನಾ ಇಲ್ಲಿ 8 ವರ್ಷಕ್ಕೆ ಊರಿನಲ್ಲಿದ್ದ ಎಲ್ಲಾನ ಬಿಟ್ಟು ಬೆಂಗಳೂರಿಗೆ ಬಂದು ನಾನು ಕೂಲಿಯಾಗಿ ಮಾಡಿ ಮೆಜೆಸ್ಟಿಕ್ ನಲ್ಲಿ ಒಬ್ಬ ಸರ್ವರ ಕೆಲಸ ಮಾಡಿ ಇಲ್ಲಿ ದುಡಿದಂತನ್ನೆಲ್ಲ ಊರಿಗೆ ಹೋಗ್ಬಿಟ್ಟು ಅಪ್ಪ ಊರಲ್ಲಿದ್ದಾರೆ ಅಂತ ಅಪ್ಪನ ಹೆಸರಿನಲ್ಲಿ
ಹೇಳಿ
ಅಪ್ಪನ ಹೆಸರಿನಲ್ಲಿ ಆಸ್ತಿ ಮಾಡಿದ್ನೆಲ್ಲ ಇವರು ಅಪ್ಪಂದು ಸ್ವಯಾರ್ಜಿತ ಸ್ವತ್ತು ಪಿತ್ರಾರ್ಜಿತ ಸ್ವತ್ತಿನಲ್ಲಿ ಬಂದಂತ ಸಂದರ್ಭದಲ್ಲಿ ಫಾದರ್ ವಾಸ್ ಅಲೈವ್ when the suit partition was there going on here.
ಅವ್ರು ಹೇಳ್ತಿರೋದು
ಇವಾಗ ಅಪ್ಪ ಸತ್ತಿರ್ಬೋದು.
ಫಾದರ್ ಉಳಿದವರು ಪ್ರೋಟಾನ್ ನ್ಯೂಟ್ರಾನ್ ಇದ್ರು, ನಾನು ಎಲೆಕ್ಟ್ರಾನ್ ಆಗಿ ಸುಮ್ಮನೆ ಸುತ್ತಾ ಇದ್ದೆ, therefore I am not in the nucleus ಅಂತಾರೆ ಅಲ್ವೇ?
ಅಲ್ಲ, ಇವಾಗ ಅದು it would have been the burden on the person who comes to show that he is entitled, and the suit schedule properties are earned and acquired through the joint nucleus of the family. Joint nucleus of the family ಅಂತ ತಾವ್ ಹೇಳ್ದಂಗೆ ಬಂದಂತ ಸಂದರ್ಭದಲ್ಲಿ ನ್ಯೂಕ್ಲಿಯರ್ ಎಲ್ಲ ನಾವು ಬಂದಂತ ಸಂದರ್ಭದಲ್ಲಿ ಅಲ್ಲಿಂದ ಏನಾದ್ರೂ ವರಮಾನ ಬಂದಿತ್ತು ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ if that is put across, your honor, yes, I will hold up.
That we will see. Yes, Lord Counsel.
ಇವಾಗ ಇದರಲ್ಲಿ ಎರಡನೇ ಕೇಸ್ ನಲ್ಲಿ ಏನಾಗಿದೆ,
appellant and caveators in RFA 2172/2019 and the learned counsel for the appellant in the connected RFA 128 of 2015 are physically present. For the submission from both sides on admission of RFA 2172/2019. Concerning the grounds raised in the memorandum of appeal, which requires a detailed consideration, RFA 2172/2019 stands admitted. Call for TCR if not already called. ಬಂದಿದೆ ಅಂತ ಎರಡು ಕಾಮನ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲ ರೀ, ಬೇರೆ ಬೇರೆದು ಮತ್ತೆ ಬಂದಿದೆ ಅಂತ ಹೇಳ್ತಿದ್ದೀರಿ. ನಿಮ್ದ್ರಲ್ಲಿ ಆಗ್ಲಿಲ್ಲ ಇನ್ನು ಏತನ್ರಿ? For record if not already called. Paper book to be filed within 6 weeks from today. Yes.
in the connected appeal, I am put to hardship.
ಅಲ್ಲ ಹೌದು ರೀ, ಕನೆಕ್ಟ್ ಮಾಡಿಸ್ಕೊಂಡಿರೋದು ನೀವು ಅಥವಾ ಅವರು?
ಇಲ್ಲ, ದಯವಿಟ್ಟು
ಅದೀಗ ಕನೆಕ್ಟ್ ಆಗಿ ಬಿಟ್ಟಿದೆ, ನೀವು ಅದನ್ನ ಹೇಳಿ ಬಿಡಿ. ಅದು ಏನೇ ಮಾಡ್ಲಿ, ಈಗ ಒಂದು ಬೋಗಿ ಅಟ್ಯಾಚ್ ಆಗಿದೆ, ಒಂದು ನಿಮಗಿರೋದು 2 ಆಪ್ಷನ್. ಯಾವ್ದಾದ್ರು ಒಂದು ಸ್ಟೇಷನ್ ಸಾಧ್ಯ ಇಲ್ಲ, ಜಂಕ್ಷನ್ ಬಂದಾಗ ಬೋಗಿನ ಡಿಲಿಂಕ್ ಮಾಡಿಸಿ, ಎಂಜಿನ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಸ್ಪೀಡ್ ಆಗಿ ತಳ್ಳಿ, ಬೇಗ
ಮಾಡೋಣ ಅಂತ ನನ್ನ ಇಚ್ಛೆ ಇದೆ.
ಮಧ್ಯಾಹ್ನ ಚಂದ ಮಾಡಿ ಅವ್ರನ್ನ ಮಾತಾಡಿಸಿ ಶಾಸ್ತ್ರಿಗಳನ್ನ, ಅವ್ರು ಬೇಗ ಪೇಪರ್ ಬುಕ್ ಹಾಕ್ತಾರೆ, ಅವಾಗ ಮುಗಿಸಿ ಬಿಡುವ.
ಮುಂದೆನೆ ನಾನು ಇವಾಗ ಇದೇ ಜಂಕ್ಷನ್ ಅಂತ ತಿಳ್ಕೊಂಡು ನಾನು ಇಲ್ಲೇ ಡೀಲಿಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಪ್ರಯತ್ನ
ಮಾಡುವ. ಮುಂದಿನ ವಿಚಾರಣೆಯಲ್ಲಿ ಅದು ಏನಿದೆ ಹೇಳಿ, ಯಾಕೆ ಲಿಂಕ್ ಆಗಿದೆ, ಅದು ಯಾಕೆ ಲಿಂಕ್ ಆಗ್ಬಾರ್ದಾಗಿತ್ತು ನೋಡು. ಎಸ್
ಶಾರ್ಟ್ ಡೇಟ್ ಅದಕ್ಕೋಸ್ಕರ ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಟ್ರೆ
ಶಾರ್ಟ್ ಡೇಟ್ ಅಲ್ಲ, ನೀವು ತಯಾರಾಗಿ ಬನ್ನಿ, ಅವ್ರನ್ನ ತಯಾರು ಮಾಡಿಸಿ ಬನ್ನಿ, ಲಿಸ್ಟ್ ಮಾಡುವ, ಅದನ್ನ ಕೇಳುವ.
ಇವಾಗ ಅವ್ರ ಪೇಪರ್ ಬುಕ್ ಹಾಕ್ಲಿಕ್ಕೆ 4 ವಾರ ನಮ್ಮ ಸಮಯ
ಅಲ್ಲಿವರೆಗೆ ಕಾಯ್ಬೇಕು. ಇಷ್ಟು ವರ್ಷ ಕಾದಿದ್ದೀರಿ ಅಲ್ವೇ? 8 ವರ್ಷ ಕಾದಿದ್ದೀರಿ,
15ರಿಂದ ಕಾಯ್ಕೊಂಡೇ ಇದ್ದೀವಿ.
ಕತ್ಕೊಂಡೇ ಇದ್ದೀರಿ. ಇರ್ಲಿ ಬಿಡಿ, ಸೀನಿಯರ್ ಸಿಟಿಸನ್ ಏನಾದ್ರೂ ಭಾಗ್ಯ ಬರ್ತದೆ ಮತ್ತೆ ಹೊಸ್ತು ನೋಡುವ.
ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಅಲ್ಲ, ತಮ್ಮನೇ ಅಲ್ಲಿದ್ದಿ, ತಮ್ಮ ಮತ್ತೆ ತಮ್ಮನ ಕುಟುಂಬ ಅಲ್ಲಿ ಇದ್ದಿದ್ರೆ ತಾವ್ ಹೇಳೋದಕ್ಕೆ ನಾನು
ಬಾಡಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತೀರಿ ನೀವು.
ಬಾಡಿಗೆ ಕೊಟ್ಬಿಟ್ಟು
ಸರ್.
ನೋಡುವ, ಅದನ್ನ ಕೇಳುವ. ಈಗ ಬೇಡ, ಮತ್ತದು ಉದ್ದಕ್ಕೆ ಬೆಳೀತದೆ. ಬರ್ಲಿ. ಎಸ್,
ಅಲ್ಲಿ ಏನಾಗಿದೆ
ಮಾಡುವ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಮಾಡುವ. ಒಂದೇ ಸರ್ತಿಗೆ ಅಷ್ಟು ಆಗಲ್ಲ. ಅದು ಯಾಕೆ ಲಿಂಕ್ ಆಗಿದೆ, ಅದು ಏನು, ಇಟ್ ಟೇಕ್ ಸಮ್ ಟೈಮ್ ಟು ಹಿಯರ್ ಫ್ರಮ್ ಬೋತ್ ಸೈಡ್. ಎಸ್,
ಮುಂದೆ ಆಗುವಷ್ಟು ಬೇರೆ ಕಡೆ ಆಗಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ನಾನು ಇಷ್ಟೆಲ್ಲ ತಮ್ಮ ಮುಂದೆ ಕೋರಿಕೆ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ನೋಡುವ. ಈಗ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಬರ್ತದೆ ಅದು. ಬೇಗ ಹಾಕ್ರಿ ಪೇಪರ್ ಬುಕ್. ಎಸ್, ಯಾಕೆ ನಿಮ್ ದುಡ್ಡು ನಿಮ್ಗೆ ವಾಪಸ್ ಬರ್ತಿಲ್ಲ?
But in fact, he had issued me a check that was bounced. Now their defense is not that they have paid it to the tenant. According to them, for the purpose of eviction of the tenant, they have paid so much to him without my consent, without my knowledge, and the tenant was supposed to have, who is said to have received this amount, but has not come before the court to say that he has received. By an MOU between the defendants and the so-called tenant lord. They say that it has been paid to him so that defendant need not pay me. The sale deed has been categorically said the entire physical possession of the property has been handed over to the vendors, that's it, defendants. There was no question of vacating any tenant at that point of time. They say that they have taken the vacant physical possession.
Admit notice, TCR, process to be paid within 4 days from today. Yes.
70 HN Basuraju.
But appellants are the defendants before the trial court. First respondent is the plaintiff. Suit for damages for defamation.
ಒಂದು ನಿಮಿಷ. ಕಂಡಾಪಟ್ಟೆ ಬೈದಿದ್ರ ನೀವೆಲ್ಲ ಪ್ಲೇಂಟಿಫ್?
ಇದನ್ನೇ ಬೈಗಳದಾದ್ರೆ
ನಿಮ್ ಕ್ಲೈಂಟ್ಗಳೆಲ್ಲ ಆಪಾಟಿ ಬೈತಾರ?
very nicely they have used. Very nicely they have. ಇದೆಲ್ಲ ಬೈಗಳ ಇದು ಮಾನ ಹಾನಿ ಇದ್ದಾರೆ. It's a time for him to commit suicide because he is not eligible to stay in our country. House building cooperative society.
ಅಂತವ್ರಲ್ಲಿ ಬೈಯೋರಿಗೂ ಸ್ವಲ್ಪ ಧೈರ್ಯ ಬೇಕಲ್ವೇ?
ಹೌದು. ಅದು ಮಹಾತ್ಮ ಗಾಂಧಿ ಮೂರ್ತಿ ಕೆಳಗಡೆ ಕೂತ್ಕೊಂಡು ಬೈದಿದ್ದಾರೆ ಸೈಕಿಕ್ ಕೂತಾಗ. 20 lakhs damage award. Now, I have done the Iladi's inquiry report under section 64 of the Cooperative Society. But it is not attained finality, it is subject matter pending before this honorable court in writ jurisdiction.
Emergent notice, TCR, paper book 6 weeks. Steps in 2 days. ಬರ್ಲಿ ಅವ್ರು ಬರ್ಲಿ. ಅಡ್ಮಿಟ್ ಆಗಿದೆ ತೊಂದ್ರೆ. You have served copy to other side today only. ತೊಂದ್ರೆ ಇಲ್ಲ, ಇವತ್ತು ನೀವು ಮಾಡಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಅವ್ರು ಹುಕ್ಕುಮಂದ್ ಮಾಡ್ತಾರೆ. Counsel for the appellant who is physically present prays for a short accommodation 2 weeks time as spread is granted. Yes.
Serial number 72, my lord.
Yes.
Serial number 72, there was a direction from BBMP to file a report. Report file.
ಅದನ್ನ ನೀವು ಮಧ್ಯಾಹ್ನ ವೇಟ್ ಮಾಡ್ಬೇಕು. ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ರೀಚ್ ಆಗ್ತದೆ. ಈಗ ಅದ್ರ ಹತ್ತಿರ ಇದ್ದೇವೆ.
My lord,
ಸಬ್ಮಿಷನ್ ಕಾಸ್ಟ್ ಇತ್ತು 3,000 ರೂಪಾಯಿ ಕಟ್ಟಿದ್ದಾರೆ. ನೀವು ಅವರು ಗೊತ್ತಿಲ್ಲ ಅಲ್ವೇ? ಬಿಬಿಎಂಪಿ ಕೂಡ ದುಡ್ಡು ಕಟ್ಟುತ್ತೆ ಅನ್ನೋದಾಯ್ತು, ಬರೀ ತಗೊಳ್ಳೋದಷ್ಟೇ ಅಲ್ಲ.
The respondent does are exploring possibility of settlement. View of that fact, respondent number 1, my neighbor, the plaintiff and me, my lords, are exploring a possibility of settlement. If we can settle this matter, in view of that, my lord, we kindly grant us 1 week time.
Court, with all humbleness, asked you to wait till afternoon, till lunch, till you attempted to secure an adjournment who has no patience to appear in the court when the matter is called. This matter would be taken at the end of the list. End of the list.
ಮೂರನೇ ಮ್ಯಾಟ್ರ್ ಏನಂತ
ಅಪ್ಲೈ ಮಾಡ್ತೀವಿ ಅಂತ ನೀವು ಹೇಳಿದ್ದು ಇಲ್ಲ ಹಾಸ್ಪಿಟಲ್ಗೆ apply application for 3 6.
Yes. Also matters, set number 4. Santosh Kumar returns. Request of the concept for the appellant as well. Panel of corporation while reiterating the observation made on 2023. Panel of corporation which step is granted in selections not compared in the entirety in the time. It will matter on 26. On which day the court may proceed to file so and so and so. Yes. Number 35. Sadashivaya KG.
Presented in the morning. Here, my lord, the subject matter of the property more than 30 lakhs. My lord, therefore, my lord, subsequently after verifying the records and also the registrars, my lord, it is more than 30 lakhs. Therefore, my lord, the lies before the division bench.
No, say the value of the property is more than 30 lakhs is your submission. The registry has said to ascertain that valuation, say some relevant proof which was filed before the trial court is to be filed here.
But I on the valuations maintained by the government that has been placed because of the 2nd June, August 2004, though 6 months later to the notification issued by the government. Comes to
Mr. Counsel, this submission was made before me on the previous date of hearing, that is on 2/6 also. This court made a clear observation of hearing all these. Court made an observation. Since the office has sought for filing of some proof regarding value of the appeal, the appellant to comply the same.
I tried my level best, but I could not get. Therefore, I was forced to produce the notification itself for the convenience of the court.
You were the plaintiff. You are the plaintiff. Therefore, you must be able to produce the necessary material.
Permission of the court, I may permit it.
What is that?
This is a valuation arrived by the government of Karnataka at the time of 2004. Valuation of the property per
Guidance value. File it in the registry. Learned counsel for the appellant. Called again, learned counsel for the appellant physically present and submits that he has filed a copy of the guidance value of the immovable property as the date of the year of the institution of the original suit. And submit that registry. It is to consider the said guidance value to assess the valuation. Further submits that he accept this such document, though he is a plaintiff, he could not lay hands on any other document above the valuation of the suitable property. In the right of the above, registry to consider the said document said to have been filed today, and if serves the purpose to comply the office objection, to proceed further, if not to make its submission. Is the matter on 27/6. Yes.
Number 71. Devana
Hereby reports the death of respondent number 1. Died on 8/7/2000.
Respondent one now. What are you filing now?
Quoting the death of respondent. First respondent.
What to be done now?
Take steps to legal hearing of R1.
The counsel for the appellant physically present and files a memo reporting the death of upon attempt 8/7/2021. He also prays for 2 weeks time to do needful in this regard. Time study granted. Yes.
Yes. Vinay Kumar GS for R1.
What is the matter? The counsel from both sides present. This is the matter after 2 weeks. The interim order granted earlier and extended by 3 weeks. Yes.
What I'm seeing.
Huh.
It's explicit and clear. Before this honorable court, this honorable court said they are sufficiently cautioned. Immediately after rejection of the injunction order, they came before this honorable court. This honorable court also said it is not, suit is not maintainable. You have to go before the appropriate authority. ಹಾಗಾಗಿ ಈಗ ಇನ್ನೂ ಡಿಲೇ ಆಗ್ತದೆ. ಹಾಗಾಗಿ
ಮಾಡುವ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ನಲ್ಲಿ ಮಾಡುವ. With the matter in admission ಅಲ್ಲೇ ಇದ್ದೇನೆ ನಾನು. I have not proceed further. Yes. Yes.
Number 74.
My lord, interim order.
Interim order extend ಮಾಡಿದೇನ್ರಿ?
For R1.
membership of native is rejected without grounds.
Yes.
Please, my lord. Lord, 17/9/97, I filed an application for Bangalore Club membership, seeking permanent membership. In the year 99, on 2 occasions, they sought for, they called upon me to pay enhanced membership fees. I paid the enhanced membership fees. Now the total enhanced membership fees and the original fee comes to 90,000. Abruptly on 8/8/2009, they reject my membership without giving me an opportunity. The reasons which I could find is that I am not a graduate and I have married a person of a different caste. That cannot be a ground for rejection of the membership, is what I urged before the court. And I sought for review by way of mandatory injunction for reviewing the decision of the club to reconsider my membership. My suit is dismissed on the ground that Section 7 of the Rule 7 of the bylaw of the club does not provide for the club to reconsider. That is what the trial court considers it, and my suit is dismissed. Now, my contention is.
No, if the bylaw does not permit any review,
But it is
you
not.
could have
I understand.
filed a suit
But the bylaw does.
for
not
mandatory
specifically
injunction
say-
to grant you the membership.
Review the decision.
No, why you opted for a review?
But they
For
rejected.
which
my-
there is no provision in their bylaw.
That is what.
Generally, merely by asking review cannot be granted.
Certain. If my lord permits me to read Rule 7, Lord, it is extracted in ink page 30.
Page?
Ink page 30, internal page. 7.7, please. Lord, we get it.
Yes.
Permanent member 7.7. Each candidate for membership shall be proposed by one and seconded by 5 other permanent members, whom all of whom he or she is personally known. Every application for membership, together with prescribed entrance fee, shall be handed over to the secretary, who shall scrutinize the particulars in presence of the candidate and verify all signatures accepted by the secretary for registration. A serial number allotted to it on the application. If the application is complete in all respects, it shall allot and a receipt issued to the applicant for aforesaid fee. Simultaneously, the name of candidate shall be entered in the waiting list register for permanent members under the written advice to the computer section, which shall make necessary entry in the master date. The secretary shall publish an updated waiting list of the applicant from time to time on the club notice board in the main lawn, and this shall be in strict chronological order. All applications shall be considered only as per the published waiting list. Before the applications come up for consideration by the general committee, the secretary shall get the waiting list register initiated by the president or in his or her absence by the vice president. Secretary shall notify the candidates' names and particulars, and also the names of proposer and seconders on the aforesaid notice board for a period of 30 days before the names come up for consideration by the general committee. Objections, if any, against the candidate being considered for membership may be submitted to the secretary in writing by any permanent member during the aforesaid period of 30 days. Such objections shall be treated as privileged communications. While considering the application for membership, the general committee shall scrutinize them and satisfy themselves that they are in accordance with the waiting list and in strict chronological order. The general committee may reject the application at this stage if it considered it prudent. So, if the general committee does not reject the application at this stage, the candidate shall be called for so and so. But this is the only clause which says the general committee may reject an application at this stage if it considered it is prudent. But this is the only reason the learned judge says that I am not entitled for the decree. My submission is to consider whether it is prudent or not. There should be a procedure. They should have notified, after notifying my name and after collecting enhanced.
Mr. Counsel, assuming for a moment that the society has not applied its mind or it has not considered your application in the manner how it ought to have been considered.
Yes.
Still, number one, did you not have remedy before the other appropriate forum?
There is no appeal. Therefore, I have to not be civil.
Not even before the register of societies and
I
forums.
could not get from the bylaws, the entire bylaws. I could not get it. Appeal provision.
No, what is the nature of this dependent number one, respondent number one?
It's an unregistered club, not registered also.
Where you have mentioned it? The nature of the establishment.
My client, I only said,
Show me your plaint, please.
please. Para 3 and 4, this is what I have stated, not published.
Peacefully.
Not permits me to read one sentence in the written statement. This is what they say.
Have they filed their written
Yes,
statement?
they say it is an.
Whether all the defendants have filed their written statement or a common written
The
statement.
second defendant filed and others have adopted.
First defendant did not file.
No.
Whom you appear for? You did not file your written statement in the trial court.
Written statement is filed by the defendant number 2 president, my lord. It is represented by the club.
You have adopted that written statement.
The respondent number 2 filed a written statement.
Club is made an independent defendant. Question is very simple, whether that independent defendant has filed its written statement. If not, whether it has adopted the written statement filed by any of the other defendants.
Sorry, my apologies. Representing for the carry to respondent number 1.
What is your nature? What type of are you in society, association, company, firm,
Registered.
unregistered? ವಕೀಲರುಗಳು ಅಪಿಯರ್ ಆಗುವ ಮುಂಚೆ ಅವ್ರ ಕಕ್ಷಿದಾರದ ನೇಚರ್ ಏನು ಅಂತನಾದ್ರೂ ತಿಳ್ಕೊಂಡು ವಕಾಲತ್ ಹಾಕ್ಬೇಕು. ಏನು ಇಲ್ಲದೆ ಹಾಕೊಂಡು ಅವ್ರದ್ದು whom they are representing, what is the nature or constituency of say their client ಅನ್ನೋದು ಗೊತ್ತಿಲ್ಲದೆ ಹೋದ್ರೆ unregistered, registered, ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿ, ಮೈಕ್ರೋಫೋನ್ ಅಲ್ಲಿ ಹೇಳಿ.
Bangalore club, I am representing for the respondent number 1 is an unregistered institution, my lord.
Unregistered institution. Unregistered institution means it should come under one or the other law, right? Nimens is an institution. Judiciary is an institution. Tata Institute is an institution. A typic tutorial is an institution. A school is an institution. ಕೇಸ್ ಹಾಕಿದವರು ಹೇಳಲ್ಲ, ಕಂಟೆಸ್ಟ್ ಮಾಡೋರು ಹೇಳಲ್ಲ, ವಕಾಲತ್ ಹಾಕಿರೋ ಅಡ್ವೊಕೇಟ್ಗಳಿಗೂ ವಾಟ್ ಇಸ್ ದ ನೇಚರ್ ಆಫ್ ಮೈ ಕ್ಲೈಂಟ್ ಅನ್ನೋದು ಗೊತ್ತಿಲ್ಲ. ನೋಡ್ಕೊಂಡು ಬನ್ನಿ. Learned counsel from both sides present. Since the learned counsel from both sides are unable to submit to the court as to the nature of the respondent number 1, the matter could not be proceeded today. List the matter after 2 weeks. Yes. Client ಅವರು ವಾಪಸ್ ಕೊಟ್ಟಿದ್ರು.
75 ಶ್ರೀ ಜನಾರ್ದನ ಜಿ.
Minutes appeal. Suit for physical performance has been decreed. And it is as examination, it has been decided that she doesn't know anything about the agreement, what is the amount, who is the witness, who have signed the thing. And the learned judge gave a finding, kindly page 25. The line.
1 minute. alleged agreement was with the husband of plaintiff 1A.
But there was two agreements. 93, there was an agreement, it was not admitted. 93 for 1 lakh sale consideration, 1,50,000. So agreement, the transaction to be completed in 6 months. Right? It has not happened, it is an admitted. Thereafter, that, in the 1998, that the husband of the respondent, largely the police complaint against the appellant who is was working as an ITI officer in ITI. Some theft has been taken place to identify and take action. The police have come and has arrested him and produced the magistrate. And magistrate, when I after 2008, not after so many years, that he was been acquitted. And now pending proceedings, he says that 2005, there is when the case was going on, they are fighting, but he was got arrested. But the respondent says there is another agreement of sale agreement on 2005. But when the case was going on, criminal case, there was an occasion for them to enter.
Was he in judicial custody throughout or was he on bail?
He was on bail.
He was on bail. So he was facing a criminal trial,
Yes.
but he was at free. He was at liberty.
He was prosecuting him and making allegation against him. But 2005, they said there is an amicable settlement. It was not reported to the magistrate. Nothing has happened, but case continued. And 2005, on the basis of the same, the suit has been decreed. The learned judge says she would have been answered in a better manner, but she has not done so. That doesn't mean the preponderance of probability and so on, so on. So it will be in favor of plaintiff. But a civil suit, how it could be? But documents are there, and we have got it elicited. She said, I don't know anything about the agreement. Who has signed the agreement? I don't know. What is the sale consideration? I don't know. And who has signed the agreement? I cannot identify signatures. Right? If all these things, the learned judge says, no, it should even then it should be decided in favor of the plaintiff.
But the submission of learned counsel for the appellant who is physically present in the court, both on mission of the main IA1/23, which IA is filed under part 1 rule by read with section. There is the memorandum of judgment and claim. Let me with the result. The appellant, an applicant in India, number 23 is pending. The execution of the interim judgment and order. The appeal is by the defendant in the trial court, against whom the interim judgment and decree is possible, directing him to execute a sale deed in favor of the plaintiff with respect to the socially movable property. The indemnity is also given for the execution of the sale deed after accepting legal balance sale consideration. In that regard, the appeal has to be admitted and the applicant has shown the apprehension of execution of the impugned order. I find the reason to go, however, for a limited period. Accordingly, operation and execution of the execution judgment and decree dated so and so, passed in so and so by so and so. It stayed for a period of 8 weeks from today. Other subject to the condition of the appellant, paying the process and furnishing copies, etc. Take appropriate steps within a week from today in the registry. Issue notice to the respondents. It's made clear that not taking of the appropriate steps in completeness within a week from today would automatically deprive the benefit of today's order. 1/23 in favor of the plaintiff, in favor of the appellant. That's an issue notice to the respondent. Yes.
Yes, Nagaraju for K beta respondent number 1 to R1 to R3.
Please. Invoice of wakalat? Ah. One, two, three. ಸಂತೋಷ ಏನಾಗ್ಬೇಕು ಈಗ ಅದು? ಆಗ್ಲಿ ಸಂತೋಷ ಕುಡಿ. You have to complete office subjections. You have any submissions to be made? ಯಾರೋ ಒಬ್ರು ನೀವಿದ್ದೀರಿ ಮಾಡಿ. ನೋ ಸಬ್ಮಿಷನ್. ನಿಮ್ಮ ಕ್ಲೈಂಟ್ಗಳು ಹಣೆ ಬರ ಏನು? The counsel for the appellant and the counsel for respondent number 1 to 3 are present. For both sides. This is the previous order sheet. On the previous date of hearing, though the office objections overruled, but the same was for present. However, perusal of the office objection would go to show that before proceeding further, the appellant is required to complete all the office objections, since there are office objections with respect to the with respect to ascertaining the pecuniary jurisdiction. Okay. Therefore, the appellant is directed to complete office objection, for which 2 weeks' time as spread is granted, despite the court specifically asking in submission from the respondent side, the 11th counsel First point number 1 to 3% submits that he has no further submission to be made. Is the matter? Meanwhile, the interim order granted earlier continues for 3 weeks from today.
Submit yes. Say MB Chandrachud.
Hearing for appellant in this matter. Lords, in the last date, your lordship had directed me to file paper book minutes, leaving behind the exhibit P39, which was not obtained by us minutes. It's still not obtained by us. I have given all the documents for preparing of paper book minutes. It may take another 2-3 days for me to get the paper book.
Have filed an application for vacating the interim order.
Let it come in due course.
Excellent.
Yes.
I have filed the application for vacating the interim order.
Ah.
Will you take the list of documents I placed before the court?
No, in what way the interim order affects you?
But there is an order.
According to you, you are in possession.
Please.
And,
Status has been granted.
and the trial court has accepted that.
Construction has been halfly stopped. That is the difficulty I am facing. I was putting up the construction by the time when the suit was filed. foundation has been laid, pillars have been raised. But the stage and entry of status has been granted by the trial court. It was confirmed by the honorable court. May I request your lordship to kindly see the MFA order passed by the honorable court. A list of documents I have placed before the court. On an earlier occasion, there is a direction. May I read the order passed by the honorable court in MFA?
Where is that?
I'll put it in the list of documents. I'll put up something. Along with the application, you got a left paper. List of documents. Left ticket. Page 66.
No, 1 second. Whether these documents are the part of the trial court?
Proceeding before the trial court culminated in MFA before the honorable court by an interlocutory order. This honorable court may I read the operating portion of the interim order. Original order passed in MFA. Page 66, next R7. Kindly go to page 87.
1 minute.
In a start of status quo, I am before the honorable court in MFA. Kindly go to page 87. Till page number 22. Therefore, page 87, paragraph number 16.
Yes.
Therefore, in the above discussion, I pass the following order. All the appeals stand disposed of. The improved orders are modified. The plaintiff and the defendants are directed to maintain status quo with respect to the nature of the suit scheduled properties till the disposal of the suits. The defendants, present appellant, are directed to file an affidavit in 4 weeks from today undertaking to compensate the plaintiff for the loss that may be suffered on account of the stoppage of the construction. The affidavit shall be filed before the trial court. Pursuant to this, an affidavit has been filed before the trial court. I succeeded in the suit. Suppressing this fact, an interim order has been obtained by the honorable court. In an application filed before the honorable court, nowhere they mentioned about this interim order passed by the honorable court on earlier occasion. Simply they said in status was granted by the trial court, they granted status.
Counsel, even in this MFA also, you are not permitted to proceed with the construction.
Certainly.
Even in MFA also, both the parties are directed to maintain status quo.
Subject to rider, subject to rider.
So with a rider, in case if you succeed and he fails, he has to compensate you.
I succeeded
The
in
damages you suffer.
I succeeded in the suit.
So now we are in an appeal. We are in an appeal. Therefore, there is already an order of status quo in his favor. In his favor. So you have filed an application. Have you filed your objection to this application?
You have not filed the objection for the vacating of the stay.
You have no objection.
Happened.
I submitted in the affidavit. In the event if you succeed in the appeal by the appellant, I will not claim an equity. I give an undertaking before this court.
That will
I may be
consider.
permitted to proceed with the construction.
That will consider. When are you filing? Mr. Counsel, when you make a submission, you should make it full. Being a counsel, you have some responsibility towards the court. You cannot stand simply quiet, telling that say everything court would take care of. Learned counsel is making submission, reading some order. He has made an application, IA. He is repeatedly telling that I have filed an interlocutory application seeking vacating of the stay. You are not opening your mouth whether you have got any objection to be filed, or if you are filing any objection, do you require any time to file objection? Nothing. The court should ask you every sentence. You have an objection? Yes, I have. You intend to file statement of objection? Yes, I intend to. Then the court should ask you, do you want time to file objection? What do you think a court is about? Take down.
In 2 weeks, I'll file my objections as
The
well.
learned counsel from both sides present. ನಿಮಗೆ ಇದು ಒಂದು ಕೇಸ್ ಹೋಗಿಲ್ರೆ 100 ಕೇಸಲ್ಲಿ ಬೆಳಗಿಂದ ಸಂಜೆವರೆಗೆ ಇಂಥದನ್ನ ನೋಡಿ ಒಂದು ಬೇಸಿಕ್ ಮಿನಿಮಮ್ ವಾಟ್ ಈಸ್ ಅಡ್ವೊಕೇಸಿ, ವಾಟ್ ಟು ಬಿ ಟೋಲ್ಡ್, ಹೌ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಟೋಲ್ಡ್ ಅಂಥದ್ರ ಬಗ್ಗೆಯೂ ಗಮನ ಕೊಡೋದ್ರಲ್ಲಿ ಕ್ಯಾಶುವಲ್ ಆಗಿ ಹೋಗೋದು ನೋಡಿದ್ರೆ ಬೇಜಾರು ಅನ್ಸಲ್ವೇ? ಅಲ್ಲೇ ಕ್ವಾಲಿಟಿ ಚೆನ್ನಾಗಿದ್ರೆ ನಮ್ ಕ್ವಾಲಿಟಿ ಚೆನ್ನಾಗಿರ್ತದೆ. The learned counsel for the respondent insists for hearing on IA 2 of 2023 filed by the respondent seeking vacating of the interim order dated 13/2/2023. He further submits that the application was filed on 2/3/2023 and on the same day the copy was served on the other side. The learned counsel for the appellant does not make any submission as to whether he has got any objection to be filed or not. When the court specifically asked him as to whether he has got any objection to be filed to the said application, he submits that he has. Despite that, he doesn't even pray for time to file objection. When the appellant themselves are not evincing any interest in praying for time to file objection and not coming forward to file an objection to the said IA, there is no point in granting further time. Accordingly, it is taken that objections are not filed to IA 2/2023. This is the matter in the week after next to hear on the IA 2 of 2023. Yes. Not extended. Yes.
When a hearing matters, case number 78, Sri Sidmalappa PM, Bhaskaraju HJ, correspondent.
Wow.
You move for an adjournment this morning. The learned counsel for the appellant alone is present. Learned counsel for the respondent neither present physically nor through video conference. As a matter, did not be proceeded today. Called again. Yes. Number 79, Sri S.V. Giridhar. S.V. Bhatt for R1A. For Bhaling, not person. The council for responding. Arun is present. Hence the matter could not be proceeded today. Yes. For R1A to see Nagaya, correspondent. Yes.
Yeah, after tomorrow, my lordship, my seniors not keeping well today. I need tomorrow. We are ready to argue the matter, but seniors some pasta in front. I need tomorrow.
The council from booth is present. Council for the respondent stating the reason of medical inconvenience press for the short accommodation. And finally, a week's time is granted. Yes. Serial number 81, Sri Dilip Kumar, V.S. Nagaraj for Kevita respondent.
Last occasion, my friend was taken adjournment to study more, investigate the question of law, whether the signature is required on each page of this agreement or not. Your lordship was put the question. What is the law? And any rulings of this world, signature of the agreement, each page is required. And the friend has taken time. Issues to
Counsel for the appellant not present. Counsel for The respondent gave it. Yes.
Last occasion. Lots of these to ask you the question regarding the signature. There only one sheet of 4 sheets of the agreement per se, which is the agreement in issue in this. What was the agreement on the basis of which specific performance was sought very like. The question was when there is only one signature on one sheet of paper. Attention of the defendant was that she did not know the contents of the document. She had signed. She had signed under the impression that she has taken a loan of 2 lakh rupees in total. From the respondent hearing and one of her uncles, one Shiv Shankar.
Yes. Yes.
The document is purchased as a bond. Both the two separate sheets are amalgamated together. Both of them are taken up as bonds on 7th of August. Under
From
article,
where do you get the bonds?
there in each stamp, first sheet of the stamp,
Below that bond, what is written?
agreement is written. We draw and what's it?
No, you should draw in its entirety, not the selective portions.
Bond, it was an agreement of sale, right? It is covered in separate item in the list of the stamp act.
No, repeat that, I couldn't follow you. If it were to be,
Agreement of sale.
ah,
It would be under a different article of the stamp act. A bond is under.
ah,
article 12.
hmm,
Which is the bond.
hmm.
It's an agreement of sale. It would be under Article 5. The stamp act. So clause 1 of Article 5. Be what would cover. It's a plus 1. Seven.
Neutral, sir. Neutral color. कोई article. Read that article.
Relating to sale of new properties where part of properties. First, one of E is where possession is delivered. Second, small. Possession of the property is not delivered. 10 paise for every 100 rupees or part thereof, the market value equal to the amount of consideration, subject to a maximum rupees 20,000, but not less than rupees 5.
That is so far as the stamp duty is concerned. Stamp duty is concerned. Probably that has got nothing to do with these descriptions. You should convince the court as to, according to this e-stamp concept, what these left side column denotes. Because it has got a replica, description of a document and a description. What is the difference between those two?
7 also mandates. So then, with respect to purchase of stamp papers under e-stamp, specific reason why the stamp paper is being purchased is what is asked for, and that is why we fill in a separate column. And this is the reason why the stamp paper is being purchased. Unlike the earlier time, not only the stamp paper was taken and the description of the document could be entered in later at some point of time. Now, under the e-stamp provision, the reason why it is being purchased is mentioned at the initial stage itself. And the article under which it is being purchased, whether it is an agreement of bond or indemnity bond, whatever it is, under the numerous classification under the schedule stamp is mentioned there. The presumption would always be it has been taken for that set purpose.
It is true, Mr. Consi. I am not on that point. That is fine. That is the objective. Point is, had it been shown as bond only, nothing more than that, it stops showing it as bond, then fine. Your concept, there is a difference between a bond and agreement, and the agreement of sale won't come under the concept of bond, etc. could have been heard at full length and his answer to that. But the very same agreement at Exhibit P1, beneath the word Article 12 bond, in bold, in capitals, mentions as agreement. The description as agreement. So what is the difference between description of document and a description? A guideline should be there for issuing authority. How to fill these left side details, the questions, because it is a standard format in all e-stamping. All these left side column would be there. Right side they have to fill. Right side also they will customize it. So far as the certificate number, issued date, etc., automatically that will be generated. Only they have to enter the description of document and description. More particularly the description. So how to fill the guidelines is there, or what these denotes a guidelines is there, then the court would be at ease to understand that for any agreement of say to validate any e-stamp paper, it shall not show that it is under Article 12 as a bond. It shall be shown under Article 5 agreement. Here is no such case. You have not convinced me as to what this left side column denotes and how they have to be filled. There ought to be some circular issued by the competent authority, maybe the authority under Karnataka Stamp Act, who has issued this model for e-stamping, as to what this column denotes and how they are required to be filled. That answers your doubt, or the court's doubt rather. Reason is that it also shows as agreement in bold letter. What is the purpose? Probably it can also be argued well that the purpose for which the stamp paper was purchased is denoted by that row description. There the stamp issuing authority writes. If he writes agreement, agreement, sale deed, affidavit, affidavit. So what purpose the stamp paper is issued or sold? That is the description. That argument also can be addressed, and that sounds to be more probable. ಅಲ್ಲ ರೀ, ಇಲ್ಲಿ ಬಲಗಡೆದು ಬರೀತಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅದಕ್ಕೊಂದು ಗೈಡ್ಲೈನ್ಸ್ ಬೇಕಲ್ವೇ, ತಿಳುವಳಿಕೆ ಬೇಕಲ್ವೇ? ಬೇರೆ ಏನ್ ಹಿಂದೆ ಹೋದ್ರು ಇದು ಯಾರು ಸ್ಟಾಂಪ್ ಪೇಪರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ, ಆ ಸ್ಟಾಂಪ್ ಪೇಪರ್ ಇಶ್ಯೂ ಮಾಡಿರ್ತಕ್ಕಂತಹ ಸೊಸೈಟಿ, ಅಸೋಸಿಯೇಷನ್, ಫರ್ಮು ಅವರಲ್ಲೇ ಒಂದು ಗೈಡ್ಲೈನ್ಸ್ ಇರ್ತದೆ, ಯಾವ ಕಾಲಂನಲ್ಲಿ ಏನ್ ಫಿಲಪ್ ಮಾಡಬೇಕು. ಈಗ ಯಾವುದು ಇಲ್ಲದೆ ಬರೀ ಒಂದೇ ಇದ್ದಿದ್ರೆ ಆರ್ಟಿಕಲ್ 12 ಬಾಂಡ್ ಅಂತಿದ್ರೆ ನಿಮ್ಮ ಪ್ರಕಾರ a bond is different from an agreement. Therefore, the very stamp paper was issued for the purpose of a bond, and the content of that particular document is not a bond. Antadre, now next question ಏನಇದೆ ಅದಕ್ಕೆ ಹೋಗಬಹುದು. ಆದರೆ ಇಲ್ಲಿ I am repeating it for 4th time. Apart from showing that Article 12 bond, what you read, the court noticed that beneath that, as against the row description in capitals, it is shown as agreement.
What is agreement? Would encompass only an agreement of bond, or it would encompass any other agreement other than that of a bond?
No, I did not use the word agreement of bond. You are coining a new word, agreement of bond.
Because the definition of bond, bond is an agreement, obligation, or a contract to pay a certain amount of money on the happening of certain contingent events. My book has got one of the citations with respect to that of Justice Chandrasekhar Gordon in that.
No, you refer to the book and the section of the authority.
This is an explanation which is given in the book, my lord. I will get the original citation itself. The definition of bond will not be. But this is what I am reading, which is extracted from ILR. And my pardons, my lord. From ILR 1984, second volume of KR 1003 from page number. Definition is extracted. Bond is an obligation, a contract, an agreement to pay money or to do something. Generally accepted definition of bond is that it is a certificate or evidence of a debt. I place the full citation before my talk.
Mr. Counsel, you need not look for that citation. The very definition of bond says so. The very definition of bond says so.
Pay money, happening of certain things, it also be still be an agreement. It's not an agreement of sale. It is an agreement to pay a certain amount of money, discharge the debt. Different types of agreements are not covered under different clauses of the Stamp Act. An agreement of sale is specifically provided under 5E. Without possession is small.
My question to you is, if that were to be the case, do we mean to say that the stamp issuing authority, if the party, the purchaser of the stamp paper goes and asks the vendor of the stamp paper that I intend to enter into an agreement, give me a stamp paper worth ₹200 rupees. Then is it obligatory on the part of the vendor of the stamp to ascertain as to what is the nature of that agreement? And if it is an agreement to pay money, you used that phrase, agreement to pay money comes under bond, subject to what he submits and subject to acceptability of that interpretation. Is it obligatory in the part of the vendor of the e-stamp paper to ascertain as to what that agreement is for? If the purchaser of the stamp paper says, I want to purchase a property, immovable property, for that I want to enter an agreement, then is it obligatory on the part of, or is it mandatory on the part of the vendor of the stamp to show Article 5(1) in the row description of document and then issue stamp paper? Number one. Number two, assuming for a moment, the description of the document shows it as Article 12 bond, but the contents typed in that stamp paper later on, subsequently, is not a bond, but it is an agreement for sale of an immovable property. Whether that by itself invalidates the agreement. These two questions, answer one by one.
First one, when we apply for stamp, it is mandatory for us to fill in a form which has got a specific provision.
Yes.
We mentioned
Hmm.
the reason why this has been purchased,
Hmm.
the article under which this is covered.
Article the purchaser need not mention.
It's the application.
Purchase, the purpose of purchase.
Then when the stamp paper is issued by the issuing authority, mandatory contains the article under which this is being purchased. But if I were to say this is an agreement of sale, it could be under Article 5.
Who has purchased this stamp paper?
This is purchased by one Shiv Shankar, because both the cases contains this. Here evidence they say PW2.
No, what is the plaintiff's case? According to plaintiff, who has purchased this stamp?
According to the plaintiff, the defendant has purchased the stamp paper.
Defendant has purchased the stamp paper. That is you.
Yes, I have purchased the stamp paper.
Have you admitted that it is you who have purchased the stamp paper? No. According to you, who purchased the stamp paper?
Yes, purchased by one Shiv Shankar, the uncle of the plaintiff here in the matter. And one of the witnesses in their testimony says that Shiv Shankar purchased this because in sequence in both there are another suit filed by Shiv Shankar. The same dated timed paper is used for an agreement of sale there, which is also a part of one of the exhibits here in this case. With respect to that, my lord, evidence of PW2, he says that Shiv Shankar purchased this. PW3, my lord, and evidence.
No, is it required for the vendor of the stamp paper to mention in this stamp paper the name of the purchaser?
It is mentioned in the stamp paper of who has purchased this, my lord. But it depends upon what is filled up in the form, and he does not verify the credentials or the identity of the purchasing who is purchasing this paper. If I were to go and say I am purchasing this paper in the name of X, then the paper will be issued in the name of person X, son of such. He does not verify the identity. He does not verify the. He does not look into any document of identification or whether the said person has purchased. He only mentions what is filled up in the form. It's transcribed into the computer, and the computer prints out the details as in the form which is presented to him for transcribing. It is that form which will contain the
reason why the paper is also found. Respect to the
Your defense was that it was a loan agreement. Thinking that it was a loan agreement, you
side two black pieces of paper, one of which is used in this suit, other is used in a separate suit, which is also marked as an exhibit. Total loan amount is 2 lakhs.
then it is not your case that the first paper of the stamp paper, the first sheet of the stamp paper, in its description, had mentioned as bond for money, right?
She has signed 2 papers, blank portions of papers. One of which is to produce here and converted into an agreement. She says she has never entered into an agreement for sale of this land. She has never, and consequently, the other paper which is unsigned and is attached, this paper, is something which she has no knowledge about until this was presented as evidence in this court. That is the reason I pointed out last time. I got was pleased to say, because of this, the nature of the case of this type, there is one signature, then totality of the circumstances should have been seen. And that is the reason the Lord said.
No, last time the matter was stopped at a juncture that you said each page is not signed. The court asked you a question. Can you show me or can you convince the court that in a document which runs into few number of pages, more than one page, that each page is mandatory to be signed by the executants? Stating that you do some research, you sought for time.
Again, we have been with respect to that. Either way, there is no judgment which says that in a case where the other pages are not signed, it can be still relied upon as evidencing the consent of the party to the entire agreement. Standing alone, my lord was pleased to say something. Then we have to look at the entire totality of the circumstances. That is what all the courts have considered, my lord. But with respect to the specific question, what happens in a case where one of the pages is not signed or a group of pages have not been signed, and only the last page has been signed, and the intention of the party of what she claims is that she has never seen this, never agreed to it, there is no proof of such consent. Then, Lord, it is my argument that we can.
No,
there is no judgment.
What had asked you to submit in the first beginning about the requirement of law, the convenience and the possibilities, the other aspect, the requirement of law, whether law requires that each page must be signed by the executant in a document like alleged agreement of sale.
But the expertise is not what I have taken to something exhaustively. Even some arcane books, old ones, even judgments from the Allahabad High Court, we have not found a case either way, either categorically holding that it can be relied upon, or categorically holding that it cannot be relied upon.
No, was it not required of you that before going in search for a judgment, first know the requirement of law, what the law is about execution of a document?
Contract Act. That is what.
Whether the Contract Act speaks about execution or
Does not.
in which section, what it says.
Seventh is with respect to acceptance must be absolute. Then is what agreements are contract.
That is what agreements are contract. Here the question is,
Whether there was.
what is an execution?
There should be a consent of the parties.
Yes, concurrence of mind, consciousness addendum, meeting of mind. Yes,
That consent has been divided into section 13 of the.
counsel, you are not answering my question. Consciousness addendum, consent. What is consent? Everything is fine. Your contention is that you have not executed that document as shown at exhibit P1. Exhibit P1 is not my document, is your basic contention. If that were to be your contention, how do you convince the court that exhibit P1 is not your document? Your first question is that first submission on the previous date and today is also that sheet number 1 in exhibit P1 was replaced or it was substituted by the plaintiff with some other document for which you are never a party. Never a party. You have not denied that the second sheet, page number 3, bears your signature. Therefore, when that document contains 3 pages in 2 sheets, the last page admittedly bears your signature. Is it mandatory that that document, considering its nature of the document, was required to be signed by executants of document on each page? What is the law about that? Contract Act, you said Contract Act does not speak according to me about what is execution.
Specific aspect of an agreement of sale. What's going to write? What's going to hold? That would be the precedent of this court, but also all courts.
ಬೇಕಾದಷ್ಟಿದೆ ಇದರಲ್ಲಿ
Sources.
ನೀವು ಹುಡುಕದ್ ಕಡಿಮೆ ಮಾಡಿದ್ದೀರಿ, ಹುಡುಕಿದ್ರೆ ಸಿಕ್ಕುತ್ತೆ.
Also, with respect to that, again, with respect, reason why we pointed out this is a bond and the amount is to stand before the case. Some mandates that a document can be executed only or until the value for which the stamp paper has been purchased. If the bond is for paper has been purchased for an amount of
200 rupees.
200 rupees. Even if you were 200 rupees is what, even if you were to take the second sheet, my lord, that would be another 100 rupees. The signature is on a paper which is valued at 100. First sheet is valued at 200. Both of them are stamp papers, my lord. It was to be a one single agreement being taken for 300 rupees. They would have pointed out 300 rupees and the vendor would have issued a paper for 300 rupees. And it was an agreement for 10 lakhs or 12 lakhs is valued at 0.1% of the amount for which the agreement is to be made. And that is the upper limit for which a document can be executed. As per section 27, because that is subject to other portions. It says that involving intention of the parties would be. If it was a bond, not cover the value of the loan that has been given. Signed paper is for 100 rupees. The additional sheet, that is the first and second page, which is unsigned, is for 200 rupees.
Yes.
7 of the chapter.
Yes.
That the amount or value of the subject matter of any instrument chargeable with an advertisement duty cannot be or could not have consulted with the database. It shall be claimable under such instrument more than the highest amount or value for which, if stated in an instrument of the same description, the stamp act actually used would be as on the date of the provided the exemptions are there. Second proviso contains the following provisions.
Yes.
Was the totality of the circumstances which we considered. The intention of the parties was to take this as an agreement for a loan for a debt. And the highest value of that paper was 100 rupees. Not having the intention of the parties to use this as an agreement of sale. Is termed as a bond, an agreement to repay a certain amount of money. The amount for which it has been taken is also not considered with an agreement.
Yes.
That is 42,000. It would have required a paper of around 1,242.
Yes.
Whereas if it was for a loan of 2 lakhs or less, it would have been only 0.5% of the 0.05 of this 50 paise for every 100 rupees. It would be sufficient for the execution of the bond or repayment of agreement for repayment of money.
What would be the stamp according to you for a loan of rupees 2 lakh?
For loan of 2 lakh rupees, 50 paise for every 100 rupees of part thereof. Where it exceeds 1,000, for the first 1,000 rupees, same duty as A, that is subclass A is 50 paise, that is 0.5%. Where it exceeds rupees 500 or part in excess of 1,000, same duty as in A, that is 0.5%.
How much it comes for 2 lakh?
be 0.5% would be 1,000 rupees. Lakhs, 1% would be 2,000. Just doing it. If I say for every 100 rupees would be 0.5%. That would be 1,000 rupees for a 2 lakh rupees.
If according to you, if it is 1,000 rupees, then even according to you, the stamp was paid only rupees 100. 100. Therefore, your contention that it was a loan agreement for the repayment of the loan of rupees 2 lakh also falsifies. On your own logic, the same logic is applied for your contention, the defense taken in written statement. It would not hold good.
Point out the facts which are relevant. That is.
Argument madlikkiದ್ದೀರಿ. I can only point out the facts relevant and tell why should I do your homework? ನೀವೇ ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಪಾಯಿಂಟ್ ಎತ್ತಿದ್ರಿ, ಅದಕ್ಕೆ ಒಂದು ಲಾಜಿಕ್ ಕೊಟ್ರಿ, ಅದೇ ಲಾಜಿಕ್ ನಿಮ್ಮ ಡಿಫೆನ್ಸ್ಗೆ ನಾನು ಅಪ್ಲೈ ಮಾಡಿ ತೋರಿಸ್ತಿದ್ದೇನೆ.
My only contention would be this. First to be an agreement of stamp paper valued at 12 lakh. Then valuation with respect to stamp fee should have been under 5E1 should have been 0.1%. Under 27 lot, I would only tell us that the paper would not have been used for execution of an agreement, which is in excess of the said amount for which the stamp paper has been purchased.
Even for alleged agreement of repayment of the loan, also the stamp becomes deficit. According to you, then, if the same logic is applied, neither it can be an agreement of sale, nor it can be an agreement of loan. If you take the alleged requirement of the stamp duty, the amount of the stamp paid or payable as the criteria to decide the nature of the document, either way it won't hold good according to your argument. Therefore, when your argument that the alleged deficit stamp duty prevents one from accepting that it is an agreement of sale, then it is highly unsafe to accept the contention that it should have been an agreement of loan. For the simple reason, the document claiming it to be in its entirety in 2 sheets have been produced as an exhibit, describing it as an agreement of sale. The burden of proving that the said document is not in its entirety, the document was different. There existed a document, but that document was different. He is upon the person who contends that. Because according to the plaintiff, there is no second document. There is only one document, that is agreement of sale. He has produced that document as exhibit P1. Then the party who contends that this is not the original documents in its entirety, it is tampered or manipulated in particular manner, the original document was in a different type, then onus shifts upon him. Have you discharged that onus? onus shifts upon the defendant who contends that the document relied upon by the plaintiff is not the original documents in its entirety. It is manipulated. There is a different document called agreement of loan, for which I am the signatory. In such an event, the onus lies upon that person that this document is not the one, there is another document. Because it is you who are contending that who are contending about the existence of another document of a different nomenclature and a different nature.
Statement. Defendant is that she signs 2 sheets of blank paper. Papers on which the signature is put is blank. The reverse side is stamp paper. But where the signature is put is both the sheets are blank papers. And that she has availed of a loan of 2 lakh rupees from one Shiv Shankar. They have bifurcated this into 1,25,000, another 75,000. And that advance amount of 1,25,000 which is claimed here is part of this loan of 2 lakh rupees which was availed from Shiv Shankar. That is the sum of the case of the defendant.
According to you, one of the party to the agreement was one Shiv Shankar, agreement of loan. Right? Written statements put over. 6 ಗಂಟೆನ ಬಹಳ ಪ್ರಿಸೈಸ್ ಆಗಿ ಬಹಳ ಸಿಸ್ಟಮೆಟಿಕ್ ಆಗಿ ಪಾಯಿಂಟ್ ವೈಸ್ ಮಾಡಬಹುದು. ಅಲ್ಲಿ ಇಲ್ಲಿ ಗಾಳಿಪಟ ಹಾರಿದಾಗೆ ತಗೊಂಡು ಹೋಗ್ತಾ ಇದ್ದೀರಿ. ನಾನು ಈ ಕಡೆ ಹಿಡಿದ್ರೆ ಬಾಲಂಗೂಸಿ ಪಟ ಈ ಕಡೆ ತಿರುಗ್ತದೆ, ನಾನು ಪಟ ಈ ಕಡೆ ಹಿಡಿದ್ರೆ ಅದು ಈ ಕಡೆ ಗೋತಾ ಹೊಡಿತದೆ. ಏನ್ ಮಾಡ್ಲಿ? ಗೋತಾ ಹೊಡೆಯುವುದು ಪದ ಕೇಳಿದ್ದೀರಾ ಕನ್ನಡದಲ್ಲಿ? ಗಾಳಿಪಟ ಹಾರಿಸೋದ್ರಲ್ಲಿ ಬರ್ತದೆ. ನೋಡಿದೆ, ಅದು ಎಲ್ಲ ಓಡ್ಕೊಂಡು ಬಂದಿರ್ತಾವ. ಹೇಳಿ, ನಾನು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಒರಿಜಿನಲ್ ನೋಡ್ತಿದ್ದೇನೆ. Is it not a reading of your written statement gives an impression that in favor of the plaintiff, you have signed only one paper, not two papers? Your written statement, paragraph number 3.
Is one paper. 2 of them are signed and she agrees. The other one is used in a different code. Why is it not? 452 filed by Shiv Shankar. They are 1 minute apart. Purchases are 1 minute apart.
Is it not that a reading of paragraph 3 of the written statement gives an impression that you have taken a contention that in favor of a plaintiff, you have signed one paper?
Plural is not used in the paragraph 3, I would concede. But in paragraph 5, it says papers.
Yes, maybe. On blank stamp papers,
Two papers are in existence.
two papers, but in favor of plaintiff, one paper.
Paper.
In favor of Shiv Kumar, another paper. That means you have executed, according to you, if a written statement is accepted, according to you, you have executed two stamp papers. According to you, as per paragraph number, making use of those blank stamp papers, exhibit P1 is created. But you yourself has, in the beginning itself, made clear that among those two blank papers, that have been signed by you, one paper was in favor of plaintiff hearing. Another paper was in favor of Shiv Kumar.
Doesn't know how it is. It has been used after it has been marked in the exhibits. She has come to know that it has been used by the plaintiff in this case. One of them has been used by the plaintiff in this case. The second one has been used by the plaintiff in the other case. That is back to law.
Read paragraph number 3 loudly, please. Slowly.
First dependent subjects. From 7/8/2014, she borrowed a sum of rupees 1,25,000 to answer legal necessities at that point of time. The plaintiff took signature of the first dependent on blank stamp paper with a promise to return the same on repayment of loan amount to the plaintiff.
Stop here. 1 minute. On 7/8/2014, you borrowed 1,25,000 rupees from the plaintiff, Srimati Sheila. At that time, plaintiff took signature of yours on a blank stamp paper with a promise to return the same on repayment of the loan to her. That means, in favor of plaintiff, on 7/8/2014, you have signed and executed only one stamp paper. One stamp paper. Read next.
The like manner for having borrowed rupees 75,000 from A.S. Shivshankar. The plaintiff in OS number 452/2014 also took the signature of first dependent on blank stamp paper with a promise to return the papers on repayment of loan amount with interest on the amount borrowed from the plaintiff and A.S. Shivshankar.
Yes. We have not mentioned on which day you have signed the stamp paper in favor of Shivshankar. Shivshankar. So, paragraph number 3 does not specifically and clearly say whether signing the alleged two blank stamp paper was on the same day or on different days. Number 2, even according to you, one was given in favor of plaintiff, another was given in favor of Shiv Kumar. Therefore, why can't it be deduced that in favor of plaintiff, you have made only one signature, and that is page 3 of exhibit P1. Naturally, page number 1 and 2 in such a circumstance does not bear your signature.
OS number 4 is mentioned here. The agreement of sale respect to adjoint figure of property is before the court. There, the date is on the very same day, and the execution is on the same day. And the evidence of PW3, my lord, is that Shivshankar was present at the time when these documents were placed. OS 452, my lord. The agreement is dated the same day.
Sir, what is there before us in this record we have to read?
That That is a part of before the court, as exhibit. Three. Exhibit D3.
Yes.
The first two sheets are not signed. Fourth page of this site. Same date. Also, even the purchase of the stamp paper is on the PW3 says Shiv Shankar has brought this document. Papers were brought by him. Shiv Shankar is a person who regularly he says he comes to me regularly. Comes and I have executed other documents for Shiv Shankar. And also, Shiv Shankar files a criminal case against the defendant. They have only mentioned this in the line. The document is not another copy. The records were not there in India. Yet he claims that she is cheating him out of 2 lakh rupees. He files a complaint for 2 lakhs. Use this.
Who is Shiv Shankar?
Is the uncle of the plaintiff here.
Uncle of the plaintiff. Who has filed a criminal case against whom?
Shankar files a criminal case against the defendant.
Alleging what?
That she is cheating, that she has taken an amount of 2 lakh rupees in order saying that she is going to sell this property. And that she is now cheating us out of this property by eliminating this property to some others for a lesser amount.
No, I cannot see that unless they are the part of the record. Yes.
That is why I did not. There is a mention in the plain that a criminal case has been filed. And after that, there is no further discussion. This culminated later on with a report being filed by the police. Subsequently, what happened? We tried to find out the records were not available. So the previous one which had been taken, copies had been taken.
How that will help you?
No, the intention of the parties. This, when it is picked by lot, sometimes the question is asked, did you take 1,25,000 rupees from the plaintiff? She answers yes. Did you take 2 lakh rupees from Shiv Shankar? She says yes. And the bifurcation which has been made of this amount, 2 different cases, she does not dispute that she has taken 2 lakhs. How it has been distributed, if a reading of the plaintiff is to be taken and the reading of the
Yes.
Cross-examination lists that you've taken 125 from the plaintiff. That is what the court says. Because the defendant is not sure and she has been favored with respect to saying whom she has taken the money from, then we have to hold that she has taken money from the plaintiff. That has been the contention of this. These are rural people, you know. Postal pleadings sometimes not be very exact or very specific. Sometimes the parties have got an understanding of what they have received. How it is bifurcated in documents, these are illiterate people. She has been categorically stating that she does not know what is the nature of the stamp paper, which is she only knows she has signed. She says she has taken 2 lakh rupees. And it has been bifurcated between the two of them, the relations. And the other party, that is Shiv Shankar, he treats the loan as one single item. Files the complaint.
Probably they are not much relevant for this appeal. Not relevant for this appeal. Based upon what the evidence here, both oral and documentary, and the point of law involved, will you conclude your argument? So one major question that was posed to you, that to show before the court or convince the court that in an agreement of sale of an immovable property, the law requires the signature of the executant and each page of the agreement has not been answered by you. So that has remained. The same question is also there to him. Let him also show the position of law. Either of you should show the position of law. For you, yes, the law requires. Whether you show it or not, for him, there is no obligation or there is no requirement under law that each page is required to be necessarily signed. I will go by your argument and how acceptable, to what extent the same can be acceptable or entertained. His argument, I will also apply the same scale, will analyze. Yes, proceed further.
Burden, my lord, of proving a document has been executed with knowledge and consent, relying on the person, relying on that document.
True.
Defendant's categorical case, she has not seen this document, seen the first 2 portions of the case. It was never an intention to sell the property. She has obtained a loan. She is duty bound to return the loan. That is the contentions that has been taken to defendant. The attached page, there's no signature. Nothing can be deduced from such a document to say that there was knowledge with respect to these contents or regarding the agreement of sale with the defendant at the point of execution. There is no wavering on her part that she has signed a blank sheet of paper. And she says that she has, there is another suit in which another piece of such paper has been also used. And she says she has taken a loan. The only reason the court holds would be, you have said you have obtained a loan from the plaintiff. You have said that you have obtained a loan from Shiv Shankar. The conclusion regarding the bifurcation of the 2 lakh rupees which has been taken into 2 agreements, which is not to the knowledge of the defendant, is lost sight of it. The very fact that this has been bifurcated is not to the knowledge of the defendant. Only after these documents have come before the court, they know that this has been divided into 2. The 2 lakh rupees has been bifurcated into 2, and 2 agreements have been drawn based upon that.
Counsel, for nth time you are reiterating the same point. Yes. That is the alleged fact according to you.
About the reading.
In the argument, you are required to convince the court that the alleged fact canvassed by him has not been proved by him. There was something sharp for its proof. And If the trial court has an error in appreciating the evidence or deducing certain inferences from the available evidence, where it has erred and in what manner? That is it. Merely because you repeatedly telling that she executed 2 blank stamp paper, they have manipulated the thing, they substituted the sheet number 1 with that, they wrote what they feel like. Yes, that is what your client has stated before you while drafting the pleading for the client, the written statement. But while demolishing the case of the plaintiff or seeing that the plaintiff is unable to make out a case on preponderance of probabilities, what your defense is, you should at least make it to move a step ahead of what a mere pleading is. That direction, what you have done. Argument is not just repeating the pleading of the parties. Pleading is this. Proof is here. This proof have proven the pleading in all probabilities. Therefore, judgment is right or not right.
The court, Your Honor, does not enter into a discussion with respect to the validity of the document itself and how it has come to the conclusion that an unsigned document can be relied upon to show consent of the parties.
Exactly. Once again, you are going to the square one. Unsigned document. The trial court did not discuss as to how can it rely upon unsigned document. That is the reason on the previous occasion today in the opening sentence, repeatedly, the court is asking you, show me that the document request to be signed on each page. Because you are repeatedly using unsigned document. Document is signed at that particular portion where it is shown as this document is executed by executant. You have admitted your signature in that document as executant. Then how can you say unsigned document? It is unsigned in page number 1 and 2. But concluding portion, by whatever ending recital it has got, on this day both parties have joined their hand as executed, or thus we executed, or thus we signed. By whatever Mangalam it ends with, it bears the signatures of both the parties to the agreement. Both the parties are shown to have signed that. In such a case, how you repeatedly use the word unsigned document, that is the reason I am telling. Mere telling is different, proving is different. 2 signatures are there. This is the last concluding portion of the document. You have admitted your signature here. In such a case, how can you call this as unsigned document? This is the last page of the document.
Constitute one single document. It is necessary for the plaintiff to prove that they were always read as one together. 2 pieces merely because they have been stapled together or stitched together would not make one document. That is our contention. And there is no proof that the other portion of the document, the sheet of paper which is unsigned, was ever shown, was ever to the knowledge, or ever touched by the defendant.
By reading exhibit P1 in its entirety, page 1, 2, and 3, in continuously, does it impart any doubt in the mind of the reader that the recitals and contents in page number 1, 2 has got no connection with the recital in page number 3? In such a case, a doubt would arise. Page number 1 and 3 ಅಲ್ಲಿ ರಾಮಪ್ಪನು ಹೋಗುತ್ತಿರುವಾಗೆ ಸೂರ್ಯನು ಪ್ರಕಾಶಮಾನವಾಗಿದ್ದ, ಬಿಸಿಲು ಅತ್ಯಧಿಕವಾಗಿತ್ತು, ರಾಮಣ್ಣನಿಗೆ ಛತ್ರಿ ಬೇಕು ಎನಿಸಿದ್ರು ಆತನ ಬಳಿ ಇರಲಿಲ್ಲ, ತಂಪು ಕನ್ನಡಕವೂ ಇರಲಿಲ್ಲ, ಆದರೂ ಆತ ನಡೆದುಕೊಂಡು ಹೋದ. 10 ನಿಮಿಷದಲ್ಲಿ ಗಮ್ಯಸ್ಥಾನವನ್ನು ತಲುಪಿದ. ಎಂಡ್ಸ್ ದೇರ್. ನೆಕ್ಸ್ಟ್ ಪೇಜ್. ಗಮ್ಯಸ್ಥಾನವನ್ನು ತಲುಪಿದ ತಕ್ಷಣವೇ ರಾಮಣ್ಣನಿಗೆ ಸದರಿ ವ್ಯಕ್ತಿಯು ಎದುರಾದನು, ಮೃತನು ಎದುರಾದನು. ಆ ಕತ್ತಲಿನಲ್ಲಿಯೂ ಕೂಡ ರಾಮಣ್ಣನು ಮೃತ ವ್ಯಕ್ತಿಯ ಗುರುತನ್ನು ಹಿಡಿದನು, ಏಕೆಂದರೆ ಆತ ರಾಮಣ್ಣನಿಗೆ ಪರಿಚಯವಿದ್ದ ವ್ಯಕ್ತಿಯೇ ಆಗಿದ್ದನು. ಕೂಡಲೇ ರಾಮಣ್ಣನು ತಡಕಾಡಿ ಕತ್ತಲಲ್ಲಿ ಸಿಕ್ಕ ಒಂದು ಕಲ್ಲನ್ನು ಎತ್ತಿ ಆ ವ್ಯಕ್ತಿಗೆ ಬೀಸಿ ಒಗೆದಾಗ ಆತನ ತಲೆಗೆ ತಾಗಿ ಬುರುಡೆಯು ಒಡೆದು ಬಿದ್ದು ಆತ ಅಲ್ಲಿಯೇ ಮೃತಪಟ್ಟನು. ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ರಿಸೈಟಲ್ ಇದೆ, ಪೇಜ್ ನಂಬರ್ 1, ಪೇಜ್ ನಂಬರ್ 2. ಇದಿಷ್ಟು ಡಾಕ್ಯುಮೆಂಟ್ ಓದಿದಾಗ, ಪೇಜ್ ನಂಬರ್ 1 ಓದಿದಾಗ ಓದಿಗರಿಗೆ ಗೊತ್ತಾಗ್ತದೆ, ರಾಮಣ್ಣ ಹೋದ ಮಠ ಮಧ್ಯಾಹ್ನ, ಸುಡು ಬಿಸಿಲು, ಸೂರ್ಯ ನೆತ್ತಿಯ ಮೇಲಿದ್ದಾನೆ, ಅವನ ಹತ್ರ ಛತ್ರಿಯೂ ಇಲ್ಲ, ಕನ್ನಡಕವೂ ಇಲ್ಲ, ಆದರೂ ಹೋಗಿ 10 ನಿಮಿಷದಲ್ಲಿಯೇ ಆತ ಗಮ್ಯ ಸ್ಥಳವನ್ನು ತಲುಪಿದ. ಪೇಜ್ ನಂಬರ್ 2, ಈ ಪೇಜ್ ನಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ, ಪೇಜ್ ನಂಬರ್ 2 ಸೈನ್ ಇದೆ. ರಾಮಣ್ಣನ ಗಮ್ಯ ಸ್ಥಾನವನ್ನು ತಲುಪುತ್ತಲೇ ಎದುರುಗಡೆಯಿಂದ ಮೃತನು ಬರುವುದನ್ನು ಕಂಡ. ಆ ಕಡು ಕಗ್ಗತ್ತಲಿನಲ್ಲಿಯೂ ರಾಮಣ್ಣ ಆತನನ್ನು ಗುರುತಿಸಲು ಸಾಧ್ಯವಾಯಿತು, ಏಕೆಂದರೆ ಆತ ರಾಮಣ್ಣನಿಗೆ ಪರಿಚಯವಿದ್ದ ವ್ಯಕ್ತಿಯೇ ಆಗಿದ್ದ. ಆ ಕತ್ತಲಲ್ಲೇ ರಾಮಣ್ಣ ತಡಕಾಡಿದಾಗ ಅವನ ಕೈಗೆ ಒಂದು ಕಲ್ಲು ಎಟಕಿದ್ದು, ಅದನ್ನೇ ಎತ್ತಿ ಬೀಸಿ ಆತನ ಕಡೆಗೆ, ಮೃತನ ಕಡೆಗೆ ಒಗೆದ. ಆ ಕಲ್ಲು ಆತನ ತಲೆಗೆ ತಾಗಿ ತಲೆ ಬುರುಡೆ ಒಡೆದು ಪಡಿಸಿಕೊಂಡ ಮೃತ ವ್ಯಕ್ತಿ ಸ್ಥಳದಲ್ಲಿಯೇ ಬಿದ್ದು ಅಸುನೀಗಿದ. ಇದು ಒಂದರಲ್ಲೇ ಬಂದಿದೆ ರಿಸೈಟಲ್ ಅಂತಾದ್ರೆ, ಅವಾಗ ಓದಿನಲ್ಲಿಯೇ ಗೊತ್ತಾಗ್ತದೆ. ಇಲ್ಲಿ ಹೇಳಿದ್ದೆ ಬೇರೆ, ಅಲ್ಲಿ ಹೇಳಿದ್ದೆ ಬೇರೆ, ಅದೆರಡನ್ನು ಒಟ್ಟಿಗೆ ಹೇಗೆ ಕೊರೆಲೇಟ್ ಮಾಡ್ತೀರಿ? ಫೈನ್, ಅವಾಗ ಕರೆಕ್ಟ್. ಎಕ್ಸಿಬಿಟ್ P1 ಓದಿದಾಗ ಪೇಜ್ ನಂಬರ್ 1ಗೂ ಪೇಜ್ ನಂಬರ್ 3ಗೂ ನಿಮಗೆ ಈ ರೀತಿಯ ಮೇಲ್ನೋಟಕ್ಕೆ ಓದಿನಿಂದಾಗಿ ಇದು ಒಂದಕ್ಕೊಂದು ಕಂಟಿನ್ಯೂಯಸ್ ಇಲ್ಲ, ಧಾರಾವಾಹಿಯಲ್ಲಿ ಲಿಂಕ್ ಇಲ್ಲ. ಇಲ್ಲಿ ಏನೋ ಒಂದು ಎಂಡ್ ಆಗಿದೆ, ಇಲ್ಲಿ ಬೇರೆದೇ ಏನೋ ಹೇಳಿದೆ. ಈ 3ನೇ ಪೇಜ್ಗೂ ಯಾವ್ದ್ರಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಇದೆ ಆ ಪೇಜ್ಗೂ ಮೊದಲನೇ ಪೇಜ್ಗೂ ಏನು ತಾಳಮೇಳ ಇಲ್ಲ ಅಂತ ಏನಾದ್ರೂ ಕಂಡು ಬರುತ್ತೆಯೇ ಹೇಳಿ. ಈಗ ನಿಮ್ಮ ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್ ಅದಿದೆ. ಯಾಕೆ ಅಂತ ಹೇಳಿದ್ರು, ಬರೀ ಸ್ಟ್ಯಾಪಲ್ ಮಾಡಿದ ಕೂಡಲೇ ಒಂದಾಗಲ್ಲ, ಅದು 2 ಪೇಪರ್ ಸ್ಟ್ಯಾಪಲ್ ಮಾಡಿದ ಕೂಡಲೇ ಒಂದಾಗಲ್ಲ ಅಂತ. ಅವ್ರು 2 ಬೇರೆ ಪೇಪರ್ನ ಇಟ್ಟು ಸ್ಟ್ಯಾಪಲ್ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದನ್ನ ನೀವು ಈ ಪ್ರಕಾರ ತೋರಿಸ್ಬೇಕಾಗ್ತದೆ. ಯಾಕೆ ಅಂದ್ರೆ ನೋಡಿ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ಓದಿ, ರಾಮಣ್ಣ ನಡೀತಾ ಇರ್ಬೇಕಾದ್ರೆ ಸೂರ್ಯ ನೆತ್ತಿ ಮೇಲೆ ಇದ್ದಾನೆ, ಗಮ್ಯ ಸ್ಥಳವನ್ನು 10 ನಿಮಿಷದಲ್ಲೇ ತಲುಪಿದ. ಅಂದ್ರೆ ಮಠ ಮಧ್ಯಾಹ್ನ 10 ನಿಮಿಷ ಅಂತ ಹೇಳಿದ್ರೆ 12 ಗಂಟೆ, 12 ಕಾಲ, 12:15 ಒಳಗಿರುತ್ತೆ. ಗಮ್ಯ ಸ್ಥಳವನ್ನು ತಲುಪುತ್ತಲೇ ಆ ಕಡುಗೊತ್ತಲಿನಲ್ಲಿಯೂ ಅವನು ಎದುರಾದ. ಇದೇನಾದ್ರೂ ಹೊಂದಾಣಿಕೆ ಇದೆಯಾ ಸ್ವಾಮಿ? ಇದು ನಂಬಿರ ಅದನ್ನ ನಂಬಂಗಿಲ್ಲ, ಅದನ್ನ ನಂಬಿರ ಇದನ್ನ ನಂಬಂಗಿಲ್ಲ. ಫೈನ್. ಇಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P1 ರಿಸೈಟಲ್ ಓದಿದಾಗ ಪೇಜ್ ನಂಬರ್ 1 and 2 ನಲ್ಲಿ ಇರೋದಕ್ಕೂ ಪೇಜ್ ನಂಬರ್ 3 ನಲ್ಲಿ ಇರೋದಕ್ಕೂ ಬಿಲ್ಕುಲ್ ಹೊಂದಾಣಿಕೆ ಆಗಲ್ಲ. ತೋರಿಸಿ. ಅವಾಗ ಪ್ರಿಪಾಂಡರೆನ್ಸ್ ಆಫ್ ಪ್ರಾಬಬಿಲಿಟೀಸ್ ಅಲ್ಲಿ ನೀವು ಯು ಹ್ಯಾವ್ ಕ್ರಿಯೇಟೆಡ್ ಎ ಡೌಟ್ ದಟ್ ಯುವರ್ ಡಿಫೆನ್ಸ್ that page number 1 and 2 should have been manipulated by the plaintiff is possible. Yesterday appreciation of evidence class ಮಾಡಬೇಕು ನಾನು.
All the essential conditions of the contract, they are relying upon. Is in page number 2 of the agreement. Fact that parties have agreed to the sale, parties have agreed to pay this as upon her, that she has agreed to receive the rest of the amount within 3 years at the time of execution of the. It's all in page 2 of the. The other portion. Signature, accepted signature. Top portion contains only the receipt. Burden would be on the plaintiff to show this, that these essentials of the contract, these are the significant essential items of the contract, were to the knowledge of the person that she has.
You are provoking me to say something. ನಾನು ಅದನ್ನೇನಾದ್ರು ಹೇಳಿಬಿಟ್ರೆ ಅವ್ರಿಗೆ ಅಮೃತ ಕುಡಿದಷ್ಟು ಸಂತೋಷ ಆಗ್ತದೆ, ಅವ್ರಿಗೊಂದು ಕ್ಲೂ ಸಿಗುತ್ತೆ.
Also, my lord, because
Huh.
the reason why she agrees to sell this property is because there is a marriage of the daughter, which occurs during the coming January. That is also one of the, what's the totality of circumstances to see. If the money is being sought for the marriage of the daughter, it is a pressing immediate requirement. And 2 lakh rupees today and the remaining of the 12 lakh rupees at a later date would never be at the intention of the parties, because the marriage occurs a short time after this loan has been taken.
Fine. You are relying upon certain circumstances to show what made you to borrow money. What made you to borrow money? What was the compelling circumstances for you to avail a loan? Then, fine. How you have attempted to convince the trial court about your defense that you were in their need of money for family necessity or marriage or whatever may be, therefore you borrowed. What made you to borrow money from 2 different persons of 2 different sums? 3, apart from your self-serving statement, have you examined any other witnesses who says, I know family of Bhagyamma. I am the one who negotiated for marriage, or I am the one who moved around in arrangement of marriage preparations, booking the chowdhury, printing the invitation, purchasing the goods, articles, jewels, etc., etc. I know her financial capacity. I was a well-wisher of Bhagyamma. I myself accompanied Bhagyamma to avail a loan. In that situation, the plaintiff Sheila asked her to sign a document. In my presence, Bhagyamma signed only 1 paper in favor of Sheila. And I have seen that. Because we were in need of money, we did not ask her to fill the paper. Or we could not read that. I am also illiterate, she is also illiterate. Or though I am literate, Sheila did not permit us to read. And since we were in need of money, we reposed faith on her and we both signed it and came. ಈ ರೀತಿಯಾಗಿ ಯಾವುದನ್ನು ದಾಖಲೆಗಳ ಆಧಾರದಿಂದ ನೀವು ಸಾಬೀತುಪಡಿಸಲಿಕ್ಕೆ ಸಾಧ್ಯವಿಲ್ಲವೋ, ಅಥವಾ ದಾಖಲೆಗಳ ಆಧಾರದಿಂದಾಗಿ ನೀವು ನಿಮ್ಮ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ತೆಳೆದಿರ್ತಕ್ಕಂತಹ ನಿಲುವನ್ನು ಬಲಗೊಳಿಸಲು, ಪುಷ್ಟಿಗೊಳಿಸಲು, ತನ್ಮೂಲಕ ವಾದಿಯ ನಿಲುವನ್ನು ಶಿಥಿಲಗೊಳಿಸಲು ಅಥವಾ ವಾದಿಯ ನಿಲುವಿನಲ್ಲಿ ಒಂದು ತೀವ್ರತರವಾದ ಅನುಮಾನಕ್ಕೆ ದಾರಿ ಮಾಡಿಕೊಡಲು ಸಾಧ್ಯವಿಲ್ಲವೋ, ಅವಾಗ ನೀವು ಅಂತಹ ಸಾಂದರ್ಭಿಕ ಸಾಕ್ಷ್ಯಗಳ ಕುರಿತಾಗಿ ಈಗೆಲ್ಲ ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೀರಿ? ಶಿ ಇಸ್ ಇಲ್ಲಿಟರೇಟ್, ಶಿ ಕೆನಾಟ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ವಾಟ್ ಶಿ ಇಸ್ ಸೈನಿಂಗ್, ಶಿ ಕೆನಾಟ್ ಆಸ್ಕ್ ವಾಟ್ ಶಿ ಇಸ್ ಸೈನಿಂಗ್, and she was in need of money. She did. She purchased 2 loans from 2 different persons, one from lady and another from his uncle of different quantities, etc., etc., etc. Should have been at least supported by oral evidence of any other person. Is it your case that you alone went to the house of Sheila and you knew Sheila alone, and Sheila also asked me not to bring any one person, therefore I myself alone went there. She gave me 25,000 rupees in my hand, asked me to sign, I signed and came, therefore there are no other person. That has never been your case. That has never been your case. For this transaction, even according to you have made use of the services of another person who is not connected with this transaction under exhibit P1 here. That is Shivashankar. Shivashankar. That means there is somebody else apart from the parties to the litigation, parties to the suit. In such an event, when you had every opportunity, Bhagyamma might have come and told you as an advocate before the trial court, look here, sir, this is what has happened on that day, etc., etc. I was constrained to do this. Then at least the advocate while drafting, because he knows the consequences, what is burden, what is onus, upon whom the burden is, how this defense can hold good. If merely what she is telling, if I say, then at least the advocate should have kept some openings in his pleading. Kept some opening in his pleading, like what I said. So depending upon their plaint, your pleading, you could have brought some witnesses at the later stage also. Looking at the strength of the evidence of PW1. PW1 ಇಷ್ಟು ಸ್ಟ್ರಾಂಗ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾಳೆ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲೂ ಜಾಸ್ತಿ ಎಲಿಸಿಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ಲಿಲ್ಲ, ಏನು ಯೋಚನೆ ಇಲ್ಲ ಬಿಡು. ಡಿಫೆಂಡೆಂಟ್ ನಾನು ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ತೇನೆ, ಆಮೇಲೆ ಲಿಸ್ಟ್ ಆಫ್ ವಿಟ್ನೆಸ್ ಹಾಕ್ತೇನೆ, ಮುಂಚೆನೆ ಹಾಕ್ಬೇಕಿತ್ತು, ಇಲ್ಲ ಸ್ವಾಮಿ ಹಾಕ್ತೇನೆ, ಕೋರ್ಟ್ ಅದನ್ನ 99.5% ರಿಜೆಕ್ಟ್ ಮಾಡಲ್ಲ, ಇನ್ನೊಬ್ಬರು ವಿಟ್ನೆಸ್ ನ ಕರ್ಕೊಂಡ್ ಬರ್ತೇನೆ, ಅವಾಗ ಅವ್ರು ಬಂದವ್ರು ಹೇಳ್ತಾರೆ ಇದಿಷ್ಟು. ಸರ್, advocacy is there. It is not that she contested the matter 14%. ಭಾಗ್ಯಮ್ಮ ಇಲ್ಲಿಟರೇಟ್ ಇರ್ಬೋದು, ಅವ್ರ ವಕೀಲರು LLB ಗ್ರಾಜುಯೇಟ್ ಅಲ್ವೇ, ಕೇಸ್ ನಡೆಸ್ತಿರೋದು ವಕೀಲರಲ್ವೇ, ಪ್ಲೀಡಿಂಗ್ ಡ್ರಾಫ್ಟ್ ಮಾಡಿರೋದು ವಕೀಲರಲ್ವೇ. ಯಾಕೆ ನೀವು ವಕೀಲರುಗಳು ಎಲ್ಲದಕ್ಕೂ ಬೇರೆದೇನು ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ, ಅಯ್ಯೋ ಸ್ವಾಮಿ ಅವರು ವಿಧವೆ, ಇವರು ವಿಡೋ, ಇವನು ಡೌಟ್ ರಾಡನ್ನು, ಇವ್ರು ಆ ರಿಲಿಜಿಯನ್, ಇವ್ರು ಪೂರು, ಇವ್ರು ಏಜಡು, ಇವ್ರು ಕ್ಯಾನ್ಸರ್ ಹೇಳ್ತಿರೋ ಹೊರತು ಅಂತದೇನು ವಕೀಲರಿಗಿಲ್ಲ. ವಕೀಲರು ಎ ಪ್ರೊಫೆಷನಲಿಸ್ಟ್ ಅಂತ ಹೇಳಿ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ. ನಾವು ಅಲ್ಲಿಂದ ಶುರು ಮಾಡ್ಬೇಕು. ನ್ಯಾಯಾಧೀಶರುಗಳು ನಾವು ಪ್ಲೀಡಿಂಗ್ ಇಂದ ಶುರು ಮಾಡ್ಬೇಕು. ಆಮೇಲೆ ಎವಿಡೆನ್ಸ್ ಬಂದಾಗ ಪ್ಲೀಡಿಂಗ್ ಇಂದ ಹಿಂದೆ ನಾವು ಹೋಗ್ಬೇಕು, ಪ್ಲೀಡಿಂಗ್ ಇಂದ ಇಟ್ಕೊಂಡು ಮುಂದೆ ಹೋಗ್ಬೇಕು, ನಾವು ನಿರ್ಧಾರ ಮಾಡ್ತೇವೆ. ಆದರೆ ಯಾವಾಗ ಪ್ಲೀಡಿಂಗ್ ಅನ್ನೋದ್ರಲ್ಲೇ ನೀವು ಶಿಥಿಲತೆ ಇಡ್ತಿರೋ, ವೀಕ್ನೆಸ್ ತೋರಿಸ್ತಿರೋ, ಅನಂತರದಲ್ಲಿ ಆಕೆ ಇಲ್ಲಿಟ್ರೇಟು, ಆಕೆ ಹೀಗೆ, ಅವಳಿಗೆ ಅಷ್ಟು ದುಡ್ಬೇಕಿತ್ತು, ಇನ್ನೊಂದೇನು, ಅದನ್ನೇ ನಾನು ನಿಮಗೆ ಪದೇ ಪದೇ ಹೇಳ್ತಿರೋದು. ದೇ ಆರ್ ಆಲ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಯು, ಬಟ್ ಹೌ ದಟ್ ಫೈಂಡ್ಸ್ ಎ ಪ್ಲೇಸ್ ಹಿಯರ್. ಎಲ್ಲರೂ ಕೇಳಿದ್ರೆ ಏನಿಲ್ಲ ಬಿಡು ಲಾದಲ್ಲಿ ಅಂತಾರೆ. ಎಷ್ಟಿದೆ ನೋಡಿ, ಒಂದು ಬರೀ ಒಂದು ಪ್ಲೀಡಿಂಗ್, ಡ್ರಾಫ್ಟಿಂಗ್ ಆಫ್ ಪ್ಲೀಡಿಂಗ್, ಇಟ್ಸ್ ಇಂಟರ್ಪ್ರಿಟೇಷನ್, ಪ್ರೂಫ್, ಎಷ್ಟು ಇದೆ. ಕೇಳ್ತಾ ಕೂತ್ರೆ 4 ದಿವಸ ಮಾತಾಡಬಹುದು. ಹಾಗಾಗಿಯೇ ಅನ್ಸೈನ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ನೀವೇನ್ ಹೇಳ್ತಾ ಇದ್ದೀರಿ, ಇಲ್ಲಿ ಅನ್ಸೈನ್ಡ್ ಅನ್ಲಿಕ್ಕೆ ಬರೋಲ್ಲ. ಬಿಕಾಸ್ ಇಟ್ ಈಸ್ ಸೈನ್ಡ್, admittedly it is your signature. ಇಲ್ಲಿಗೆ ನಿಲ್ಲಿಸಿರುವ, ಇನ್ನು 10 ನಿಮಿಷ ಮೇಲೆ ಸಮಯ ಇದೆ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕನ್ಕ್ಲೂಡ್ ಮಾಡ್ಲಿಕ್ಕೆ. ನಾಡಿದ್ದು ಹಾಕೊಳ್ತೇನೆ, 10 minutes you have got time. ಅನಂತರ ತಮ್ಮದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳ್ತೇನೆ ಸೇಮ್. ಯಾಕಂದ್ರೆ I have given you sufficient time in this matter. ಆಗ್ಲಿ, ತೊಂದರೆ ಇಲ್ಲ. ನೋಡಿ ಏನ್ ನೋಡ್ತೀರಿ. ನನಗೆ ಒಂದು ಆಯಾಮದ ಅನುಮಾನಗಳು ಮಾತ್ರ ಬಂತು. ತಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳ್ಬೇಕಾದ್ರೆ ನನಗೆ ಬರಬಹುದಾದ ಮತ್ತೊಂದು ಆಯಾಮದ ಪ್ರಶ್ನೆಗಳನ್ನು ಕೂಡ ನಾನು ಪ್ರಶ್ನಿಸಬಲ್ಲೆ, ಕೇಳಬಲ್ಲೆ. There are counsels from both sides present. For the argument of learned counsel for the appellant in part. For a further argument followed by respondent's argument and reply if any. List this matter. ಗೊತ್ತಾಗಬಹುದು ವಕೀಲರೇ. 20, 21, 22. ಆಗಬಹುದೇ 21, 22 ತಮಗೆ?
ಯಾವ ಆಂಗಲ್ ಅಲ್ಲಿ
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಫಸ್ಟ್ ಬೇಸಿಕಲಿ why should exhibit P1 to be accepted? Why the court cannot find some loopholes in exhibit P1? ಆಮೇಲೆ ಮತ್ತೆ ಮುಂದೆ ನೋಡುವ. ಮೇನ್ on 21/6 on the top of the list. ಎಷ್ಟಿದೆ? 3 ಮ್ಯಾಟರ್. Still number 82. Hello, Prasad K. Issue Mr. for K-Vita respondent. Counsel for respondent alone person. List the matter. Week after next, Mr. Counsel. It's a matter in the week after. Date ಕೊಡಬಲ್ಲೆ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಅಂದ್ರೆ ನೀವು ಮಂಗಳವಾರ ಬೇಡ ಬುಧವಾರ ಹಾಕಿ ಬುಧವಾರ ಬೇಡ ಗುರುವಾರ ಹಾಕಿ ಅಂತ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ರಿಜಿಸ್ಟ್ರಿ ಅವರು ಒಬ್ಲೈಸ್ ಮಾಡ್ತಾರೆ. ಆ ವೀಕ್ ನಲ್ಲಿ ಯಾವತ್ತಾದ್ರೂ ನಿಮ್ಮ ಅನುಕೂಲಕ್ಕೆ ಹಾಕ್ತಾರೆ. ನಾನು ಡೇಟ್ ಕೊಟ್ಟೆ ಅಂದ್ರೆ ನಿಮಗೆ ಏನೋ ಪ್ರಮಾದವಶಾತ್ ಆ ದಿವಸ ಅನಾನುಕೂಲ ಆಯ್ತು ಅಂದ್ರೆ ಅವ್ರು ಇದ್ದಾರೆ ಇಲ್ಲ ಸ್ವಾಮಿ ಡೇಟ್ಗೆ ಇವನು ಇವತ್ತೇ ಹಾಕೋದು ಅಂತಾರೆ. (27)6 as prayed. Serial number 86. K. Venkatamuni Shetty, Ramesh Ananthan for K-Vita respondent. 80? 86. 86. You are the appellant. Yes, you are for? Respondent. You are reporting the death. Whose death you are reporting? ಇಸ್ಕೊಳ್ರಿ ಅದೇನ್ ಕೊಟ್ಟಿದ್ದೀರಿ, ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಿ, ಅದರ್ ಸೈಡು ಅದ್ರ ಮೇಲೆ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದೀರಿ. ಮತ್ತದನ್ನ ಯಾಕ್ರಿ ಹೇಳ್ಬೇಕೇನ್ರಿ ಇಂತ ಸಿಲ್ಲಿ ಮ್ಯಾಟರ್ ಎಲ್ಲದು. 1.5 ಗಂಟೆ ಕೂತಿದ್ದೀರಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ವಕೀಲರುಗಳು ಘನತೆವೆತ್ತ ಗನಂದಾರಿ ಪ್ರಾಜ್ಞಾ ವಕೀಲರು. ಇಷ್ಟು ಬೇಸಿಕ್ ಸಿಂಪಲ್ ಕಾಮನ್ ಸೆನ್ಸ್ ಇಲ್ವೇ? ಹೇಳಿದ್ರೆ ಸಾಹೇಬ್ರು ಹೇಳ್ತಾರೆ ಅಂತ 1.5 ಗಂಟೆ ಕೂತಿದ್ದೀರಿ. ಅಲ್ಲಿಯೇ ನಾನು ನೋಡ್ತಾ ಇದ್ದೇನೆ. ಕೂತಾರೆ ಪಕ್ಕದಲ್ಲಿ ಒಂದು ಕೊಟ್ಟು ಸರ್ ಒಂದು ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಇನಿಷಿಯಲ್ ಹಾಕ್ರಿ ಅಂದ್ರೆ ಹಾಕ್ತಾರೆ. ಅದನ್ನು ಕೋರ್ಟ್ ಹೇಳ್ಬೇಕು ಮಾಡ್ಬೇಕು. ಏನ್ ತಿಳಿತೀರಿ ನಿಮ್ಮನ್ನ ನೀವು? ಹಿಂದೆ ಕಕ್ಷಿದಾರರು ಕೂತಿರ್ತಾರೆ. ಏನ್ರಿ ಅಪಾಲಜಿ ಮರ್ಯಾದೆ ತೆಗಿಬೇಡಿ. ಸಿಂಪಲ್ ಥಿಂಗ್ ರೀ. ನಮ್ಗೆ ಹೇಳಿದ್ರೆ ಸಂತೋಷ ಇರ್ತದೆಯೇ, ಬೇಜಾರಾಗ್ತದೆ. 40 ವರ್ಷದಿಂದ ನಾನು ನೋಡ್ತಿದ್ದೇನೆ ಕೋರ್ಟ್ ಹೇಗಿತ್ತು ಸ್ಟ್ಯಾಂಡರ್ಡ್ಗಳು. ಅವಾಗ ಜೂನಿಯರ್ಗಳು ಅಂದ್ರೆ ಹೇಗಿರ್ತಿದ್ರು, ಎಷ್ಟು ಚಟುವಟಿಕೆ ಇರ್ತಿದ್ರು, ಎಷ್ಟು ಅಕ್ಯುರೇಸಿ ಇರ್ತಿತ್ತು. ಈಗ ಆ ಪಾರ್ಟಿಯ ಕ್ಯಾಶುವಲ್ ಆಟಿಟ್ಯೂಡ್. Learned counsel from both side present. Learned counsel for respondent files a memo reporting the death of sole respondent on 5/6/2023. Learned counsel for the appellant. ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ ಈಗ? Appellant stating that he would do needful in bringing the legal representatives of deceased respondent on record, praise for a time by 10 days. The time as prayed is granted. Serial number 72, MD Raghunath, correspondent 72. Yes, please.
I served on both the items. My status report is ready for once.
First identify whom you are appearing for.
PVMD.
ಹೇಳ್ಬೇಕಂದ್ರೆ there are more respondent way. These are the basic thing. Yes, status report is ready. You are filing status report. You have furnished copy to other parties to the litigation. You have received copy. You have received copy. Equally. The learned counsels from both sides present. The learned counsel for respondent number 2. ವಕೀಲ್ರೆ, ಇಂಥದ್ದು ಸ್ಟಾಟಸ್ ರಿಪೋರ್ಟ್ ಜೊತೆಗೆ ಒಂದು ಮೆಮೊ ಹಾಕ್ಬೇಕು ಅನ್ನೋಷ್ಟು ಗೊತ್ತಿಲ್ವೇ ತಮಗೆ? ಮೆಮೊ ಹಾಕ್ಬೇಕು ಅನ್ನೋಷ್ಟು ಗೊತ್ತಿಲ್ವೇ? ಮನೆ ಬಂದಿರಾಗ ಎಷ್ಟು ಲೋಟ ನೀರು ಕೊಡಪ್ಪ ಅಂದ್ರೆ ಹೀಗಿಟ್ಟಾಗ ಆಗ್ತದೆ. ಅದೇ ಮನೆಗೆ ಬಂದಿರಾಗ ಎಷ್ಟಿಗೆ ನೀರು ಕೊಡಪ್ಪ ಅಂತ ಹೇಳಿದಾಗ ನೀವು ಹೀಗಿಟ್ರೆ ಹೇಗಿರ್ತದೆ? ಅಷ್ಟೇ ವ್ಯತ್ಯಾಸ. ನೀವು ಹಾಕೋ ಮೆಮೊ ಅನ್ನೋದಕ್ಕೂ ಇದಕ್ಕೆ. ಯಾರ ಆಫೀಸ್ ತಾವು? ಇಂಡಿಪೆಂಡೆಂಟ್ ಅಥವಾ ಯಾವ ಆಫೀಸ್ ಹೇಳಿ, ನಾನು ನಿಮ್ ಗುರುಗಳನ್ನ ನೆನಪು ಮಾಡ್ಕೊಳ್ತೀನಿ. ಯಾರು? ಗಚ್ಚಿನ್ ಮಾಡಿ. tell him, I have banged him. He was my student. So that I can take that liberty of banging him. University law college student ಆಗಿರ್ತೀನಿ ಅವರಿಗೂ ಗೊತ್ತಿದೆ. ಏನ್ ತಗೊಂಡ್ರಿ?
Correspondent number 2.
Files. Status report. The file say document showing it to be a status report. ಮೆಮೋದಲ್ಲಿ ನೀವು 2 ಸೆಂಟೆನ್ಸ್ ಹೇಳಬೇಕಲ್ವೇ? The undersigned council has got the honor to submit the status report submitted by the executive engineer of respondent number 2 corporation as per the direction given by this court dated so and so, and request to accept the same and take the status report on record. ಅದು ಪದ್ಧತಿ ಅಲ್ವೇ? ನಾವು ಮನೆಗೆ ಬಂದು ಅತಿಥಿಗೆ ಬಡಿಸ್ಲಿಕ್ಕೂ ಭಿಕ್ಷುಕನಿಗೆ ಅದನ್ನೇ ಬಡಿಸ್ಲಿಕ್ಕೂ ಇರ್ತಕ್ಕಂಥ ವ್ಯತ್ಯಾಸ ಏನು? ಅದು ಇದು. ಈಗ ನಾನು ಎಂತ ಬರೆಸ್ತಿದ್ದೇನೆ ಇಲ್ಲಿ? ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಎ ಡಾಕ್ಯುಮೆಂಟ್ ಶೋನ್ ಟು ಬಿ ಎ ಸ್ಟಾಟಸ್ ರಿಪೋರ್ಟ್ ಅಷ್ಟೇ. ನೀವು ಮೆಮೋ ಹಾಕಿದ್ರೆ ನಾನು ಇನ್ ಕಾಂಪ್ಲೇನ್ಸ್ ಆಫ್ ದ ಡೈರೆಕ್ಷನ್ ಗಿವನ್ ಬೈ ದಿಸ್ ಕೋರ್ಟ್ ಆನ್ ಸೋ ಅಂಡ್ ಸೋ ಡೇಟ್ ಅಂತ ಬರೆಸ್ತಿದ್ದೆ. ಅವಾಗ ಡೈರೆಕ್ಷನ್ ಕಂಪ್ಲೈಂಟ್ ಅನ್ನೋದು ಆಗಿ ಬಿಡೋದು, ಆನ್ ರೆಕಾರ್ಡ್ ಬರ್ತಿತ್ತು. 3,000 ರೂಪಾಯಿ ದಂಡ ಹಾಕಿದ್ದೀನಿ, BBMP ಕಟ್ಟಿದೆ. ಆದರೂ ಹೀಗೆ the learned counsels for the appellant and other respondents acknowledge the receipt of the copy of the status report. Next line. Settlement ಆಗ್ತಾ ಇದೆ, 1 ವಾರ ಅಂತ ಹೇಳಿದ್ರು, ಆಗ್ತಿದೆಯೇನ್ರಿ? ಮಾತಾಡ್ತಾ ಇದ್ದೀರಿ. ಸೊ ಈಗ ನಿಮಗೆ ಅದು ಡಿವಿಯೇಷನ್ ಪ್ರಾಪರ್ಟಿ ಹಾಗೆ ಉಳಿಸ್ಕೊಳ್ಬೇಕು, ಏನೋ ಮಾಡೋಣಪ್ಪ, ನೆರೆ ಹೊರೆ ಸ್ವಲ್ಪ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ನಿಮ್ ಸುಣ್ಣ ಬಣ್ಣ ಎಲ್ಲ ನಾನೇ ಮಾಡಿಸಿ ಕೊಡ್ತೀನಿ, ನಿಮ್ಗೆ ಸಂಪಿಲ್ಲ ಅಂದ್ರೆ ಸಂಪನ್ ಬೇಕಾದ್ರೆ ನಾನೇ ಮಾಡಿಸಿ ಕೊಡ್ತೀನಿ, ನಮ್ ಬೋರ್ವೆಲ್ ನೀರಿಂದ ನೀವು ಸ್ವಲ್ಪ ತಗೋರಿ, ನಿಮ್ ಕಾರ್ ಪಾರ್ಕಿಂಗ್ ನಮ್ ಕಾಂಪೌಂಡ್ ಎದುರು ಮಾಡ್ರಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಆಗ್ತಾ ಇದೆ ಪ್ರಯತ್ನ ಮಾಡಿ, ಅದು ಬಿಟ್ಟು ಇನ್ನೇನ್ ಮಾಡ್ತೀರಿ ಇದ್ರಲ್ಲಿ? ದಿ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ appellant and respondent number 1 jointly submit that both parties are proceeding for a settlement and substantial progress also has been made in the matter. As such, they require some more time. With this, they pray for 3 weeks' time to make their submission. As finally, the time as prayed is granted, either to report settlement in a manner known to law or to proceed further in the matter. ಅಲ್ವೇ? ಇದಕ್ಕೆ ಅಲ್ವೇ ನಿಮಗೆ 1 ನಿಮಿಷ ವೇಟ್ ಮಾಡ್ರಿ, ಊಟ ಕೂಡಲೇ ತಗೊಳ್ತೇವೆ ಅಂದ್ರೆ